pleasure to have you join us for these important symposia. A few years ago, one might have assumed that with increased awareness of wrongful convictions and exonerations and some changing attitudes towards criminal justice and human rights, might have assumed we were quietly on the path to abolition. It's no longer obvious that we're on that path. Our public language has turned away from a focus on fairness and humanity to dehumanization and retribution. So we'll see where we're headed. But irrespective of the language being used, the death penalty is an issue of profound moral, legal, and social significance. And so I am very grateful to the Law Review for sponsoring this program and bringing together some of the nation's leading experts and practicing lawyers on the subject of the death penalty. This promises to be a very enlightening, maybe at times disturbing, but nonetheless important program. And again, I'm very grateful to the Law Review for putting it on. Let me turn things over to the Law Review Symposium editors.
Good morning, everyone, and thank you so much, Dean Perdue. On behalf of the University of Richmond Law Review, I'm honored to welcome you to our 2025 Symposium, Advancing Abolition, Anti-Death Penalty Advocacy in Regressive Times. It's a bit of a mouthful. My name is Anna Bickley, and I have the privilege of serving as Symposium Editor for Volume 60 of the Law Review. I also had the great honor of planning today's event. Before we begin, I'd like to share a few words about the inspiration behind this year's symposium. Since we are in Richmond, the capital of the Commonwealth, let's start with Virginia's complicated history with the death penalty. The first execution in the United States was carried out in Jamestown. Since then, Virginia has executed over 1,300 people, more than any other state in American history. Yet, in 2021, 4 centuries of executions came to an end when the Virginia General Assembly abolished the death penalty, making Virginia the first Southern state to do so. That extraordinary achievement was made possible in no small part by the advocacy of some of our speakers today. So why hold a symposium on the death penalty in a state that has abolished it? Great question. I see 2 main reasons. First, while the death penalty has been abolished in Virginia, it is alive and well across the country. Like Dean Perdue said, federal policy signals renewed support for executions, and states continue to carry them out. Florida executed a man by lethal injection this Tuesday. It is a reminder that progress is fragile and the struggle for abolition is ongoing. Second, Virginia's transformation from leading the nation in executions to ending the practice altogether is remarkable. It offers a powerful case study for future abolition efforts in even the most zealous of states. So where better to hold the symposium than here in Virginia? Next, I want to turn briefly to the theme of the symposium, advancing abolition. I was first introduced to the idea of death penalty abolition through Bryan Stevenson's memoir, Just Mercy, as I'm sure many of you are. In it, Stevenson tells the story of Walter McMillan, a Black man wrongfully convicted of murder and sentenced to die. Despite overwhelming evidence of his innocence, including dozens of witnesses who placed him miles away from the scene of the crime, he was convicted by an all-white jury and sentenced to death row. Walter spent 6 years confined in a cell just a few feet from the electric chair before Stevenson and the Equal Justice Initiative proved his innocence. By then, his health had deteriorated, he had lost years with his family, and he carried the trauma of wrongful condemnation until his death. Yet, as Stevenson recounts, Walter forgave the people who unfairly accused him, the people who convicted him, and the people who judged him unworthy of mercy. Speaking at Walter's funeral, Stevenson reflected on the lessons that Walter had taught him. He wrote, "Walter's case taught me that fear and anger are a threat to justice. They can infect a community, a state, or a nation, and make us blind, irrational, and dangerous." Reflecting on Walter's extraordinary forgiveness, Stevenson wrote, "Mercy is just when it is rooted in hopefulness and freely given. Mercy is most empowering, liberating, and transformative when it is directed at the undeserving. The people who haven't earned it, who haven't even sought it, are the most meaningful recipients of our compassion." This lesson is at the heart of abolition and at the heart of today's symposium. The idea that mercy is not a scarce resource, that we have the capacity to extend it to all, even those who have caused significant harm, is transformative. It animates every presentation you will hear today, and I hope it is an idea you will engage with openly. My final invitation before I turn things over to our speakers is to think of today's theme of abolition in broad terms. Abolitionist thought, to use the words of Angela Davis, seeks to creatively explore new terrains of justice. In other words, it dares to imagine a world where punishment is no longer our touchstone and where mercy and hope take its place. So as you listen today, I invite you to not only reflect on the death penalty, but to imagine what justice rooted in mercy, hope, and community might look like. Thank you. Before I head away, I want to announce our first panel of the day. This panel will examine the historical developments of the death penalty, the implications of current policies, and the future of abolition. Our moderator is Richmond Law Professor Riley Keenan, and our esteemed panelists are Professor Carol and Jordan Steiker from Harvard and the University of Texas, who will be joining us virtually, Professor William Berry from the University of Mississippi, and Richmond Law's very own Professor Aaron Collins. Please join me in welcoming them.
Okay, so thank you so much, Anna, for that introduction and for the opportunity to be here today to moderate this amazing panel on advocacy in regressive times. I think what I want to do is maybe just jump right into with some questions that we have for our panelists. Anna has already given us our introduction. So I want to begin with Carol and Jordan Steiker. And what I'd like to do, oh no, did we lose them or are they still here? Wonderful, okay. So what I'd like to do is I'd like to first invite you to just briefly introduce yourselves if you're so inclined. And then the first question that I have, it's two questions, but they're related. To begin, could you give us an overview of the historical development of the death penalty in America and the current state of the Supreme Court's death penalty jurisprudence? And then second, more recently, the court has been less interested in policing the administration of capital punishment. How do you interpret this retreat, and what practical consequences does it have for lower courts, states, and practitioners?
Hi, I'm Carol Steiker. I'm going to start. Can you all hear me? Yes, I saw a head nod. Thank you. So I'm Carol Steiker, and the person next to me on the screen, that way, is my brother, Jordan Steiker. Yes, we have the same last name. No, we are not married. Most people assume that, but no, we're siblings and law professors and longtime collaborators. I'm a professor at Harvard Law School. I've been there for more than 30 years, and I teach and write in the broad area of criminal justice, but with a special focus on the law of capital punishment. So I'm delighted to be here today, and I want to extend my thanks to Anna Bickley and the staff of the Richmond Law Review for hosting this event. And I also want to say I'm sorry, but I'm going to have to leave after this panel because I have a memorial service for a beloved colleague later today. So I'm sorry to miss the rest of this terrific event, but I'm glad to be able to participate in this panel this morning. So I'm going to start with the first part of the question, and then Jordan is going to pick up with the second part of the question. The first part of the question, I'm going to talk for a little while. You can cut me off, but you asked about the historical development of the death penalty in the United States. You know, we've been around for a few hundred years, so I'm going to try to do a very, very bird's eye overview. But if you feel it's going on too long, just give me the hook and I'll stop talking.
That's fair.
The death penalty has been with us in the United States since the very first colonists came to the shore. As Anna just said, the first execution occurred in the Jamestown colony in Virginia, down there, in 1608. So that just gives you a sense of how long this has been going on. All of the original colonies, like all of the countries of the world at the time, had the death penalty. That doesn't mean that in colonial America that the death penalty was a monolith any more than it is today. The colonies used it quite differently for different purposes. Up here, I'm talking to you from Massachusetts. In the Massachusetts Bay Colony, the Puritans used the death penalty to sort of enforce biblical norms, things like sodomy or blasphemy, or as I used to like to tell my children, disrespecting your parents was a capital offense in the Massachusetts Bay Colony. Witchcraft, as you all know, from the Salem witch trials. Down there in the South, the death penalty was used to support the slave economy. And there were a lot of capital offenses for slaves that didn't exist for white people to, rule by terror, because there were so many slaves and not that many slave owners. There was a sense that the death penalty was a necessary punishment to, promote that kind of way of life. Going back to the early parts of, colonial America and then the early republic, and well into American history, for the vast majority of American history, the Supreme Court did not play any role in, or very minimal role, very, very minimal role in regulating the death penalty. I mean, today, I say that because today, if you think if you have an important question about the death penalty, what's required, what's permitted, what's forbidden, who you're going to call, you're going to ask the Supreme Court, and they're going to rule on that. This was not the case for most of American history. For most of American history, the death penalty was a creature of the political branches and mostly of state and local law. It doesn't mean it didn't change over time. It changed considerably over time, but those changes came from the bottom up, from legislative action, from influence by what was happening in other states, not at all from some big federal court in Washington, D.C. So across the 19th century, just going to hit them really briefly, there were big changes in the death penalty. Early on, the death penalty was used for all kinds of offenses. I told you, like blasphemy and sodomy and, robbery and burglary and horse stealing and all kinds of things. As the 19th century wore on, the death penalty really shrank in its ambit, especially in the northern states, really shrank down essentially to murder. And so that was a big change. And that had to do with the invention, one of the most important inventions of the 19th century, which was the penitentiary, the modern prison, got invented, and it became a substitute for the death penalty in a lot of ways. In addition, the death penalty used to be mandatory upon conviction of certain crimes. There was no discretion not to impose it. Over the course of the 19th century and into the 20th, the mandatory death penalty disappeared, and juries, the traditional capital sentencers in American law, were given discretion to grant mercy and not to impose the death sentence, even in capital prosecutions. Similarly, you can find old pictures, the death penalty used to be imposed publicly in public squares, usually locally. They built a scaffold. We inherited hanging as the primary mode of execution from England, and local communities would build scaffolds and crowds would come out, and the death penalty was a public community event. It was actually, they didn't have Netflix. It was a big part of the, entertainment of the crowds back in the day. As the 19th century wore on, the death penalty and the prison got invented, the death penalty was moved behind prison walls. It was thought it was a little too entertaining and coarsening of crowds. There was really a lot of inappropriate behavior that happened at these public executions, and the sort of growing gentility of the bourgeoisie that were offended by public executions. And finally, those things actually happened in Europe too. The shrinking of the death penalty, non-mandatory sentences, private executions rather than public executions, One thing that happened in the US that did not happen in Europe and our other peer countries was we began to experiment with other modes of execution. So England had hanging, and they kept hanging as their mode of execution until they abolished the death penalty in the 1960s. There's a great book about the abolition of the death penalty in England called Hanging in the Balance. Get it? It's the hanging in the, anyway. And the French had the guillotine, which they invented for the French Revolution in the 18th century. And they kept it till 1981 when they abolished the death penalty. But in the US, we experimented not just with hanging, but with the firing squad in the Mormon territory, with the electric chair, which was first invented in New York and spread widely throughout the states after World War I, with the gas chamber, which 12 states, especially California, one of the big executing states in the earlier parts of the 20th century, used lethal injection, which then overtook everything in the 1970s. And now today, like, we're, experimenting with even yet newer forms like nitrous gas as a way of executing people. So, partly it's like good old American technological know-how that we were, willing to experiment with these modes of execution. And believe it or not, each one of these successive modes of execution was generally embraced because it was supposedly less torturous and less destructive of the body. You might think that sounds weird about the electric chair or the gas chamber, but that is in fact what was argued at the time for why these were good inventions. Okay, so that's like big changes. So we're getting to the end of the 19th century. Or stick with me. Am I doing all right? Got five more minutes or so. So how did the U.S. Supreme Court get involved with it? What brought it in? And what brought it in was the racially discriminatory use of the death penalty in the South. That seems pretty obvious when you look at how the Supreme Court got involved. Now, from the very, very beginning, like honestly, from the colonial era, the South was the biggest user of the death penalty. You can trace it back that far. And in the pre-Civil War era, Southern states had separate capital codes for white people and Black people. And so just for example, for Virginia, in pre-Civil War Virginia, there were 4 capital offenses for white people. There were 66 capital offenses for slaves, and some of them were for free Black people as well. So that gives you a sense of the differential use of the death penalty in the South. But even after the Civil War, obviously the 15th Amendment, it's not 14th Amendment, whatever, it's no longer permissible to have explicitly separate codes based on race. So, but this is why the South was actually very embracing of discretionary sentencing, because that way they could keep broad eligibility, knowing that all white jurors would spare white defendants but sentence Black defendants to death. And that is in fact what happened for generations. What also happened was a huge era of lynching, sort of extrajudicial executions of Black people, almost exclusively men, accused of crimes against white people. And, there was a time, a period of several decades in which lynchings outnumbered legal executions in the South. And lynchings became a real problem for the South. Like, honestly, many Southern leaders felt that this was a black eye on the South. It showed the weakness of the government, the mob rule. They really wanted to quell lynchings as a way of showing that, the South was civilized and in control. And to do that, they embraced the death penalty so that they could assure the mob that, say, a Black man accused usually of the rape of a white woman or the murder of a white person would be executed. But to do that, to really assure the mob that this would happen, they developed something that, historians have called legal lynchings. They would, the person would be arrested, charged, tried, and hung by midnight. And the sheriff would stand on the steps of the Southern courthouse, assuring the crowd outside, don't worry, this person's going to hang. Now, you can imagine there was not a lot of what we might call due process involved in these legal lynchings. And the Supreme Court began to get involved in these cases and began to develop, this is long before incorporation. This is in the 20s and 30s. The Supreme Court began to, under the Due Process Clause, which is the only thing that applied to the states, regulate some of these extreme practices. And the most famous case, I'm going to talk about one case and talk about very briefly, in the 1930s, was the Scottsboro Boys case, which was a case of 9 Black, and I'm going to say boys, not in a derogatory way, they were boys. They were all teenagers, 9 Black teenagers who were, it turns out, falsely accused of raping 2 white women while riding the boxcars. I mean, later, just spoiler alert, all of them were pardoned, many of them posthumously, but they were tried. Nobody wanted to represent them. So the judge appointed the entire bar to represent them. You can imagine this did not yield much representation for them. They essentially had no counsel. The 9 trials took 2 days. They were all convicted and sentenced to death, except for the 12-year-old. He did not get sentenced to death. The others all did. And the Supreme Court took this case up. And this is the reason I say this in 1930s Alabama. This is the first case ever in which the Supreme Court said that the capital defendants had special rights. And they said in capital cases, the Due Process Clause assures you a right to counsel. The Supreme Court didn't go on, I can make this a quiz, guys, in the audience, until what case, what year, to say that you have a right to counsel in all serious criminal cases. That would be Gideon's Trumpet, Gideon versus Wainwright, 1963. This is Alabama in the early 1930s, right? This was a shot across the bow of the American death penalty, that sense that the Supreme Court was going to create rights in this realm to kind of push back on Southern justice in this area. Now, they didn't really do much more than that until the 1960s, because 2 things happened, 2 things needed to happen. One was the Bill of Rights needed to be incorporated, especially the 8th Amendment's Cruel and Unusual Punishments Clause, which is what the Supreme Court used as a vehicle later for regulating the death penalty. So that didn't happen until the 50s and 60s. And 2, there was a civil rights movement that really put racial justice front and center. And there was a racial justice NGO, the NAACP Legal Defense Fund. That's the group that brought you Brown versus Board of Education. In the 1960s, the LDF, as they were called, decided that the death penalty was their issue. And you might think, why would the nation's preeminent racial justice organization, who just, desegregated America's schools, or at least in theory did, won cases that said they should be desegregated, that took them decades. Why would they turn to the death penalty? Well, the story I've told you about the, extraordinary racial use of the death penalty is what led the LDF to do that. And that yielded what we call now the modern era of capital punishment, in which the main player of regulation in this sphere is the U.S. Supreme Court. It's no longer death penalties, the Wild West, if you will. It's just up to whatever state and local political leaders think it should be. There's a layer of top-down, constitutionally based regulation. And after a long campaign against the death penalty, spearheaded by the LDF, 1972, huge year for the death penalty, landmark case, Furman versus Georgia, the Supreme Court abolishes the American death penalty. 40 states had it. Supreme Court wipes it out. You should go look up the New York Times headline. The banner headline is exactly the same size as the one 3 years previously when we first had men walk on the moon. That's how big Furman versus Georgia was in 1972. And the Supreme Court said in Furman versus Georgia, basically giving juries complete discretion over who should live and who should die violated the Eighth Amendment prescription of cruel and unusual punishment, because the death penalty, as Potter Stewart said in the most famous line in the hundreds of pages of Furman versus Georgia, the death penalty was cruel and unusual, the way being struck by lightning was cruel and unusual. It was, in their words, random, wanton, and freakish, which is like code for racially discriminatory. But, William O. Douglas wrote a separate opinion saying it's racially discriminatory. So it wasn't even subtext, but struck by lightning, wanton, freakish is all about race and controlling the discretion of juries. But you might say, Professor Steicher, you say the Supreme Court abolished the death penalty, but don't we still have the death penalty? Yes, that would be a good observation. Furman versus Georgia did not last very long. 4 years later, the Supreme Court came back and undid its work. And because of 35 states in 4 years, 35 states and Congress, the federal government, enacted new statutes. They're like, hey, we can guide discretion. If discretion's the problem, we got an answer. We want to keep the death penalty. The Supreme Court granted review in 5 of those cases, all from southern states, and it upheld 3 of those statutes as that, and it's saying that they guided discretion enough or more than the ones that had come to them in Furman, and the death penalty was back in business. But here's a very important thing. The Supreme Court struck down 2 of those statutes, and the 2 they struck down were statutes that made the death penalty mandatory again. Those states, and they were, there were a dozen states, thought, all right, if the problem's discretion, the answer is no discretion, right? You do the crime, you get the death penalty. It's not a crazy thought, but the Supreme Court said, no, actually, that's a problem too, because not enough discretion, one, just hides the discretion, because you could always just acquit of capital crime, and juries were happy to do that when they didn't want someone to get the death penalty. And 2, that in very poetic language, the Supreme Court said it doesn't give play to the diverse frailties of humankind. It treats defendants as members of a faceless, undifferentiated mass, that you can have mandatory sentences in non-capital cases, but you cannot constitutionally, under the Eighth Amendment, have mandatory sentences in capital cases. So that created a right for defendants to be treated individually, to have mitigating evidence presented on their behalf, which is a crucial feature of today's death penalty practice. I'm just going to mention one more case, and then I'm going to stop talking. So 72, death penalty struck down. 76, death penalty brought back, but mandatory death sentences struck down. 77, the following year, the Supreme Court struck down the death penalty for the crime of raping an adult woman. Why? We think race was a subtext in that case, but it was a white man who had raped a white woman. The Supreme Court obviously did not want to talk about race. So what they said was the death penalty is just disproportionate, grossly disproportionate under the Eighth Amendment's cruel and unusual punishments clause, again, to the crime of rape, because the victim lives, so killing the defendant is just a disproportionate punishment. And that line of cases, just like the mitigation line of cases, has yielded a lot of law. The Supreme Court later applied that same reasoning to the death penalty for people with intellectual disability, to the death penalty for juvenile defendants, to the death penalty for the aggravated rape of a child. Or actually, in that case, in the child rape case, the Supreme Court said basically for any ordinary interpersonal crime other than murder. Like you can still have it for or the Supreme Court said, we're not saying anything about terrorism and espionage, treason, crimes against the state, but for ordinary interpersonal crimes, only murder. So that's huge. That's the basic structure of what we call the modern era. in which the Supreme Court basically, you have a question, they're going to tell you, like, what's the shape of a capital trial? What evidence must be or cannot be introduced? Who can get the death penalty and for what crimes? You're going to ask the Supreme Court because they are the source of this law, and this law applies everywhere in the United States, which is a very different story. So I'm now going to stop talking. That's my overview of the history, and I'm going to let Jordan take over the second half of the question.
Good morning. I'd like to join Carol in thanking Anna for inviting us to participate and for the law review and putting together this terrific symposium. The second half of that question focused on the significance of the Supreme Court's retreat in enforcing constitutional norms in capital cases. And I want to just say a few words about that retreat and then talk about the possible significance going forward and what it means for the potential abolition of the death penalty. As Carol indicated, the Supreme Court first really enters the fray about subjecting the American death penalty to constitutional review in the late 1950s, early 1960s, and the Supreme Court built on its precedent, which tied the Eighth Amendment, the prohibition against cruel and unusual punishment, to the evolving standards of decency. In other words, the Supreme Court said what violates the Eighth Amendment is not rooted in those practices that were rejected in 1791 when the Eighth Amendment was adopted, or in 1867 or 1868 when the 14th Amendment was adopted, but instead practices that were once acceptable might over time be rejected by the American people. And when that happens, all states would be prohibited from engaging in those practices. And that was those decisions, the first decision that ties the Eighth Amendment to evolving standards of decency was actually a non-capital case in 1958. And then the evolving standards of decency extends against the states in the early 1960s. And when the Supreme Court focused on whether the death penalty as a practice was constitutional, that's the focus, that's the test for whether a practice is permissible. And as Carol said, in 1976, the Supreme Court looked at the death penalty on the ground and concluded the American people had not turned their back against the American death penalty, but reiterated that that was the focus, that the question is not, what was tolerated at some earlier point in American history, but whether there was prevailing moral support for the practice. That doctrine has yielded some significant regulation of the death penalty, which Carol just described, the protection against execution for non-homicidal crimes against persons was rooted in the idea that the American people didn't support that, and that was reflected in statutes and sentencing practices and the court's own judgment of the purposes of punishment. What's happened recently is that the Supreme Court has questioned whether or not we should continue to interpret the Eighth Amendment by focusing on evolving standards. And there are now, I think, a working majority of the court that believes that the death penalty is constitutional, not because there's prevailing moral support for the practice within the American people, but simply because of the text of the Constitution, that the text of the Constitution contemplates the existence of the death penalty, the protection of due process, the most important protection probably in the Constitution, speaks of not depriving persons of life, liberty, or property without due process. And the working majority, I think, would say that the implication of the due process clause is that with adequate safeguards, states can deprive persons of life. And it's consistent with the court's larger commitment to textualism and to originalism as a way of interpreting the Constitution, that diverts attention from prevailing moral norms and instead focuses on a particular moment in time. And the court recently said very pointedly that the death penalty is constitutional, not because of prevailing attitudes, but because the court doesn't have any license to revisit the judgment that was made at the time that the Eighth Amendment was adopted, that the death penalty was an acceptable form of punishment. So one significant part of the retreat, the current retreat, is to move away from the methodological approach of focusing on evolving standards, which by its very definition allows for the possibility of enhanced constitutional regulation as attitudes and practices change. And just one, illustration of that, one of the decisions that is rooted in the evolving standards framework is the rejection of the death penalty for child rape, a decision that's about, almost 2 decades old. And just this last month, 20 attorney generals urged the rejection of that decision and urged the courts essentially to reverse the prohibition against executing persons for the non-homicidal crime of the rape of a child. And so there's definitely on the horizon the possibility that the Supreme Court will roll back its substantive protections under the Eighth Amendment, and that might facilitate some growth in the American death penalty. The other obvious way in which the Supreme Court is less protective in the current era is its manifest frustration with end-stage litigation in capital cases. And the Supreme Court has made it clear to lower courts that it is applying an extraordinarily high standard, an unprecedented standard for reviewing constitutional claims made during the warrant period, in the shadow of an execution. And that was most clearly illustrated during the end of President Trump's first term, when there were very substantial questions relating to the execution of a number of federal prisoners, questions that hadn't been answered and questions which looked actually as though they might be answered favorably, statutory and constitutional questions that might be answered favorably for those inmates. And yet the Supreme Court demonstrated, I think, what could only be described as impatience with lower courts granting stays and using its summary docket, what some people describe as the shadow docket. The Supreme Court reversed stays of execution without giving explanation, without full briefing, without oral argument, and allowed a number of executions to go forward in circumstances where everyone understood that if there was any delay at all, the folks who had been scheduled to be executed will likely not be executed because of the transition from President Trump to President Biden. And so on the one hand, you have a retreat from some of the substantive constitutional law protecting folks facing the death penalty. On the other hand, you have the court making it much easier to consummate death sentences with executions. And the question is, what is this going to portend for the future? And I think we're going to have an odd situation in which the death penalty looks substantially more robust than it actually is. In other words, I think we will have, as we've seen this year, a significant uptick in executions because the Supreme Court is simply not going to vigorously enforce, and it will discourage the vigorous enforcement of constitutional norms as cases approach execution. And this year we've had the highest number of executions in over a decade. We've had 34 executions to date, which is, more, almost a 50% rise from the number of executions we had just in the last few years. But at the same time, we still see that the death penalty is withering in so many respects on the ground. And the most important respect in which the death penalty is withering is just the extraordinary decline in death sentencing. There's still not much of an appetite at the local level for seeking the death penalty in the many cases in which it is statutorily available. I think as of the mid-year this year, we only had 10 death sentences by the end of June or the end of July, and we're on pace for having one of the lowest levels of death sentences nationwide. It's kind of shocking. We've almost never had executions actually outpace death sentences. And I think the public view of the American death penalty is, look, the death penalty is on the rise. We're having executions, which are much more highly public, salient events than anything else that's happening within the American death penalty. But I think the future is much more likely to be reflected in the leading indicator of death sentencing, because the decline in death sentencing means that, death rows are just going to shrink. Now, some of the death rows are still substantial. Florida, which is the state which is driving this enormous rise in executions, has the second largest death row. It has close to 300 folks on death row. So Florida has, a horizon of having many executions every year without exhausting a supply of inmates to produce those executions. But even Florida is still not producing death sentences anywhere close to what we were experiencing as a country in the 1980s and the 1990s, and even in the early 2000s. So that obviously leads to questions for people who are interested in abolition about what's the strategy. It's very difficult to prevail in the courts, especially in federal courts, as cases move closer to execution. But it still seems as though there's a lot of activity on the ground that will diminish the footprint of the American death penalty. I mean, the other major way, apart from death sentences, that I think reflects the decline in the American death penalty is just the sheer number of states that have rejected the death penalty. Carol mentioned that when Furman was decided, there were 40 states or so that authorized capital punishment. That number has declined. In the last 20 years, we've moved to 27 states that now authorize the death penalty. And of those 27 states, there are still quite a number who have either small death rows or no executions or both. Amnesty International considers states to be de facto abolitionists when they haven't conducted an execution for over 10 years. And by that measure, more than half the American states are now abolitionists. And I think there are a number of states, including what we would call red states like Kansas, that are contemplating abolition, in which there's, I think, a real prospect that those states will abolish the death penalty. And so I think from an abolitionist perspective, increasing the number of states that reject the death penalty and decreasing the number of death sentences, which is actually a hard thing to do now. I mean, we're at such low numbers. When I first came to Texas, we were looking at 38 or 40 death sentences a year. And in the last several years, we're hovering, around 3, 4, 5 death sentences in the whole state of Texas in a particular year. And I think that the writing is on the wall that there's just not the enthusiasm from a grassroots level for the death penalty reflected in juries and prosecutors that there is for what I think of more as political entrepreneurs. I mean, many people view the dramatic rise in executions in Florida, just, tying it directly to the ambitions of the governor, who obviously is interested in a national profile. And despite his earlier, lack of interest in the death penalty, has taken a great new interest in the death penalty. And I think, that might continue to drive a rise in executions, but I don't think it's enough to produce much political and energy on the ground to increase death sentencing. And without death sentencing, it's very hard to have a death penalty. But we're further away than we've been in 40 years from the possibility of Supreme Court abolition of the death penalty. In fact, we're at a moment where it's quite possible that the court will overturn the precedents that make it possible for judicial abolition, because if the constitutionality of the death penalty turns not on evolving standards of decency, but on the text and the original expectations and understandings of the framers, then constitutional abolition is a non-starter, and constitutional abolition is probably the only real route to full abolition in the United States, because state by state abolition, at least at this moment in time, is hard to envision.
So I just want to say thank you to both Professor Steikers for that wonderful and illuminating introduction to our death penalty jurisprudence here. I want to turn now to our next panelist, our very own Professor Erin Collins here at Richmond. Professor Collins, if you wouldn't mind also just briefly introducing yourself, although I imagine you're known to many folks in this room. And could you also, and the question that I have for you is, what are your reactions to the recent executive order that's calling for the increased use of the death penalty, particularly against those without legal immigration status? How does that fit into this broader trajectory that we're seeing with the death penalty?
Thank you so much. Can everyone hear me okay? Okay, great. I'm Erin Collins. I'm on the faculty here. I'm a former appellate public defender, and I have to say I feel like a bit of an imposter at this event because I write about punishment law generally, but we have one of the leading experts on the death penalty and lethal injection on our faculty, so that's not really where I focus, but I'm going to do my best to hang in here. My reactions to the executive order, I have a lot of them, only some of which are appropriate to share here. Overall, I'm going to describe the order, but I'd say overall, I find the order to be deeply troubling, dangerous, contrary to well-established constitutional principles, though, as Professor Steikers have highlighted, the constitutional principles are a little bit in flux, but also I find the order not all that surprising, given the tenor of the current presidential administration. So I'll come back to the possible unlawfulness if time permits, but first I want to describe the order and position it within the trajectory of the federal death penalty policy. So Executive Order 14164 is called Restoring the Death Penalty and Protecting Public Safety, and it was one of 26 orders that President Trump signed on Inauguration Day. It directs the Attorney General to seek the death penalty for any, quote, capital crime committed by an alien illegally present in this country, and specifies that the mandate applies, quote, regardless of other factors. In addition, it also mandates that the Attorney General seek to impose the death penalty anytime the victim of homicide is law enforcement. So in other words, the order requires federal prosecutors to set aside their duty to determine what punishment comports with justice in an individual case, and instead to seek the authority to kill anyone who is within the country without lawful status upon commission of a capital crime, even if they wouldn't make that recommendation for a differently situated person. Closer? Okay, thank you, Carl. And it encourages state attorneys general to adopt the same policy. A few months after this executive order was signed, Republican senators introduced the Justice for American Victims of Illegal Aliens Act to codify the order. The act would add a 17th aggravating factor to federal capital punishment statute for homicide offenses committed by anyone who, quote, came to, entered, or remains in the United States in violation of a federal law, but importantly applies only when the victim of the crime is a US citizen. The order and the act, in my opinion, are remarkable and not in a good way from both a capital punishment law and crimmigration law perspective. I'll focus here on capital punishment law, but happy to talk more about where I think it fits in kind of the crimmigration law landscape later in Q&A. So this is remarkable from a capital punishment law perspective because jurisdictions that retain the death penalty commonly use as aggravating factors consideration of whether a defendant has previously been convicted of serious criminal offenses, such as another murder or another felony involving violence. And the purported justification for this use of criminal history as an aggravating factor is that certain past convictions are said to indicate that the defendant is more likely to act dangerously in the future, and or that the commission of a capital offense after such convictions renders the instant conduct more culpable and therefore more deserving of this enhanced punishment. The fact of, it's sad that this needs to be said, but the fact of being a person without lawful status in this country satisfies neither of these conditions. At first blush, the executive order may seem to resound in this past as prologue justification, especially if one accepts the message incessantly circulated by the White House and ideologically aligned politicians and organizations that lack of lawful immigration status correlates with dangerousness and criminality. But this rationale doesn't withstand even the most superficial scrutiny. First, the order is distinct from criminal history aggravators in a very important way because it applies to anyone who is not a citizen and is here illegally, right? That means in violation of federal immigration law. The act, and that's civil law, the act of being present in the country without authorization, quite simply, is not a crime. While entering the United States without authorization may be prosecuted and punished under federal criminal law, remaining in the country after that entry only violates a civil law regime aimed at controlling international borders, not increasing public safety. Moreover, that someone convicted of a capital crime happens to be in the country in violation of civil immigration law simply does not render them more dangerous than one who is a citizen or who has permission to be in the country. In fact, multiple studies, many of them coming out of the Keynote Institute, show that immigrants, regardless of whether they are in the country with or without authorization, are less likely to commit crimes than American citizens. And this conclusion extends to violent crimes, including homicide. So arrest and conviction data reveal that the fact that one is in the country, quote unquote, illegally, right, in violation of civil immigration law, and I want to keep on stressing it's civil immigration law because I think that fact gets overlooked in popular discourse, renders them less likely to engage in criminal behavior that threatens public safety and otherwise. Moreover, multiple studies have concluded that an increase in immigration to a particular area either has no effect on violent or property crime rates, or it correlates with a reduction in these types of crimes. So in other words, increased immigration may make the country safer. So these statistics showing that non-citizens are less likely to commit crimes not only breaks the chain of logical inferences necessary to justify this order in the name of future dangerousness, but it also provides reason to believe the federal government may quite simply never have an opportunity to apply it because commission of a capital offense by non-citizens is statistically uncommon. Furthermore, the data reveal that the factor that renders one eligible for the death penalty under this order is not an action or characteristic that heightens the threat posed by their actions. It is their immigration status and their immigration status alone. In light of this revelation, I would hope that any court applying well-established legal doctrine would quickly find that the order violates Equal Protection Clause and the prohibition on cruel and unusual punishment and the promise of due process under the law. I won't go into the details of these possible legal challenges, but I'm happy to circle back to them later, but I do want to underscore two key points when we're talking about the possibility of legal challenges. First, it is clear and well established that people who are not citizens but are in the United States quote, have long been recognized as persons guaranteed due process of law by the 5th and 14th Amendments, even if they do not have authorization to be in the country. So as such, they are in fact protected by the 5th Amendment's promise of equal protection from invidious discrimination by state and federal governments. And I also just want to highlight a quote I came across from Justice Douglas's concurrence in Furman, where he concludes that the constitutional prohibition on cruel and unusual punishment contains an implicit promise of equal protection. He reasoned that the 8th Amendment requires, quote, legislatures to write penal laws that are even-handed, non-selective, and non-arbitrary, and to require judges to see to it that general laws are not applied sparsely, selectively, and spottily to unpopular groups. Reading the 8th Amendment and the Equal Protection Clause together, he concluded it is cruel and unusual to apply the death penalty or any other penalty selectively to minorities whose numbers are few, who are outcasts of society and who are unpopular, but whom society is willing to see suffer, though it would not countenance general application of the same penalty across the board.
Thank you, Professor Collins. Now I'd like to turn to our last but not least panelist of the day, Professor Berry from the University of Mississippi. If you wouldn't mind also just taking a brief moment to introduce yourself, and then the question that I want to pose to you, another sort of twofer but related. First, we've actually, as the Professor Stikers both mentioned, we've seen a sharp national decline in death sentences and also executions over the last 2 decades generally. What strategies, in your view, have been most effective in driving that change? Has it been litigation, public opinion, politics? And then second and relatedly, Virginia, where we are now, abolished the death penalty in 2021, and we were the first southern state to do so. Are there any lessons that might be drawn from Virginia's experience and applied elsewhere?
Fantastic. Thank you all for having me. Thank you, Richmond Law Review, for putting this on. I'm going to talk loud, but I think the microphones are kind of squeaking off each other up here. So thank you all for having me. I'm excited to be here, and I think this is a really important conversation to keep talking about the future of the death penalty and how we try to move towards abolition, especially in the year where it looks like we're further away from that than we've ever been. I wanted to start, though, by framing this. I guess the quick answer to your question is LWOP, and we'll get there in a second. But I want to frame the decline, because if you ask the average American how many people are getting executed this year, how many new death sentences, they throw out wild numbers. And so I just want everybody to get the landscape, and Professor Jordan Stiker talked about this a little bit, but we have consistently, roughly since last 25 or 30 years, roughly 20,000 homicides a year. We had a spike during COVID of the 22,000. This year they're estimating down to 15,000 homicides. So murder, by the way, in 2025 is like at an all-time low, which is interesting. So how many of these people are we, first of all, sentencing to death, and then how many are that we then ultimately executing, knowing that there's a 20-year lag on average between the sentence and the actual execution? So this was really at the height in the late 1990s. We had almost 100 people, 98 people executed in 1999, and then you see this gradual decrease over time. By the mid 2010s, we're down to about 50 a year. We were kind of averaging about 75, and then now we've been dropping down to 20 roughly a year until we've had the spike up to 34 so far this year. We may have a few more before the end of the year, thanks to Florida. But you see in the late 1990s and the early 2000s, all the states that have not adopted life without parole as an option, almost all of them do. And so the sentencing calculus in a homicide case really changes from what you have in the 1970s and 1980s, which is, do we sentence this person to death, or do we give them a life sentence, which means they could get out in 10, maybe 15 years? And so that's one calculus to, we know this person's never going to see the light of day again. We can give them life without parole. And so you see us going from 250 new death sentences around the turn of the century, dropping down to about 100 a year by 2010. And now we're in the 20s or 30s. So this year, for instance, we have this huge spike, as Jordan was talking about, in terms of the number of death sentences, the number of executions, but we have, outside of California, 10 new death sentences. California has 4. There are 14 so far this whole year. And so that's not many cases when you're talking about, 15,000 homicides. It's a very, very small, the whole quote from Furman, I think, is very true. This is as random and arbitrary as being struck by lightning. The actual individuals and the individual cases who are getting these sentences, it's very, very rare in most cases, even in the most conservative counties in the country, for a jury to choose to give someone the death penalty. And we'll talk about Florida and Alabama in a minute, but those states are having to cheat to even get there, 8 votes and 10 votes instead of 12. And so I think life without parole has been this driver of fewer death sentences. And it's a good thing on the one hand that it's fewer people we're executing, but it's also created its own separate epidemic with almost 60,000 people serving these kinds of sentences, and these cases don't get the same kind of scrutiny, perhaps, that capital cases. So I think that's sort of underside of all this. There are a couple other drivers, though, of the decline in the death penalty as well in America. I think one is cost. So many states do like my state, where the county will pay for the capital case. And so there's a county in northern Mississippi that 5 or 6 years ago decided to, have their jury sentence someone to death, and the county's essentially been bankrupted for 5 years because of the one case. And so that's taking the death penalty from, it could be in any county, to which county is going to put their money where their mouth is and pay for this. And so it's really making this geographic, the death penalty is really local, but it's driving it to a really, really local level, right? So what's the moral of the story? Don't kill people near big cities, I guess, but, that have money. But it's making this seem really arbitrary and random in so many ways on a local level. And it used to, people always think, oh, it costs more to put somebody in jail the rest of their life versus execute them. And it's not even close. It's way more expensive to execute people. And the numbers being thrown around were $3 or $4 million a case. And the most recent study from Florida says, we spend $51 million a year on the death penalty, including an average of $24 million a case. And so you have these conservative state legislatures across the country saying, hold on, we have LWOP, why are we doing this, right? And so you see Nebraska, and the citizens voted it back, but one of the drivers, Professor Berger can talk about this, and Nebraska's legislature's decision to abolish the death penalty was cost. So I think cost is a second piece of this puzzle, and to what extent is there an appetite to spend money on this going forward? And so I think that's a second thing. There are a couple other things, though, that have also, in different places, at least I think given juries pause or raised questions about this, which is Professor James Liebman and others from Columbia had a really important study at the turn of the century that showed that the error rate in capital cases was 2/3. So 2/3 of the death sentences are being reversed. So getting 1 out of 3 right, if you will, is great if you're playing baseball, right? But not so much if you're doing the death penalty, right? And not only that, but the amount of innocence that we've seen on death row, I think the current number is 201 people who've been innocent, who've gotten off of death row. And so we have an innocence clinic at our law school. Lots of law schools have these. But getting this really wrong so many times also, I think, gives people pause. Another obstacle, and this is Professor Lane's book and Professor Berger's work as well, but the lethal injection crisis and the fact that states can't get drugs has slowed down a lot of states. And some of the spike in the last couple of years are states like Indiana, Louisiana, South Carolina, Utah, that have now been able to get drugs or find a way or find a new method, if you will, maybe firing squad, to move forward with the death penalty. But for a long time, lethal injection was something that was at least slowing down the issuance of new death warrants in these cases. You mentioned public opinion. What is public opinion? It depends on how you ask the question. If you say, are you for the death penalty? Roughly 65-70% would say yes. And then you say, are you for the death penalty if life without parole is a choice? And we're below 50%. And so again, there's I think an increasing question about people can say what they want to say publicly, or you have the bravado of the White House, but when you get on a jury where you ask a prosecutor, do you want to bring this case or would you not bring this as a capital case? right? I think that there's a decreased appetite for this outside of really 3 states. I think Alabama, Florida, and Texas are really driving this. So part of my contribution to the law review is looking at, okay, what last 5 years, how many people have gotten sentenced to death? And it's right now we're exactly at 100. And 70% of those have been from those 3 states. And so you're seeing 3 states really monetizing this and driving this. So part of, I think, the abolition agenda is what's happening in Florida and Alabama and Texas. And interestingly, I would argue that all 3 states are cheating, right? That their death sentences are not legitimate. Florida, why? Because you have to have 8 votes instead of 12 votes on a jury. And a couple of theirs this year, Alabama just sent someone to death with 10 votes, not 12, right? And so to me, that's not fair. And then in Texas, if you look at what does it take? What do you have to show? There are no aggravating, mitigating factors. We're asking, is someone dangerous? Are they going to kill again? And to me, that's an irrelevant question as well. We're trying to punish what crime the person did as well. So what you're seeing, I think, with this death penalty is, in practice, people are having to push and cut corners and do things to actually get people sentenced in most cases. And then that brings me back to the Virginia point, or the Virginia story, which is who's getting the death penalty. And so O'Connor and Ginsburg both famously said, well, no one's getting the death penalty if they had a good lawyer. And so many of the handful of people that are getting this punishment are people who are not represented well. And I think the Virginia story, and there's an amazing law review in volume 56 of the Richmond that Doug Ramser and Karina Lane wrote, telling the story much better than I could tell it, and you can ask them when they get up here, right, about how Virginia got rid of the death penalty. But I think a big part of the story is we are defending every case at every turn, and we are providing massive resistance. And if you want to do this, you've got to overcome every motion we're going to file and every piece of opposition that we're going to do. And even if, as the psychers have suggested, even if, the courts are not going to grant all this, making them go through all the work, I think, is really helpful. Creating a record is really helpful because it gets really, really expensive. And the appetite for the states to want to do this in a handful of cases and counties, I think, will decrease over time. And you're seeing this, I think, on the ground. And so on the one hand, publicly, this looks really horrible, and we are having executions. We certainly have, 2,067 people on death row currently. And so I think states have a lot of people they can draw from if they want to start doing a bunch of executions next year. But the overall trajectory, I think, is declining, and so many of those people are getting old anyways. I mean, the leading cause of death on death row is natural causes. So yeah, I think, in the whole broader trajectory, I think it's still slowly dying. But I also think, to your question, I think, there have been lots of different things, but LWOP, I think, has been really the main driver to get us where we are. But certainly part of the hope is to oppose this. And we were on a good streak. Like, we had New Mexico 2009, Illinois 2011, Connecticut 2012, Maryland 2013, New Hampshire 2019, Colorado 2020, Virginia 2021. And which state is next? Maybe it's Kansas. I don't know. So to me, I think, this is a thing where, and to the law students, right, this is where you can have an impact, right? This is one case at a time in a local jurisdiction. And you can think of all this stuff as a big national thing, but it's one defendant and one case and one decision about how to respond to a homicide. So I threw a lot on the table, but I don't know if I answered your question or not.
No, thank you. That gives us a lot to chew on, for sure. Okay, so I have more questions, but I imagine that folks in the audience also have questions. So I think we might open it up now for Q&A from the audience. So the way we'll do this is, if you have a question, just raise your hand. We have members of our law review executive board who are going to be coming around with microphones. So I'll just call on you, and then someone will deliver you a microphone, and we can do it that way. Yes, in the front.
This is for everybody, everyone on the panel. So with the recent shooting of Charlie Kirk, there has seemed to be a very zealous embrace of pursuing the death penalty in that particular case at all levels of the federal and the state public officials. And I'm curious, do you have any thoughts? You're talking about this trajectory towards, a softer view and shaking the death penalty sort of at society in large, but do you think there's any risk that this high-profile killing and sort of the enthusiasm that's been expressed for pursuing the execution of this individual could make people all of a sudden more embracing of the death penalty in general again?
I'll jump in. So I think with any high-profile killing, right, whether you're talking about the Charlie Kirk thing or the murder in the South Carolina church, I do think these big cases, people want revenge or to me, that's really the only justification for the death penalty. Like, it's like the part of the movie where the villain gets impaled on, and then everybody in the theater claps, right? That's sort of to me, the only legitimate justification for this idea for revenge. And Marshall talks about this in his opinion in Furman quite a bit. This idea that revenge is not a justifiable reason to do this. But I think, all of this is just very local. So in a jury in a small town in Mississippi or a small town Mississippi prosecutor, what kind of pressure do you have to bring these kinds of cases? And I just think the national appetite is not there consistently. So everybody might rush and say, we love Charlie Kirk, let's execute the person that killed him in that case. But I don't know that, I just think this is such a localized phenomenon that it's not like some other thing where you're going to see some wave. It's not like we can all of a sudden just go point out all the people that we want to kill. Certainly that's the upshot of the immigration thing, is there are all these murders coming in, which, as you pointed out, is just not true. But I think, to me, that's part of the thought, but I just think it's too localized. And so on either side is problematic. It's like harder, without the Supreme Court stepping in, we can't just wipe this away and have abolition. But on the other side, I don't think you can just line people up and do this as long as we have due process of law in our country. So,
Could I jump in? Could I just jump in on that for a sec? Can you hear me? Okay, I was just going to underscore what Will said with just an example from Boston. So the Boston Marathon bombing happened in 2013. A huge drumbeat. This was Obama was president, but a huge drumbeat for the death penalty. The trial happened here in Boston, abolitionist Massachusetts, but a federal trial in 2015. Death penalty was returned. But 2015 was probably the year in recent history in which the nationwide abolition of the death penalty looked most likely in the court. Like Justice Scalia, right before he died, said, there are 5 votes on the court right now to abolish the death penalty. Time magazine had a cover, the death of the death penalty. That all happened in 2015. So I agree with Will. Like here, on the one hand, you had this like super high profile, public murder, drumbeat, trial, execution. At the same time, it did not seem to affect the trajectory of things in the United States. It was, the Obama's administration that was pushing that. So that I just wanted to underscore, I completely agree with Will. Even when there's a national, not localized, but national, drumbeat like there is for Charlie Kirk, I don't think it has that kind of power, at least looking at recent history.
I would just add to that I think that already the energy and enthusiasm for a death sentence in that case is dissipating somewhat, especially with the comments of Kirk's widow about forgiveness. And I think that the more and more people actually reflect on the crime and as well as the person accused of committing the crime, I think attitudes will be more nuanced, and it won't be, this drumbeat towards execution as sort of the uniform response across the board. I think it's actually going to be, I think the enthusiasm for a death sentence and an execution are going to be less substantial than they were in the immediate aftermath of Kirk's death.
Excellent. Next question right here in the front.
Thanks. I'll say to that as well, if we think of some of our most recent high-profile death penalty trials that have resulted in life sentences, I think nowadays when mitigation is done correctly, we almost always are seeing life sentences returned because we're finding defendants, like there's a reason that they've done this, and it's not because they're like completely sober, rational people that have just decided to go out in cold blood and kill someone. So, I think that's part of it too. But I thought to sort of maybe ask about a discussion in light of kind of these regressive times. Professor Barry sort of mentioned, some of these state legislatures are looking at the cost. There's a group called Conservatives Concerned about the Death Penalty that has chapters in several states that is sort of picking up on this idea of like, what are we doing? Conservatives, we want small government. We don't trust them with a whole lot of things. Why are we trusting them? They're botching these execution attempts. We're spending all this money. It brings in like the pro-life, type of thing. In Ohio, we have abolition bills pending. And one of the co-sponsors is like the most pro-life representative we have. Like she would like to outlaw birth control if she could, but she also, is very pro-life and has met an exoneree from Ohio's death row and, is very concerned about that as well. And so I just didn't know if any of the panelists had any comments about, a way forward, since I agree that, kind of like with abortion, the approach of like one single fell swoop at the Supreme Court doesn't exist anymore. And as Professor Barry was saying, it is more local. It's definitely like a state issue now, or even, like county level, and trying to convince, a local prosecutor whether to bring a case or not, if the path forward might involve, some unusual bedfellows that have a common interest in this regard.
I might jump in just to offer, and this is where I'll draw my perspective as not deep in the capital punishment world, but in punishment reform efforts generally, it's money and fiscal concerns that are bringing people together who are not otherwise ideologically aligned, right? There's a group called Right on Crime in Texas, which is pushing for a lot of reforms that I think people on the more left side of the political spectrum would agree with, because incarcerating people is costly. Pretrial detention is costly, right? A lot of these things that we do in the name of punishment cost a lot of money, and the monetary concerns can bring people together in interesting ways.
Question from Professor Lane? Or is there an answer on that?
So I'll just piggyback on both of those things that were just mentioned. On the Charlie Kirk, as some of you may know, I've been driving around the country, so I actually gave a talk the day after Charlie Kirk's murder, and I've been hearing about it all through. And I think, Jordan, your point on forgiveness and Charlie Kirk's widow coming out, and she said, I don't want that on my ledger. I don't want that on my ledger. I don't want his life on my ledger. And the thing is that the strongest support for the death penalty is the evangelicals. It's the religious right. And so, when she came out and said that, I think Trump would have liked to have attacked that, but he couldn't. And I've been talking, I was out in Salt Lake City 2 times this summer, and I'm not Mormon, but I will say these people are people of deep and abiding faith, and they do believe in redemption, and they do walk out what they believe. So in my mind, what I wonder about is whether Charlie Kirk's murder and what will happen after might actually backfire and be, I think it's going to be who knows, right? I actually think it could be very hard to get a death sentence in Utah. I mean, yes, it was, this high-profile murder, but it happened in Utah, and this kid, this young man, 22 years old, we know the science is, your brain isn't developed till you're 25. What, he gets an award for having straight A's. His neighbors are talking about how he helps them. I'm not seeing it. And then what do you do when that's another, sentence that does not end up in death, where the state will spend millions to go for it? And so that's, of course, I'm an optimist, but that's what I see. And then the other point about cost, I think one of the narratives that I'm seeing, and it goes to your point, Aaron, is I'm seeing victims' family members talking about cost, and it's something that I didn't realize as a researcher, but I ran into one in particular that I'm thinking of in Tennessee. Her son was murdered in her backyard, and she said that when my son was murdered, I couldn't get out of bed. I literally could not get out of bed. I was so overcome by grief. And she said, I was worried I'm going to lose my job. I'm going to lose my house. I need therapy. My kids need therapy. I need childcare. I have all of these needs because I am in crisis. And she said, I went to the Tennessee, Department of Health and Human Welfare, and they said, we don't have money for that. And so she said, right then and there, I decided, okay, she said, when I got it together, I decided I'm going to join the Tennessee Abolition group. And what she said is, we're spending millions upon millions of dollars. And this is her words, certainly not mine, but she said, it's selfish. It's being spent on very few victims. Often they are white, often they are high profile. But she said, the vast majority of us, that's not what we need. She said, the death penalty is really for richies. And I was like, oh, tell me more. And she was like, these are people who have all of their needs. And she's like, that's not the bread and butter death penalty. And so I was like, oh, this is teaching me something that I probably should have been aware of, but I'm not. And so I think even a victim-centered approach can think about money and where we should be spending it. And that, if that word gets out and is amplified, can be another move in abolition advocacy in regressive times. I guess that wasn't a question. Sorry, but
a wonderful
good job.
Other questions? Or contributions, right? Yeah.
Those to the panel. So to add on to that, yes, there's a gentleman in Ohio named Jonathan Mann. His father was murdered, and he's in conservatives concerned about the death penalty. He talks about how he was denied any sort of victims services because his father tested positive for drugs in his system after his death. So he couldn't get any services or anything like that. And he's like, that's what I need. I don't need this, someone on death row for 20 years. I needed, help with his funeral costs. I needed, that kind of thing. And then just recently in Alabama, if anybody noticed in the news, so a man was executed for killing a woman whose son was, I think he was 12 or 15 at the time. And this man asked the governor, to spare him from execution because he said, this is not what my mother would want. That doesn't help me at all. But short of that, can I at least meet this man? I would like to express my forgiveness. That would help me heal. And that was denied because, it's the policy of the state to not let, a victim's family member, meet the defendant. And he said, you know, when I was 12 or 15, I had a DA in my face screaming at me about how I needed, you know, to support the death penalty, but I never got any other support that I needed, you know, certainly not as a child growing up, and certainly not as an adult. And I think the way that the death penalty disserves surviving, you know, family members and friends of victims is a huge component of its failure. And we see this time and again where, you know, politicians and prosecutors love to say that they are seeking justice for the victims and their family until the victim's family doesn't support them. And then they are tossed to the curb. And even when they do support it, I was at a clemency hearing a number of years ago, and one of the widows of someone who had died responded to the fact that the defendant's team was saying that he was remorseful. And she got up and said, if he was really remorseful, our phone number has been in the phone book all this time, and our phone never rang for him to call and apologize. And the parole board chair had to say, well, ma'am, there are reasons why we don't let our inmates call the victim's family, you know, right? But no one in all this time had ever explained that to her. Like, where are these victim advocates from the prosecutor's office explaining that to her? You know, like, she's just totally, and it was so, I mean, her emotions were so raw after all this time. And it's clear to me in this work that, you know, it doesn't provide the closure that it's promised. Instead, you know, every time there's another hearing, another court date, you know, it's reopening these wounds to victims. And so many victims have said, you know, this is not what they want. The restorative justice paradigm, you know, provides what they actually need. There's something called defense-initiated victim outreach that, you know, we could have a whole panel on that, but it's all based on this restorative justice paradigm, which is meet the victim's needs. You know, sometimes they just want someone to explain what's going on, you know, they have some questions they want answered, and that's what gives them, you know, a sense of justice and closure and healing, and not an execution. And so I just say I agree that that's another aspect of, you know, the death penalty not serving, you know, what it's supposed to do. And I think that's another avenue that is going to continue to, you know, be talked about as, you know, a reason why it's really not doing its work.
Other questions or comments for our panelists here today? We have one in the back.
I know Professor Berry got into this a little bit with life without parole, but my question is, if the death penalty were abolished today, where do we look next in the criminal justice system for reform, especially areas where we see the same racial inequities, the same problems arising?
I have a lot of thoughts, but go ahead. Great question, Anna. I resist the chronological sequencing that we have to do this, then that, right? I think movements for reform are the most powerful when there's meaningful coalition building. And I think this executive order underscores the need for coalition building in this particular area on a number of different fronts simultaneously. I think resisting this particular order and the death penalty in general requires a commitment not only to ending the death in the name of punishment, but also to working against the ways actively that the government makes living in the country dangerous or death-inducing for people who aren't citizens and for people who are living at the intersections of lots of systems of inequities. So I was just reading that to date this year, this calendar year, 38 people have died in Los Angeles County jails alone. California has a moratorium on the death penalty, but since it was revived until present, I think about 13 people have been executed by California, right? And that's after all of the processes, the expensive processes that we've been talking about, right? But 38 people died in in jail custody this year, right? I think there's connections and coalition building between the movement to end the death penalty and the movement for prison abolition more generally. I think also on the front of immigration, 16 people have died in immigration custody to date, 16 that we know of, right? And so I think that there's also opportunities to build power in movements to end the death penalty and to end the way that ICE conducts their business, right? ICE has not always existed. It was created in 2001, right? We have dealt with immigration policies differently in the past, and we can deal with it differently in the future, right? So I think it's an opportunity to come together and think about not just what's next, but what's now, and where are the connections between all of these related issues.
Yeah, I mean, I think it's a both and, not an either or kind of thing. And certainly, you could argue, well, what the problem with all this death penalty stuff is sucking out all the oxygen, but it's also drawing the line, I think, of, okay, you're willing to go that far, right? And so, but to me, I think LWOP, it was interesting, I clerked on the Sixth Circuit, you had a capital case, and the court would be split in half in terms of how they would do that, in terms of representation of the court, but you had an LWOP case, and everybody's like, oh, well, that's fine. I mean, and so I think there's that problem. I think, but on the lower level sentencing, I think mandatory sentences are a problem. The First Step Act in 2018, which was the only bipartisan thing I can remember from the first Trump presidency, right, was a good first step. But what's the second step? You have a lot of draconian federal laws, but you also have, I mean, I was in the grand jury, twice out of 3 years in Oxford, Mississippi, and what I saw was a lot of misdemeanors dressed up as felonies. And so I think even on a local level, looking at our interventions, restorative justice, providing mental health courts, providing drug courts, I think there are just lots of different options to deal with all of the many, many problems we have in our largely broken criminal justice system. But I do think things are getting traction. I mean, I think we've had this whole thought that juveniles are less culpable, and we've had, the Supreme Court cases, but we're starting to understand the brain science, and people, until they're in their late 20s are different. And you're seeing that, I think, bearing out even in the death penalty case. One of the interesting things that I found, I did mention earlier, looking at the last, 10 years of, and really the last 5 years of who's getting the death penalty, the average age is late 30s, early 40s. The average age of the 14 this year is 42. And so we're looking at people who are older saying, okay, that's really bad. You should know better. You're in your late 30s, early 40s. But on the younger side, query to what extent are prosecutors or juries being more understanding that, people are impulsive, their brains aren't developed, et cetera. And so I think, part of this is as we understand or learn more about people who are committing crimes and why they're committing them. But the other piece, I think, to reform, and then I'll stop here, is just the narratives are so wrong in the public sphere, right? Like, people are shocked that crime is down, but we're down, 15,000 homicides this year when we've been averaging 20? That's a huge decrease. But we watch the Memphis news, and it's like, if you watch the Memphis news, why would you ever go to Memphis, right? It's like, this is a war zone, right? But it's a narrative, and people want this narrative because maybe they feel alive when they're afraid. I don't know. But I think that the stories that we're telling about what's happening, and it's why you have so many people watching true crime, because I really am seeing what's happening here. But telling the stories of what's really happening versus what's not, I think is a big piece of reform. If people are operating off a playbook that's inaccurate, they're not going to have smart opinions about how to move forward. And so I think that's the other piece of this. But again, I would say this is just a both and thing. There's lots of space for reform and to raise issues for sure.
Can I just jump in and add, I thought those comments by Aaron and Will were really great, and I just wanted to underscore one thing that each of them said. For Aaron, I love the idea of coalition building and connecting death by execution to deaths in other spheres, and I just wanted to add a very powerful number would be the number of people killed by police violence in the United States. It's like part of our criminal justice system. It's not a sentence of punishment, but it's a leading cause of death within our system, and also very much plagued by the racial disparities that, probably even more so in the police violence context. So that's just one thing to add to your excellent point. And Will, I just wanted to say on your LWOP and, juvenile brain stuff, like a nice bulletin from here in Massachusetts that our Supreme Judicial Court of Massachusetts has raised the age for juvenile LWOP, which is, there's a lot of raise the age legislation about all kinds of punishments from the death penalty to LWOP, but it also shows that, when I travel abroad to talk about the death penalty, people want to talk about the death penalty in the US or the American death penalty. But it's important to underscore we are so disaggregated and so federalized that there are different opportunities in different places. So even as, Florida is ramping up its death penalty machine, Massachusetts is raising the age for LWOP. Obviously, we don't have the death penalty. So to keep that in our minds as a sort of pushback about thinking so globally.
We have time for one more question. I will ask it unless someone else has a question they would like to ask. Gil.
I am curious with what you're discussing about the unlikelihood of anything changing at the Supreme Court level, at the federal level. If we're talking about advocacy as a whole, we see maybe more grassroots things changing, but like you said, not a lot of change at that level. So I guess I'm curious, is there a point in advocating at the federal level, try to push for legal change there, or should efforts be focused other places? Should we be doing both? Like, where do you think the best advocacy is in today's world?
I'll jump in. I think it's really localized, right? And I think the way, how are we getting rid of the death penalty? It's opposing it on a case-by-case almost basis, or it's getting a group of people in the legislature that want to say this doesn't make sense for us anymore. I mean, it would be nice if we could have Furman again, but the response to Furman was, let's write our new death penalty statute. So, I think that there's a weird sort of cultural piece to this, which is there are a lot of people that like the idea of this, but they don't really want to be a part of it or watch it or see it, right? I mean, you can watch almost anything in the world on the internet except for executions, and Professor Lane will talk about this later, but the way we're doing executions is to hide it all, right? And so I think there's a real sort of, I want this to have this symbolically, but do I really, and so I think putting up resistance locally, I think, to me, is the best way in the world that we're in. I mean, again, it'd be nice if the Supreme Court would say the Eighth Amendment says this is a cruel and unusual punishment, but as Professor Jordan Syker said earlier, I don't see that happening for a long time. Until we have a new court, really. But
I'll just repeat what my esteemed co-panelist said, which is, I think, to think of change and resistance as both and, not either or, right? I think resist on all fronts that are available, and that might be that might lead to success, knowing that some might be more fruitful than others.
Okay, with that, we are just about at time. So if everyone would join me in thanking our panelists for today.
Good morning, everyone. My name is Jeffrey Kidwell. I'm the publications editor for Law Review. Thank you one more time to our wonderful panelists and for our wonderful moderator, Professor Keenan. Thanks again. With that, we're going to take a brief intermission, so we'll meet back here at 11 a.m. Thank you so much.
And it's such an honor to have you all here today. It's been amazing to hear these speakers already, and we're just very glad how well you make it. Our panelists are often very modest, but when I tell you we have the best of the best
Here today, I mean it. These are leading scholars, leading practitioners. They're amazing people, and we're just honored to have them, both the last panel and the panels the rest of the day. And so I have the honor of introducing our next panel, which is on methods of execution, a really fascinating topic. And Richmond's Professor Hank Chambers will be moderating this panel today. We also have Professor Alex Klein from Washington and Lee down at the end.
Professor Eric Berger from University of Nebraska Law, and our very own Professor Corinna Lane from here at Richmond. So without further ado, please give them a warm welcome.
Thanks, Caleb. Hello, folks. As Caleb noted, this is our panel on execution methods. Obviously, as the name tag says, I'm Hank Chambers, professor here at U of R. We have three powerhouse panelists. I'm just going to say one sentence about each of them, and they are more than welcome to add any additional stuff that they want to mention. We'll just go alphabetically. Obviously, Professor Berger teaches at University of Nebraska School of Law, and his areas of expertise are broad. They include administrative law, capital punishment, the death penalty, and constitutional law. Professor Alexandra Klein. Alex is a professor of law at Washington Lee University School of Law. She teaches and writes in the fields of capital punishment, criminal law, criminal procedure, and her research focuses on the Eighth Amendment arbitrariness and cruelty in punishment. And right next to me, my colleague Corinna Lane. Just want to note her book, Secrets of the Killing State, The Untold Story of Lethal Injection, was released earlier this year and is available at many booksellers all across the country. So that being said, as with the first panel, we'll do about an hour of moderated discussion, and then we'll throw it open to questions, answers, discussion, etc., right around noon. So let's do this. Let's sort of set the scene and ask this question for anybody. How have execution methods in the U.S. evolved over the last century, and what are some of the legal, technological, political forces that have driven the moves we've seen today?
I got looked at, so okay. I thought I was done with being cold called. Just kidding. So really, we've had this shift, right, from hanging to the electric chair. Cyanide gas came up at one point and was running sort of parallel with the electric chair and some hanging. And then the development of lethal injection, the firing squad plays a role here and there. But I think that this shift has been driven a lot by the development of technology, right? There have been these changes. Oh, we're going to stop hanging people. We want something that's more humane. It's difficult. I don't think that it is, but some of it was driven by the desire to create something that looked better, looked less violent, was more humane, had sort of more technology built into it. It looked a bit more peaceful. And I think that in terms of political forces, right, this sort of intent to be more humane, or look more humane anyway, has mattered a lot more to courts than the actual results or effects. And legislatures tend to get a lot more credit than they deserve. Courts often credit them with a lot of decision-making and thought, but really they haven't necessarily unpacked things, and they're often operating on some kind of concerning assumptions. So like one example, when Oklahoma adopted nitrogen, they relied primarily on a report written by 3 people who are not doctors or chemists. Over the course of, they said, the people who wrote the report, said they did it in about 3 hours one night. And then I believe they also watched videos of teenagers on YouTube, like huffing helium and doing whippets. So very thoroughly researched. So that's part of the issue. And then I think some of the shifts in method decisions, right? Sort of states' decisions to add methods, to add backup methods, to give options, has been in part to attempt to avoid lethal injection drug shortages, which Professor Lane, I'm sure, can talk much more about, as well as to try and evade and limit litigation over methods of execution. So it's less, I think, a process of, are we doing this better? Which I will say the adoption of the electric chair seemed to be intended in that direction, even if they didn't quite understand what was going to happen. And in fact, there's some very interesting stuff in the New York court's opinions addressing the constitutionality of the electric chair, where they say, well, we don't know how this works, but we also don't know how gravity works, and we rely on that, so we can rely on this. But lately, I think the real shift is, can we keep doing this? Can we keep getting our drugs? And can we continue to evade oversight?
So that's a great, we're going to hit you in just a second. This is a great entry point in doing an overall notion. So let me do this. For both Professor Lane and Professor Berger, do y'all have some overall thoughts about these issues? Because there are a number of issues that Professor Klein got into that we're going to unpack a little bit more. So what do you think about and just sort of opening up and setting the scene?
I loved can you all hear me? I loved what you talked about when you said evading oversight, because I was thinking about, what am I going to talk about today? Because we could just stay here all day, but we can't. Not up here. But I was thinking about oversight and thinking about, the examples that I saw from studying lethal injection. I'm like studying this method. And what I really found, I found so many things, but one of the things I really found was the ways that states evade review. And so there's this narrative about executed or they got off on a technicality. And I'm like, actually, the truth is the exact opposite. So I'm going to start because Dale Bache is somewhere in this room, probably. Where are you, Dale? Yep, he's in the very back corner where the cool kids are. He reaches out to me. He's has done capital litigation work in Arizona. And, in Arizona spent $1.5 million on drugs for 3 executions and botched all 3. And then they said, well, gosh, that wasn't good. So let's have an independent investigator look at this. They appoint a retired federal magistrate judge, and he's investigating. And in November, right after the election, he gets dismissed by the governor. She signs a letter saying, we're going to go a different direction. And the different direction was, instead of having an independent investigator, the Department of Corrections investigated itself, said, we're great. Now give us our warrant, our death warrant, and we're going to start with a volunteer. We're going to start with a volunteer. So there is no person on the other side to challenge them at all. And I've got like 4 or 5 different ones. I think I'll stop there, but that's the sort of thing that I saw over and over again. I'll just throw out one more that went to the first panel, like the Trump executions in 2020. So the federal government is using this pentobarbital one-drug protocol, and the prisoners put forth all of this scientific evidence showing we're waterboarding people to death. And they put forth the autopsies that showed it, everything. The district court over 2 weeks looks at thousands of documents, hears testimony from the top experts in the country, and finds that the plaintiffs, the prisoners, have shown a likelihood of success. Even under the crap law that we've been talking about, they still showed a likelihood of success. The Supreme Court reaches down, and so she issues the stay so that they can get to trial. The Supreme Court reaches down on the shadow docket, lifts the stay, and then the federal government just executed the plaintiffs one by one. So much for the trial. There's no trial because they're all dead. That's the sort of thing that I, see.
Thank you. So first of all, thank you very much to the Law Review, to Anna and Caleb and the wonderful Law Review editors for hosting this. It's a pleasure to be here. Just to sort of pick up on a few things Professor Lane said, I think one of the threads that runs through a lot of these method of execution cases is the extraordinary deference that courts, especially the U.S. Supreme Court, give the agencies that are carrying out executions, usually State Department of Corrections, but as Professor Lane just said, it also extends to the federal agency. The Barr v. Lee case, which was the one Professor Lane just summarized involving the Trump executions, would be a great example of that. And I think if you look at how the agencies that are designing and implementing execution protocols actually do their work, you realize that deference is totally bonkers. And that's the legal term, I think. If you want a sort of thorough explanation of why, read Professor Lane's fabulous book, which sort of gives you, it's like 400 pages of bonkers. And she's not the bonkers, but the stuff she's describing in the book is. But just to sort of touch on that briefly, if you look at how the Supreme Court is thinking about administrative agencies generally, especially on the federal level, this Supreme Court is very skeptical of agency action generally. And then if you contrast that to how they look at agencies designing and carrying out execution protocols, not just at the state level, but the federal level too, it is like uber deferential. And if you sort of dig into that, you might ask, well, what are the measures by which we should decide whether an agency deserves deference or not? And, obviously you could spend weeks talking about this, but two things that courts typically would look at would be epistemic authority and political authority. So epistemic authority, does the agency have expertise? Do they look at the facts before them? Do they look at the evidence? Are they thorough in their reasoning? And if you look at how these agencies are designing execution protocols, they have no expertise. Again, Professor Lane's book details it over and over again, but these are often state officials who have no idea what they're doing, who get one drug confused with another drug because it has a similar name, who select a drug that as an anesthetic that does not have anesthetic properties at all, who appoint a doctor to oversee the protocol, who admits I don't know how many drugs I'm mixing, I'm just, throwing it all together, even though the amounts of the drugs are pretty crucial to try to make sure you don't have excruciating pain. So they're utterly lacking in expertise. And if you think of political authority, well, yes, they have some political authority to the extent the states or the federal government has delegated them authority to do so, and that's a topic Professor Klein has written on. But political authority also comes from things like transparency, but these execution protocols are being designed and implemented in total secrecy. The title of Professor Lane's book is Secrets of the Killing State. This is all being done in secret. There's almost no oversight. Elected officials want to wash their hands of this. They just want to push this difficult task down the bureaucratic chain and have nothing to do with it. So it doesn't really have high measures of political authority either. So I guess the question I would ask is, why do courts repeatedly defer to these agencies botching these executions over and over again when it's very clear the agencies don't deserve deference? They don't have expertise, they're operating in secret, there's no oversight of what they're doing, and then on top of that, it's with a culture where in other contexts, courts aren't deferring to agencies at all. So
those are great points. We're going to roll back into that when we talk about the Eighth Amendment after the next question. We are contractually obligated to mention the Eighth Amendment a few times in order to get CLE credit. So I mentioned it once, I will mention it again, and we will go from there. But in the broader sense, I'm curious as to what y'all think in terms of how the discussion of execution methods relates to sort of the broader death penalty abolition movement. Some of the things that were talked about in the first panel as well, how do they relate? If you can get the execution method better, what does that do for the abolition movement, good or bad?
I guess I'll just start quickly. As Professor Berry and Professor Collins and the Stikers talked about on the last panel, there are lots and lots of problems with the death penalty. And I don't want to pretend that the problems with methods of execution are the only problem or even the most important problem. But I do think the problems with methods of execution have complicated the story around the death penalty and have been one of the factors that have pushed a gradual trend we've seen in recent decades of movement away from the death penalty. As Professor Berry and others noted, it's hard to imagine the death penalty entirely going away anytime soon, but it is clearly eroded in lots of ways. And I think, certainly not all of that story, but part of that story is botched executions, states having the death penalty but not being able to get their drugs, the sort of manifest incompetence that a lot of state Department of Corrections that I've talked about already. All of that, and then on top of that, the tremendous costs that Professor Collins and and Barry were talking about as well. So it's not the whole picture, but I think it's definitely part of the gradual erosion in support for capital punishment.
Okay. Other thoughts?
Yeah, I'll just kind of build on that because, you know, I think that litigating, I agree with Professor Berger, right, that litigating these issues it slows things down, it slows the process. I don't think by itself it's sufficient, but I do think that it makes a big difference in the same way that, you know, zealous capital defense attorneys litigating every single capital case as hard as they possibly could made a difference in the number of death sentences, right? Because, you know, states, there is so much secrecy about this, and I know we'll talk about this. One of the things that I think is really important about working in the method of execution space and addressing it is that there is the possibility of forcing this poor decision making, you know, this fascinating desire to move the responsibility for decisions about executions literally anywhere but yourself. You know, state incompetence, all of these agency incompetence, all of this stuff being exposed, I think, adds to discussions about what are we doing and why are we doing this? Why are we spending, you know, millions of dollars? I think Indiana spent almost $1 million on drugs that expired that they could not use. That I think matters, right? And look, the fact is, even if, you know, I think certainly many of our objections, at least to the use of capital punishment, isn't just the way that it's carried out, but it's certainly relevant to that conversation. And it's, I think, part of it, at least from my perspective, is reminding courts that the people who are sentenced to death are human beings, right? And nobody deserves to have this happen to them. Not the way state, like, at all, right? I think reinforcing that humanity also makes a difference.
Sure,
I'll add.
go for it.
Yeah. You know, I really love this question, in part because it is kind of a weird thing where you're like, okay, you're going to talk about how we execute people, and that's not a natural conversation for those who are like, I don't think we should be executing people at all. So in one sense, you know, critiquing like, this is a bad way, you know, almost suggests like there are good ways to kill and there are bad ways to kill, when we may think there are no good ways to kill. So why are we talking about how we do it? And I think I can piggyback off of both of these. One is a general point and then one is like a little story. But on the general point, you know, I started my process, my book process. By the way, he's the one that told me to write it. So it was his admin stuff that inspired me. But, you know, I started asking this question, like, why are states so bad at this? Right? Like, why am I seeing 3-hour-long executions? Why am I seeing 2-hour-long executions? Why am I seeing people waking up in the midst of their execution and trying to get off the gurney? Why am I seeing autopsies with 18 puncture wounds? You know, that's the sort of thing that was like, what is going on here? Over time, my question changed to, why are states sticking with lethal injection? Like, yeah, a few are in desperation moving to some other methods, but most states, like, these problems are long-standing, and they have stuck with lethal injection like glue. But, you know, if you think about it, like, they can't get the drugs, they can't get the medical professionals, they can't get access to the veins. These people actually have notoriously bad veins. They are elderly, they are of ill health often they are former IV drug users, so, like, it's, you know, it's a terrible, it just doesn't even make sense. It costs $1 gazillion, they're breaking state and federal laws, and it's not even humane. So it's like, what is this about? Why have they been sticking with this for, like, I mean, we're going on 5 decades now, but it really blew up at least 25 years ago. So what is it? And what I've come to think is that lethal injection just does one thing well. Only one thing, that's it. And I think what it does well when it works is it internalizes state violence, right? Like, it hides what the death penalty actually is. And I think that's doing tremendous work in maintaining the death penalty. I think that, you know, with lethal injection, we don't have to see blood. As a firing squad, we don't have to smell the sickly smell of burning flesh. That's the electric chair, or see people gasp and retch. That's the gas chamber and the gas mask. We do get to tell ourselves that these people are just falling into forever sleep. And I think that makes it easier to not think about what the death penalty actually is. It's like out of sight, out of mind. Nothing to see here, move along. And when we debate the death penalty in this country, we talk about it as an idea, like it stands for something, law and order. We talk, like, are you for it or against it? Oftentimes on tribal lines. And I think, what lethal injection does when it works is, it hides the brutality, the violence of what executions are, which allows those political uses to flow and keeps the death penalty as an idea. And so that's the connection that I see. And I talked too long, so I'll skip it.
No, that's perfectly legit.
Do you mind if I just
circle back?
Yeah.
No.
Is it okay if I just respond to one?
Sure,
thing?
go ahead. Give a pinch.
So Professor Lane asked, and it's a great question, like, why in light of all these problems that, again, Professor Lane documents in her wonderful book, why are states sticking with lethal injection? And I think she gave a big part of the answer, which is the sort of illusion of the peaceful death. And that's important to states. I do think there are a few other reasons that I'd just like to throw out, and I'd love my co-panelists' views on this. I think another one gets back to something I said earlier, which is courts are deferring to states for the most part. So states have little incentive to change since the courts are accepting what they're doing. I think another reason is just ignorance. That also gets back to something I said. The states literally don't understand what they're doing, so they might not appreciate the risks, even though you appreciate the risk, we appreciate the risk, they don't appreciate the risks. Another reason is to change the method. You usually need to pass a new statute. And in some states, at least, legislation is hard. There are veto gates that make that process hard. And then I think a final thing is just obstinacy. I think state officials don't like being told what to do. And when you get a bunch of self-righteous law professors up there yelling at them, there's sort of an instinct to just sort of dig your heels in the sand. So I don't know if you would agree with that, but I would throw those out as possible other explanations.
I not only agree with it, but these ideas happen to be published in this amazing law review. I think it's called the University of Richmond Law Review. The last time you were here for a symposium, right? The Executioner's Dilemma, I think is your essay. Fantastic. I just want to recommend that to everybody. Yeah, I think those are pieces of the puzzle too.
And I would completely, so I would agree with that. I don't think they have incentives from the court to make changes, right? And I think if anything, the court has really kind of lifted any sort of restraints on states in terms of this kind of decision making. No one's making them make better choices. They don't have to, and I think that's a huge part of it. I also think that obstinacy and, frankly, who this is happening to plays a role. So when Tennessee had some kind of serious problems with their executions, they apparently weren't testing the drugs consistently with their own protocol. Unlike a number of states that have had problems, Tennessee got an independent auditor to do the report and actually issued it. When Alabama had 3 botches in a row in 2022, they conducted some kind of internal assessment and then published a page and a half, which was very unhelpful. But Tennessee's report was pretty serious. And in fact, the pharmacist who was supplying the drugs told them, hey, so I know you want to use this drug, but just so you know, it's not going to do what you think it will do. The reply from TOC is noted. I'll pass that up the chain. And then they went ahead and used it, or planned to, right? And so I do think it's obstinacy. I also think some of it is a lack of indifference, and I think some of it's also what states tell themselves, that this is maybe not as, people are just kind of complaining about things in the same way that courts tend to sort of view these claims with a lot of skepticism. I think some state departments of corrections really have the same thing, or at least they prefer to think that.
Can I tell my story?
No. Not yet.
Okay.
Not yet. I remember.
Going back to
I have to say Eighth Amendment. Okay, I'm going to say it again. So let's talk about the Eighth Amendment and its relation to execution methods. So recognizing that there are folks who are high-level death penalty litigators in the room, but also down to first-year law students, let's dress this in the Eighth Amendment just a little bit. What does the Eighth Amendment have to say about execution methods? and how folks are limited or not limited in how they engage in execution methods. Or I'll just say glossip, discuss.
I'm gonna save my story. I'm gonna be quiet. And
You don't have to say it now. Now we're opening it up again.
All right. So I'll just say, so there were 3 Supreme Court cases, lethal injection cases, and if you want to know why these prisoners are being tortured to death, dying torturous deaths, and the Supreme Court isn't doing anything, it's because of their own case law. Every time they set a standard, lethal injection is so bad that the prisoners actually met the standard, and then they would up it. And so I'll just say, it starts with Bays, and this is Bays versus Reason, 2008. And the prisoners come in and say, all of the old cases said unnecessary risk of pain. This protocol is unnecessary risk of pain. They prove it. And the court says, yeah, no, the old cases said that, but we're going to do it this other standard. So then they walk away. They're like, all right, well, we missed the standard. It's substantial risk. Then they come back in glossip, and they're like, substantial risk. We've got substantial risk. We've got the autopsies. We've got the pharmacology people, substantial risk. And the court in glossip says, oh, by substantial risk, what we really meant was sure or very likely. And by the way, I know we didn't tell you this before, but when you make a challenge to an execution method, you have to give the state an alternative way to kill you. And I know you didn't do it because it wasn't the law before, but you didn't do it, and we're telling you now, and so you lose again. And so then they come back in 2019 and say, all right, we've got sure or very likely. We've got 20 out of 20 autopsies showing acute pulmonary edema. We meet that standard. And by the way, here's the alternative. It's the 14-page report that Oklahoma used to adopt a method. So they're like, good enough for the legislature, good enough for us.
Okay, remember, acute pulmonary edema is?
Being waterboarded to death. It's fluid seeping into the lungs in seconds. And we can talk about that. But anyway, the court comes in and it's like, oh, by the way, sure, very likely. You actually have to, I know we didn't say this before, but you have to show that the state super added pain. The state did something on purpose to make it so. You have to show that the state super added pain. So, there's this whole exchange where they're in oral arguments and the justices are like, so you're saying if they're getting tortured to death, that doesn't violate the Constitution? And the state's attorney's like, hems and haws. And they're like, no, is that what you're saying? And he avoids again. And finally, one of the justices says, is that a yes? And the state says, it is a yes, because you've already said a torturous death is not enough. You have to show this other method. You have to show super added. And now I'm going to tell my glossip story.
Go for it.
Okay.
Do your thing.
So in glossip, so here's an interesting thing, the way that execution litigation moves abolition. So here's glossip. The Supreme Court is like, you lose, so execute him already. He goes back down to Oklahoma, and it turns out on the day of his execution, the night of his execution, they learn that Oklahoma executed the guy before him with the wrong drug. And then they tried to hide it. And so they had conversations about like, nobody needs to know, we shouldn't be talking about this. But investigative journalists, God bless them all, were like, I wonder why they called it off. Something about the drugs. They start looking at the autopsy, they're like, oh my gosh, wrong drug. So this blows up. The secrecy blows up. The people in Oklahoma, the Department of Corrections, the warden, they get called before a grand jury. So there's this whole thing. Meanwhile, glossip is waiting to be executed. He's just sitting there waiting for all of this to blow over. It takes a while, and in that time, evidence of actual innocence comes out on glossip. And so it turns out, he was never the killer. It was this other guy, Sneed, who pled his case for life to testify against glossip. And he was the only evidence against glossip, no physical evidence at all. And glossip said, I'm actually innocent. I'm not pleading to a life term. Like, I didn't do it. and I'm not giving away my life for this. So he gets taken to trial, he gets the death penalty. So this actual innocence is boxes upon boxes of evidence where the prosecutor knew that Sneed was lying on the stand and actually reached out to Sneed's, the witness's lawyer, and said, you know, this is a little inconsistent, we need to work this out. So you've got Brady claims, you've got Napoli claims all over the place. So Glossop's lucky to be alive. The attorney, like this blows up, the Attorney General of Oklahoma, and Oklahoma is the second most executing state in the country. I mean, Florida's trying to match it, but right now it's Oklahoma. And the Attorney General says, you know what, we've got this is constitutional violations all over the place. We can't, he gets a new trial. He gets a new trial. And the Oklahoma Court of Criminal Appeals said, sorry, you missed the deadline. There's this state habeas rule, we can't consider it, kill him already. Goes up to the Supreme Court, that's their last shot, and before the United States Supreme Court, the Attorney General of Oklahoma once again confesses constitutional error. And by 5-3, the court's like, oh yeah, you can't kill this guy, he gets a new trial. But there were 3 justices that were like, would you kill him already? Like, let's get done with this. And so this is, like, when I think about execution methods and your point, Professor Klein, that, you know, it slows it down, what happens in that time can be really, really important and give the death penalty its own black eye, because you're seeing how unfair all this is. Okay, that's my story. And it's Glossop, so, you know.
That's fair. Anything to add about what the structure of the Eighth Amendment, or whether the structure of the Eighth Amendment provides any limitation on how states can execute folks? Or at least has it so far?
I guess I'll just add 2 quick points if that's okay.
Please.
So, I mean, first, I agree with everything Professor Lane said. I think functionally the Eighth Amendment really has nothing to say about the way the Supreme Court has interpreted it, unfortunately. I think that interpretation is wrong, but it doesn't. And one reason, and if Professor Lane already said this, forgive me, but a point that actually Caleb made when we were talking about this, and I believe he's writing about, is the Supreme Court has emphasized, you know, the Constitution makes clear the death penalty is constitutional, and therefore there must be a means of carrying it out. And that sentiment, I think, pervades all of the cases that Professor Lane summarized. Bays, Glossop, Bucklew, that idea, well, there must be a way of carrying it out, and therefore we shouldn't look too closely. And then the one other part of it that I would point out is, I think the court is wrong about this, but in the court's eyes, or at least in the conservative justices' eyes, the death penalty lawyers who are representing capital inmates bringing these claims are trying to game the system. They're bringing these cases in bad faith. They're trying to gum up the works. They're trying to delay executions. And the court does not want to countenance those kinds of delays. Again, I think that that's wrong. Having, you know, studied this stuff for a long time, I think there are real serious problems with it that, in my mind, raise serious Eighth Amendment problems, given how I think the Eighth Amendment should be interpreted, but that's the way the court thinks about these claims. They think it is a litigation tactic to delay executions, and they think of these cases as presumptively frivolous.
I'm going to pick up where you left off, because I do think that that presumption of frivolity is what is anchoring and motivating the way the court has thought about the Eighth Amendment and method of execution cases. So the Eighth Amendment prohibits cruel and unusual punishments. And the way the court has interpreted that in executions is they've really narrowed cruelty down to pain, right? And specifically the infliction of physical pain, okay? They put this ostensibly at the center of the test, right? The test that Professor Lane mentioned, right? You have to show this risk of severe pain that's sure or very certain, and then a readily available alternative that basically clearly will alleviate that specific risk. And they've ratcheted up this test. They've made it harder to hit every single case. In the last case, Bucklew, for example, the court, in Glossop, they said you have to show the alternative. And then in Bucklew, they dinged him for not, I guess, writing a detailed protocol, which is fascinating because that wasn't the requirement, but now it is apparently. So they put pain right at the heart of this test because the Eighth Amendment prohibits this super added pain, right? But the way the test operates and the way lower courts use the test, it's largely not very significant. Courts have engaged in bizarre historical comparators. There's a Sixth Circuit opinion that compares botched lethal injection to hanging. The court goes, well, roughly the same. So since it's not sure or very certain to alleviate the risk, okay, you can go ahead. I also think there's disinterest in recognizing what it is. And so when you have actual evidence of pain, right, coming from, witnesses describing things, tears, concerning movements, right, things suggesting voluntary movement, choking, gasping. John Grant in Oklahoma, for example, vomited during his execution. Byron Black in Tennessee this year said it hurts. Or pulmonary edema, right? We're seeing pulmonary edema in so many of these autopsies. And the court's answer is, well, we don't know if they were probably not conscious at the time, so it's probably okay, right? So when there is evidence, they disregard it. When it comes from, say, the person being executed's observers or witnesses, courts have discounted that for bias, including when it's medical observers. And then because this test is comparative, there's a huge problem because the court has said that executions don't have to be painless. They just have to be not unconstitutionally painful. That is not a clear standard. Pain is highly subjective. And we don't know what people are experiencing because the people who are in the position to tell us what's happening are dead, usually. And they do these comparative tests, but there's no way to satisfy the standards that they're setting because nobody can ethically give a person, say, doses of, midazolam at the level they're using in executions and see what happens. Like, you can't do that. You would go to prison. So the test doesn't actually work. What it's really, I think, driven by is finality, right? Because they just don't find these claims to be significant. What I think is fascinating, though, is there seems to be a difference in the way a lot of district courts look at this because they're actually hearing from people and talking to them. I wouldn't say it's across the board, but there are district courts who are a little bit more perturbed when they're hearing this stuff. And then you end up in the appellate in the Supreme Court and they go, oh, it's fine, right? Deference, deference, deference. So I think that's the problem, right? Is the court really never had a clear analysis for how to think about this in executions and they didn't really have a clear analysis in Bayes in 2008, but they hadn't really addressed it till then. And when they did, it's really more motivated about wrapping up this litigation. And Bayes was pretty explicit about that. They said, if you're a state and you have a protocol that looks like this one, it's probably going to be fine. It turned out that the litigation continued because it should, but they've sort of nullified, I think, parts of the way the Eighth Amendment should function and have really limited some of the other, ways to think about cruelty that could be broader, frankly.
All that's helpful. Let's nerd out for just a couple more minutes. In terms of federalism and the Eighth Amendment, we think about federalism as leaving some stuff to the states, but by the same token, when we think about the Eighth Amendment and other things the Supreme Court is supposed to regulate, it's supposed to provide some kind of set of rules for states to follow. Now, Professor Berger has noted almost near complete deference to states. How much deference should be allowed to states, recognizing that what's being provided may be too much? What should it look like?
These two are the ones. Like, I hope you talk about non-delegation doctrine, too.
I said y'all could nerd out on it. Just go for it.
I mean, I think you should.
So here's the thing. I think that's tricky. I've written about the non-delegation doctrine in sort of a, okay, if you guys want to do non-delegation, have I got a field for you? I certainly don't think it's what they should be doing. I think courts need to actually look at what states are doing and how they are making these decisions, right? Are they using, is their decision-making involving people with legitimate expertise in this area? Are states handing off substantial discretion to departments of corrections to make decisions that they are, as Professor Berger has pointed out, not equipped either with expertise or kind of political legitimacy to do so. And we're actually seeing a return to some sort of a troubling shift in a couple of states that I'm watching pretty closely with these sort of super delegation statutes. So both Louisiana and Arkansas have altered their method of execution statutes. And what Arkansas added nitrogen, which is a mistake that we can talk about later. That's a whole separate issue. Louisiana gives the Secretary of the Department of Corrections absolute discretion to pick between lethal injection, nitrogen gas, or electrocution with no preference. There are no standards to guide this decision. Presumably, I guess if they can't get the drugs, they just get to pick. But there are no standards to guide it. Arkansas actually has the same thing that's actually currently being litigated because the prisoners in Arkansas were able to raise a successful non-delegation claim a number of years ago in a case called Hobbs versus Jones, where and the Arkansas Supreme Court said, yes, you're right, this does violate the state's separation of powers because there's no direction. The legislature amended the statute and then they said it was fine. But, courts they've really said that they're just letting them kind of do almost whatever, and I don't think that's right? I think when it comes to the sort of height of state power, it's killing someone, it's killing one of its people. And so there has to be more attention to decision-making, right? And how states are doing it. And you know what, maybe a higher level of scrutiny is necessary. There's some folks who've talked about that, sort of shifting, Professor Lane, you're working on this, the idea that, we should shift some of this burden to the state to demonstrate that the method is safe. Other folks have suggested, I think Professor Catherine Miller at Cardozo has done some interesting work about like heightened scrutiny in terms of punishment decision-making. But whatever is happening now, this is less federalism and more just complete abdication.
I guess I'll just add that, I think the court sometimes says it's federalism, but we see the same deference when it's the federal government doing it too. So I'm not really persuaded that federalism is doing that much work. And I agree with Professor Klein, the court should actually look at the facts. They should look at the evidence. They should look at the degree of competence of the agency actually designing and implementing the execution protocol. I guess one other thing I'll say, and this is going to be more controversial, I think my co-panelists might disagree with me on some of this. I think there are lethal injection protocols that are just manifestly dangerous. The 3-drug protocol that I think both my co-panelists have mentioned, that was the predominant method for decades and is still being used in many states, creates a really significant risk of excruciating pain because the first drug is supposed to be an anesthetic, the second drug is a paralytic, and the third drug is potassium chloride. Everyone agrees that potassium chloride is excruciatingly painful as it courses the way through your veins to your heart. Everyone agrees that. And the paralytic makes you seem peaceful because you're paralyzed. And it also stops your breathing. It stops your diaphragm. So it also creates the sort of excruciating sensation of suffocation. So the sort of whether or not it is an excruciating or suffering in the execution depends on the first drug, on the anesthetic. And a lot of states just get that wrong. They use the wrong drug, as in the case of midazolam in Oklahoma and elsewhere, or they inject the wrong amount of the first drug, or it doesn't go into the veins. All kinds of things can go wrong. There are some protocols, I think the 1-drug protocol, where it's just an overdose of something like pentobarbital, in my mind is actually a lot safer. It creates less of a risk of suffering. I'm aware that there is that evidence of pulmonary edema. I haven't dug into the evidence as much as Professor Lane has, but to the extent I've looked at it and talked to some medical experts, it does seem an open question whether or not the inmates are actually conscious when that suffocation occurs. So in my mind, deference to that 3-drug protocol is nuts because the evidence of the risk of pain is just so high. Again, I know this is controversial among death penalty opponents. It's less clear to me that a 1-drug protocol properly implemented where you have safe drugs necessarily causes that same risk. So I don't think deference is as crazy there. So I guess I say that in the spirit of a way that a court might approach these questions where they're not just striking everything down, but they're keeping their antenna up for the most dangerous protocols. That would be one way to look at it. I know Professor Lane's going to disagree with what I just said.
No, yeah, so, one of the things that I was just gonna add is, to your point about, like, you said, what should we be doing? I'm not the administrative law experts, both of these two are. But I do think this notion of deference, and I think it does have everything to do with the fact that courts think this is just frivolous litigation. And to that point, I received an email recently from a judge. He said, I just finished your book. Actually, he says, sorry, I didn't buy it. I borrowed it from one of your former students. All right, great. Anyway, he goes on to say, I discovered I was just as ill-informed and knowledgeable about the whole enterprise as your average man on the street. I had always assumed the final effort of a death row inmate to challenge the execution method was the proverbial Hail Mary, meritless motion. And then he goes on to say, thanks for unveiling the whole sordid affair. But they're actually, this is what they think. And I think it is why they work so hard, because they just think it's meritless. And so in my mind, until there's widespread distrust, and until the state stops getting the bump, right? They walk in and say, oh yeah, we're careful. Oh yeah, we've done all this and that. I think, what I try to do with that work is show you what's happening behind the scenes, where they're like, I just care that he ends up dead. And, oh, well, we looked it up. We did our own research. This is a lawyer. I just looked online, went past the WikiLeaks. Until they understand what's actually happening, I don't know that we're going to get that sort of deference.
I guess I'll just add one more thing, and it's another shout out to Professor Lane's book. I think that's why her book is so important. And if anything, I think informing the public is actually more important than informing judges. And the reason I say that is even judges who are skeptical of what states are doing now are going to be very wary of getting reversed. And given the way the Supreme Court has crafted the law here, even if a judge thinks that on the facts, this is really dangerous, it violates the Eighth Amendment, I'm going to strike it down, they're going to have second thoughts, because the Supreme Court has constructed the doctrine in such a way that the capital inmate plaintiff bringing these kinds of cases almost is always going to lose. So there might be you might be able to find some cases here or there where the litigation is successful, but those are going to be the outliers just because of the way the Supreme Court has constructed the doctrine. So the important thing is changing the culture, changing what society thinks about it. And that's yet another reason why your book is so important.
Well, it's the reason why I wrote it for the public.
Yeah.
Is I was just like, I've given up on the courts. And so I'm like, everybody ought to know.
And it is a fun read. If you haven't read it, it is
fantastic. You guys are nice. I do want to disagree with you a little on the one drug pentobarbital. So he's right. You are absolutely right. The one drug protocol, it isn't followed by two torturous drugs, right? Undeniably torturous drugs. So you are absolutely right that it is a, quote, better protocol, I think, than the three drug. It makes the three drug absolutely indefensible. And I think for a long time, there was this presumption wait a minute, the one drug protocol, that's what we use on pets, right? That's what we use for physician-assisted suicide. And so there is a good way to do it. But, we don't do it the same way that we do pets. And frankly, the anesthesiologists that I've talked to said, look, it's not that you couldn't, it's not that an anesthesiologist couldn't bring someone down to a level of anesthesia and then do the overdose. We put people in anesthesia and cut open their chests every day. It's not that it's impossible. It's that that's not who you have doing it. And the American Board of Anesthesiology has said, if we find any anesthesiologist who participates in any way, including just telling people how to do it, including advising, we will take away your board certification. And you need board certification for hospital privileges. And, you know, like that sounds like a huge stick, but the fact is, and I just quote them in my book, they are so mad about lethal injection, you know, and they're like, you know, when we say lethal injection, you know, is an imposter to medicine and the practice of medicine, the practice is ours. That's what it's mimicking, is us. So, you know, they want nothing to do with this. And so, you know, that litigation in the federal district court on the Trump executions was showing, you know, what they're doing is you have non-medical prison guards. That's who's actually injecting these. I thought it was doctors. I have to say, I was like, what? No, you know, I'm supposed to know about the death penalty. How can I not know this? You know, but it's non-medical prison guards, and they're doing the whole thing in a bolus overdose. And, you know, so what they're finding is, you know, these drugs, no matter what they are, they have a different pH than our natural body's pH, which is 7.35 to 7.45. So pentobarbital, it's super high alkaline, it's a base, it's 10 to 11. Midazolam, 2 to 3. And so when you put this massive overdose into their veins, it goes first to the heart and then to the lungs. That is not open to discussion. Like, that is the way circulation works. That's where it goes. And the body does a great job buffering. This is where the state is like, oh, they can't really feel it because the body has to buffer it in order to use it. It's a barbiturate, right? So it's an anesthetic. But the thing is, the body is trying to buffer this thing, and it's already gone to your lungs. And the difference in the pH chemically burns the little capillaries, the little delicate capillaries in your lungs, makes them leaky. And so you've got pulmonary edema, acute pulmonary edema, like in seconds. And the thing about pentobarbital is, you know, its clinical use is for brain injuries, to quiet the brain, to stop the, you know, brain. And so it was, you know, we're using it, like, it's a barbiturate, so you can use it as an anesthetic, but that's not its use. And its peak effective is 5 minutes. So, like, you know, the end of the state litigation is they're literally saying, and I quote them, they're like, okay, well, yes, suffocating is bad, but it's only 5 minutes. And I quote Judge Spencer in a Fourth Circuit case, who says 5 minutes is an incredibly long time when you're suffocating to death. 5 minutes is a terribly long time. So, you know, it is better, I agree, but it's still like super bad.
And also, I also agree that any method, even ostensibly safer methods, they have to be implemented competently. And if they're not, they're even a...
And then we're done.
Yeah.
Actually, we're just about to the end of the moderated portion. I've got a number of questions, but I'm going to skip them and hope that folks will ask them in the Q&A and discussion piece. But I do want to ask a piece, because I know that Professor Klein's been working on this issue. I want to get her take and additional takes on it. And that is the psychological impact of executions on executioners, and how that might support abolition or not.
Yeah. So I've written a lot about I've written about executions. I've written about executioners, including firing squad executioners, who are not who you'd think they are, depending on your state. And one of the things that seems to come up, because there are a number of former executioners or people involved in executions, wardens, and you know, various workers. There are a lot of people involved in executions at the state level. It's not just whoever's pushing the plunger. There are the tie-down team, right? They move the person in, they strap them down. There are public information officers who witness executions, who have to report. There are additional guards who are doing death watch work and supervising. I mean, there are a lot of people involved in executions, okay? Many of them are corrections officers. Many of them have not been appropriately trained to do this work. And very often, many of them do not receive adequate psychological support. There's a challenge in figuring some of this out, simply because states are, in Professor Lane's book, seriously, it's an amazing resource. As she points out, the states are incredibly secretive about this. So we don't know, there's a lot we don't know, but what we do know is that from many executioners, and I'll say there are some who are not troubled, there are some who say they aren't troubled, there are a number who say, I'm really concerned about this being a problem later, and there are executioners who have said, this has destroyed me. So a pair of folks who were doing executions in South Carolina who said, who described real serious trauma, PTSD, substance abuse. Prison wardens have said, they developed substance abuse problems, they developed PTSD, they experienced real trauma just from ordering the execution and the process. And there seem to be sort of two harms, at least, two kind of categories of harms. And one is this idea of like moral deadening, moral disengagement, right? There's this real process of dehumanization and executions that Robert Johnson has studied and written about. And then there's actual secondary trauma, which can look like PTSD, it can look like moral injury, anxiety and depression. And when we think about punishment, we think about the effects of the punishment on who's being punished. But I think when we think about this in the context of abolition, we also need to ask ourselves about the effects on who has to carry out the punishment, right? Because there are certain kinds of punishments that we would not inflict. In and of themselves, it would not be okay. But then you also think, okay, we're asking someone to do this. There's a super interesting, very tiny little piece of this opinion, Jackson versus Bishop from the 60s, written by then Judge Harry Blackmun on the 8th Circuit, when he talks about prohibiting corporal punishment in Arkansas penitentiaries. And he describes it as degrading to the punisher and the punished alike. It's degrading to everybody to have to do this. There are not great solutions to this problem. I don't think you can adequately automate this until corrections employees aren't involved, and then someone would have to be involved in developing these systems, although Idaho's trying to build a firing squad automation process. I think it's really troubling that states are effectively experimenting with methods, and we can definitely talk more about this in the Q&A. The nitrogen, for example, is totally experimental, and they're putting these people in the position of carrying out experiments without any knowledge of what's going to happen or what that will be. States have a lot of responsibility shifting mechanisms kind of built in, like the sort of stereotypical blank round or whatever in a firing squad execution is real, at least in one of the states that does it. But that doesn't seem to be adequate either, because even with these procedures in place, people still experience serious harms. And I think the objection, right, the question I've gotten a lot and thinking about this, and what I thought about is, okay, well, aren't they volunteers, right? I mean, who would want to do that? Why would we worry about the people who want to do that? Well, one, they're not always volunteers. In fact, some states prohibit volunteering. So participation may be voluntary, but that's a little bit fuzzier. Many prisons, especially death rows, are often in rural areas. And in fact, the South Carolina guards, when they said, hey, I can't do this anymore, like I actually physically cannot do this anymore. They were not giving counseling, they said. They were told they were going to be demoted and transferred, right? And so there are pressures, I think. And even if it is voluntary, they're still harmed, right? And so when we're thinking about people who are doing this, when we think about capital punishment, we have to think about people who may have grievously and seriously harmed other people, right? And I think that's the case with executioners, right? And I think this is relevant to abolition. In fact, Indiana, it's not happening, but a legislator tried, and a Republican legislator, I believe, and he said, I think we should abolish it because of what we're asking our prison guards to do. Right, that's what I think the problem is. I don't think it's the magic solution, or I don't think abolition in this space is a one-size-fits-all. There's no magic answer other than just doing it. But I do think that thinking about what we're asking people to do matters as well, right? These aren't, higher ups in the Department of Corrections or executive agencies or attorneys. These are line-level corrections officers who are being put in a position where, and you've written about this, Professor Berger, right, where they may know something's going on, but they don't have power or the ability to address it. And I think that thinking about that experience is also relevant.
So any additional thoughts before we head into Q&A?
I have a little one. Sorry, guys.
Hey, that's all right.
You know, so one of the things you talked about was all of this damage, you know, that is done to them. And I do quote pretty extensively, you know, they're talking about, look, by the time a warrant comes down, we've been living with this person for 20 years, 30 years, 40 years. Mississippi just executed a guy this summer on death row, 49 years. You know, and what they said is, you might as well just go pick someone off the street. This guy, he got married, like, this isn't even the same guy. And you're making this do it for a job. But the other point of it, there's a guy that I quote, and his voice haunts, it's not his voice, his words haunt me. And what he said was, yeah, it was really disturbing at first, but now it ain't no different than getting a beer out of the fridge. And so, you know, like I said, this is haunting me. And, you know, it's like, what are the reactions to asking someone to kill for their job? And you have to dehumanize to kill. You have to. And so it's like, it's either going to destroy you, or, you know, you're going to feel all that trauma, or you're going to be like, yeah, it's no different than getting a beer out of the fridge. And what I want to ask states is, which of these is okay with you? Let's talk about virtue ethics. Which of these is an okay result? Because it's one or the other, that's what you get. And, you know, to your point, when you have the death penalty, somebody actually has to do this thing.
I imagine there may be a few questions, ideas, comments, etc. Harry, what you got?
Thank you very much.
Hold on one second. Can we get a mic just to make sure folks everywhere in the auditorium can hear?
Thank you very incredible.
This panel is an incredible panel, and thank you very much, and thank you, moderator. This question is for Karina Lane, my wonderful colleague. In 1999, I was on a federal habeas team, and our client was on Virginia's death row, Tommy David Strickler, and it went to the Supreme Court, and I knew Tommy and worked with him for about 4 years, and he asked me to be one of his witnesses at his execution, and it was that high point, low point of 1999 where there were the most. And it was absolutely profane to witness, and I spent the day with him in the death house with one other woman. And I'm asking you, just as a personal almost question, and it's not that there's a better way, but in Virginia in 1999, were we using the three drug cocktail, or what were we using? And I just had no knowledge at that time of these things, and I'm just curious. Thank you.
Yeah, we were using the 3-drug protocol.
In 1999.
Yeah, the traditional 3-drug protocol. I ended up interviewing Jerry Gibbons, who was our executioner. I did that, I don't know, probably 15 years ago. And he had conducted, of course, he became an abolitionist, but he had conducted executions both as the electric chair and lethal injection. And his view was, this is him, he's no longer with us, but this is him. He said, I like the electric chair a whole lot more than lethal injection. He said, because you knew, he's like, I would just add, like if they weren't dead yet, I would just add another jolt. He's like, but we didn't know. We didn't know how much. We didn't know what was going on with those drugs. We're not doctors, you know. And so I mean, the way he talked about it was, look, this was my job, and I didn't want people to suffer more than they had to. And so, but yeah, we were using the 3-drug protocol.
So I have 2 questions. One is a crystal ball question and one's a practical litigation question. So the crystal ball, we have nitrogen epoxy is getting some traction, right? You've had Alabama and Louisiana, and you have these other states adding that. You have firing squad happening in South Carolina. mean, maybe everybody's going to read Professor Lane's book and just vote to abolish lethal injection tomorrow, but where do you see the landscape? I mean, in terms of methods of execution in the next 5 years, where are states gravitating? Are they going to double down on the lethal injection? Are they going to try to experiment in other directions? What's your sense of what's happening on the ground just from studying all this? For the whole panel, anybody?
You want me to start? Okay. I mean, I didn't bring my crystal ball, so there's that. But, you know, my hope and what I've tried to do, some of you know I'm on a leave, like I'm all in on this thing. I really want to raise public awareness. I want to start these conversations, and every single time, including this time, right, you start talking about execution methods and you end up talking about the death penalty itself, right? And so it's this sort of beautiful, not beautiful opportunity that stands outside of an upcoming, you know, an upcoming execution. And so I hope, you know, what I say about the untold story of lethal injection is it is a story of all the ways the state cannot be trusted to kill and all the ways the state has tried to cover it up. And so, like, I'm like, crystal ball, well, I'm an optimist. So I think the more people know, the more we can get these conversations started. You know, I'm not just about blowing up lethal injection. And so, you know, that's where I am. And I know it's an odd time in this, you know, larger ecosphere of like cruelty and brutality, let's go. But I think it's actually the perfect time to say, do you trust the government? Do you trust that one? Because that one is, we're now prosecuting political enemies. Is this, like, let's think about all the ways we might not want to be engaging in state killing. I have no idea what will happen with it.
I will, so I'll throw a few thoughts out. What's interesting to me is I think lethal injection will probably persist at least somewhat. There's one of the president's executive orders on the death penalty to kind of directs the feds to help states get drugs. So however that's going to work, it's not going to stop being insanely expensive. And I think that may raise some flags. States have shifted to nitrogen in response to Alabama's success. I say that, and I'll talk about why I'm being so skeptical, right? So Alabama claimed that this was going to be super fast, right? Unconscious in seconds, dead even, you know, so fast. That is not what is happening. Eyewitness accounts describe shaking, convulsing, gasping. People appear to be conscious after the gas starts flowing for several minutes. Witnesses are describing panic, and there's litigation happening on this right now. There was an evidentiary hearing just last month. The state's witnesses were like, well, yeah, they're moving, but I don't think it's pain or distress. And interestingly, a state anesthesiologist expert had not witnessed the executions and said he wouldn't do it if he was asked, but was like, I think it's fine. And I'm sure that the appellate courts are going to go, okay, well, that makes sense. That's what they do with this. I taught glossip to some students of mine once, and my poor trial, you know, centered folks and evidence folks were in hysterics over the way the Supreme Court treated lower court findings, and expert testimony. The anesthesiologist who testified for the folks who are facing execution said, no, this is a real problem, right? We're seeing things that look and he watched them. We see things that look like very specific voluntary movements well after the gas has been flowing. So I'm watching that closely to see what happens. I think even if the trial court, because this is in the 11th Circuit, so even if the trial court, district court says, okay, I do see a problem, I expect the 11th Circuit to zip on by. And the test is going to make it harder to pass. States do seem to be increasingly thinking about the firing squad. Idaho just adopted it. So I think that's a possibility. What I think is fascinating is that these methods are more violent, visibly so, because lethal injection is violent, it's just maybe not as visible. These are more visibly violent methods. I wonder if that discomfort may be relevant to conversations about abolition. I hope it will. People have been saying the firing squad is much more certain, but South Carolina botched one. They botched it, right? Utah, the botch rate seems to be lower, but lethal injection is way more complicated. But it does happen as well, and a botched firing squad execution is really bad. So that's my thought. I don't have a clear answer on where this is going, but I do think it's interesting that we're being more violent as we get there.
I don't have a crystal ball. But a lot of what I'm going to say is going to echo what Professor Klein just said. I think it depends on a number of questions, which we don't have the answers to. One is, can states continue to get the drugs for lethal injection? That's been a big driver of state innovations in lethal injection, is when they couldn't get the drugs for their old protocol. That's obviously going to play an important role in the future. As Professor Klein just said, what do we learn about nitrogen hypoxia? The early results have suggested that that's also inhumane, so that obviously will matter. What happens with the firing squad, as Professor Klein just said, that I think it was the second firing squad in South Carolina recently appears to have been botched, and there was grave suffering. That will matter. The one other thing I would throw out there is I think the broader politics of the death penalty will influence it, and I think that's tied into the broader national mood in politics as well. I don't think it's controversial to say we have a president right now who has talked about vengeance openly in lots of different regards. He's talking about that with regards to his political opponents, but I think that also helps explain the executive order in favor of the death penalty that Professor Collins was talking about earlier. As a nation, do we continue to go down that path, or is there sort of a backlash against that and a swing to something else? I don't know the answers to any of that, but I think those are the kinds of questions that will help inform the answers to your question.
I saw two hands back in the corner.
A question for Professor Lane. I believe earlier you mentioned a discussion with the family of a murder victim. I know one of the arguments in favor of the death penalty is that it provides some sort of closure for the families of murder victims. Have you found that to be true when talking to those families? Are there any general trends that you've ascertained when talking to families?
I'm so glad you asked that, because I do get that question, and I'm a former prosecutor. And so I think about the family of victims. I think about victims and family members all the time. And I didn't have any capital cases, but my specialty was child sexual assaults. So I've seen a lot, and they are always on my heart. And the death penalty is so bad for victims in ways that I didn't understand, having studied the death penalty for 18 years. I didn't understand how bad until I started studying executions. I really didn't, and I feel so strongly about it. I actually am co-authoring a piece with another law professor, Kay Levine, about providing warnings for victims in capital cases. So here's what I found. It's no secret that the death penalty takes a really long time. It takes, the average time, I think somebody else already said, is 2 decades. And one response is well, then hurry it up. But when you have reversal rate of anywhere from 50% to 2/3, and the top 2 reasons are prosecutorial misconduct and ineffective assistance of counsel, those are not technicalities, those are not paper clips. And then you've got 200 exonerations now too, maybe Glossop's 201. So it's gonna take time. It's just gonna take time. And so one of the things that I think about is, the victims are told this is gonna bring you closure. And I think I'm protective of victims, and I think that's such a cruel lie. I think it's so cruel, because if we were telling the truth, if we were really warning them and telling them the truth, what we would say to them is, I know you just lost the most beloved member of your family, of your life, and now we're gonna take at least 2 decades of your life. You will not have closure. You will not move along. You will know every time they go to the infirmary. You will know about every single appeal. your life will stop because you're waiting for this guy or gal, but generally guy, to be executed. And what I've come to see in talking to victims is not only the point I made earlier about like, what? This is what I really need over here. So like, aside from all of that, it's like these victims are tethered to this person. It's the opposite of closure. They are tethered to this person for decades. And, you know, so I was listening to this one podcast actually, and she was talking about forgiveness, and, you know, that's a whole separate thing. And I don't think the state can require forgiveness, like that's a matter of your heart. But she was saying like, forgiveness is like bolt cutters, saying, you know, people think forgiveness is like, well, you know, it's saying it's okay. And she was saying, no, forgiveness is saying it's so not okay that I can't be connected with you anymore. I have to let this go and actually engage in healing. And when victims hear and learn this stuff, like you think about, I think about the El Paso, the Walmart, you know, shootings. That was like 24 people died, were murdered. And they pled that case out for life. And the reason was because the victims said, oh yeah, we know the death penalty is not good for us. What we really need is to move on and start our own healing, which means we don't want the death penalty. Like that's where the actual closure came. And then studying executions, one last point, what was really weird, and I don't make an argument in this book, I just tell stories. But you know, one of the things that I'm documenting is they're wheeling these people in a wheelchair. They're propping them up with medical pillows because they're on oxygen and they don't want them to choke while they're killing them. They get cancer and they're terminal, they go into hospice, and the state's like, we gotta get that death warrant and kill them before they die on their own. And so, you know, what does, or here's another one, these people actually, I found, oh my gosh, so many cases of redemption on death row. Just incredible. And so I write a little epilogue about redemption on death row, but it's like, what does it look like? What do we do with the fact that 20, 30, 40 years later, these victims who have been waiting, if they get their execution, if they get it, that person's not the same person. Like they're deprived of the cold-hearted murderer that they've been hating all these years, and everybody feels sorry for them. You know, I just document, like the executioners are like, we're gonna try to, you know, they pat them on the shoulder, they cry, you know, like, and I'm thinking if I'm a victim's family member and I've been waiting for decades and then everybody feels sorry for that guy. Or, you know what, here's another one from this summer, Alabama executed a guy, 27 years, I think, on death row, got redeemed, started the Church of Death Row for death row. And the prison chaplain came out and said, scarcely have I met such holiness in my life. And he was reaching people that we couldn't reach. And so everybody's feeling sorry for them. And so I'm like, you know, what, can you imagine? You know, it's like as a victim, you've waited all this time. And so, you know, you put all these things together and it's just, I think they don't know. I think they really don't know. And if they, and they say it again and again, if we had known, we never would have gone for this. We never would have supported this. So that's what I'm seeing.
What you got?
This is for Professor Berger, or really anybody. But, and Karina, when you mentioned Glossop and the three justices who would have just gone along with it, I know we can't get in the minds of conservative jurists completely, but at what point in your estimation is, it's not that they have a failure to exercise oversight, it's that their philosophy is that ontologically the state is coterminous with killing, and that you are not a state in the fullest sense if you do not have that ultimate prerogative and ability to kill.
I mean, you know, obviously, as we learned about in the last panel, there are lots of states without the death penalty and lots of states that in the last 2 decades have moved away from the death penalty. And I don't know that these justices have anything to say about that or necessarily object to that. But I think they do believe that those states that choose to have the death penalty should have the prerogative to keep it and carry it out at their wish. And as I said before, I think they see this litigation as bad faith, pesky delay tactics. You know, as I think we've all indicated, I think if the justices were more intellectually honest and actually dug into the facts more, they would, especially in Glossop. I think of the cases, that's the most egregious because the Oklahoma Protocol was just so badly designed and, you know, almost necessarily was going to result in excruciating suffering. And it had, you know, the Clayton Lockett botch, that is chapter 1 of Professor Lane's book, details, you know, very vividly. That occurred in Oklahoma before the Glossop case, and yet the Supreme Court still said, you know, like, oh, well, it looks fine to us. We're just going to defer. So I think a lot of driving it is they think it's bad faith litigation tactics. I think if they were willing to have a more open mind and read Professor Lane's book, they would realize that that they're wrong. You know, obviously I guess in Glossop it was 5 of them. Now it's 6. You know, and the explanations might differ somewhat from justice to justice, but I think that's broad explanation.
I sent them my book. I bet they'll all read it.
I'll just, I just want to add just a quick thing on the end of that. I agree with Professor Berger, right, what the response seems to be is if they make the choice to do that, then the states have the power to do it. I think sometimes some of the courts, and they've certainly expressed this, see addressing the method of execution as this bad faith end run around state power, right, in a way that is in some ways almost offensive to state power and control. But I don't know if that's necessarily as strong a commitment to state control as much as it is sort of more consistent with I guess the idea that if the death penalty is constitutional, then there has to be a way to carry it out, right? That backwards reasoning circle that we go back to. Yeah, that's our answer there.
No, that's helpful. We may have time for one more. What you got?
So I was thinking about the branding that you're talking about with capital litigation as sort of bad faith Hail Marys, and also, you know, as Professor Lane, you were saying, in some instances they can just kill the plaintiff and, you know, that takes care of the litigation too. Has there been any thinking about using civil law to try and provide some oversight or drag things into the light through the back door? So, for example, in a botched execution case, using some sort of civil claim either on the estate of the decedent or bystander family members to, you know, bring into light what's happening and create economic pressure for the state to use diligence. And then sort of the second part of the question is, do you think scaling back tort immunities for the state, for the officials who design and implement these protocols, or for the prosecutors who engage in misconduct to secure these death verdicts, do you think that that could be an indirect way of providing the oversight that the courts have not provided through capital litigation?
Okay, so there have been some litigation, some cases brought by folks who by sort of the estates of people who had died in botched executions, Clayton Lockett's, and also there's ongoing stuff in Alabama with Joe James, who was one of the 3 people whose executions were botched in 2022. James's execution took an inexplicable 3 hours, and he appeared to maybe not be conscious at the time of his execution. His lawyer said that was not like him. He would have said something. He would have had something to say. And the autopsy showed some kind of interesting marks that certainly suggested that something was happening back there, right? That they were having trouble with vein access. The James litigation's ongoing. The Lockett litigation went absolutely well, I went to the 10th Circuit with a panel that included then Judge Neil Gorsuch, and it didn't go anywhere, right? Because states don't have to tell people this stuff, right? So if you're doing civil litigation about this, it's really hard to get states to hand this information over. States exempt this stuff from state FOIA requests. One of my former colleagues who taught constitutional law was legitimately shocked when I explained this to him. Because we were talking, he goes, oh, why don't you FOIA it? And I was like, so about that, you can't. At least not there. It's exempt from state administrative procedure. States often exempt, participants from the regulation by pharmacy and medicine and nursing. So actually getting discovery in civil cases to show what is happening it's really hard. It can be done, but it's super, super difficult. And then with the Lockett case, it was really, well, they didn't mean to. This was all, that's really the tone of the 10th Circuit opinion is, well, they didn't mean to do that. So the civil litigation component is extremely difficult. I'm not sure about scaling back immunity. Certainly I think limiting prosecutorial immunity, especially when they intentionally violate constitutional rights, or at least recklessly do that, would be a really interesting and I think important step to holding more prosecutors accountable when they make egregious errors. But in terms of, the litigation, it's also really hard to find out, in terms of the immunity stuff, it's really hard to find out who these people even are. And that's part of the problem is who are you, how do we sue people when the state won't tell us who they are? And in fact, it may be a criminal offense in that state to tell you, even in litigation situations, right? Some states don't have exceptions for litigation. So, people are trying and people will continue to try, and I think that effort matters. But I think some of it is going to be, the bigger thing is going to be getting states to maybe start reconsidering the secrecy business, or at least get more people aware of just how covert this stuff is.
Thank you. That will be our last word. We are heading into lunch, so I hope the conversation will continue there. Thank you. Please thank our panelists so much.
We could have been up there all day.
Absolutely.
Just real quick, hi, I'm Grace. I'm the online editor for Volume 60. Thank you again to our panelists and our moderator. Just a few things. We have lunch set out in the atrium. You're welcome to eat in the moot courtroom. You're welcome to eat outside or find another space in the law school that you want to eat. And then we're going to meet back in this room at 1:30 for our next presentation. So thank you guys.
Thank you.
And it is my pleasure to welcome you back this afternoon. We've got a number of cool panels and some neat speakers that are going to be presenting this afternoon, so thank you for being here. Thank you to our speakers. Hope that you enjoyed lunch. Our next speaker is Mr. Lamont Hunter, Sr., and it is my pleasure to be introducing him to you all today. Mr. Hunter is a former Ohio death row prisoner who was wrongfully convicted of the tragic death of his 3-year-old son. After 18 years of incarceration, he was released on June 15th of 2023, about 2.5 years ago. Since his release, Mr. Hunter has devoted his time, energy, and life to sharing his story and speaking about the dangers of wrongful conviction and the urgent need for reform in the criminal legal system. Last night, I had the pleasure of being able to sit next to Mr. Hunter and speak with him throughout dinner. And this man's story is truly incredible. I think it's easy for us to sit here as law students and as professors even and practitioners and forget sometimes that there are people on the other side who are dealing with these issues day in and day out and who are impacted by these issues every single day. Mr. Hunter's story touched me deeply, and I hope and pray that it touches you in the same ways that it touched me last night. Mr. Hunter is full of life and passion and hope, and to see that come from a man who spent so long wrongfully convicted behind bars in microphone out. Sorry, thank you. In some of the worst conditions is truly an incredible thing to see. And so it is my honor, my pleasure, and my joy to introduce you to Mr. Lamont Hunter.
Excuse me. Hello, and thank you to Richmond Law School and the Law Review for welcoming to your school to share my story with you today. I became a free man a little more than 2 years ago. In some ways, memories of that experience are as fresh now as they were then. In other ways, I've had experiences during the past 27 months that I could not have even dreamed of while I sat on death row for so many years. I stand before you a survivor. I've walked through the fire of wrongful conviction and emerged scarred but unbroken, refined actually. My story is a story of injustice, yes, but also of resilience, hope, and the pursuit of truth. In 2006, my life took a devastating turn. I was living in Cincinnati, Ohio with my girlfriend and our children. We were a blended family filled with love and laughter. Trusting my girlfriend's 3-year-old son was a bright spark in our lives. He was a shy but a playful child, and I loved him like he was my own. But one day, a terrible accident changed everything. Trustin fell down the stairs while I was in the basement with my daughter doing laundry. Despite my attempts to help him and those of the paramedics and the doctors at the hospital, his injuries were fatal. As I grappled with the shock and grief of losing Trustin, I was thrust into a legal nightmare. I told the authorities what had happened, but they were swayed by the now discredited theory of shaken baby syndrome. They accused me of violently abusing Trustin. They charged me with child endangerment and murdering him. And then, to my shock, they also charged me with raping Trustin. I was horrified. I was innocent. But no one believed me. The doctors said that Trustin's fatal injuries could not have been caused by a fall down the stairs. And I had no explanation for why they found blood from the 3 puncture wounds in his rectum. Those injuries were why they said I sexually assaulted Trustin with some sort of object or something. They painted a picture of me as a child abuser. They called me a monster. They said that I must have swung Trustin around like a baseball bat for him to have such injuries. Despite my innocence and the lack of any evidence beside this, quote, expert testimony about how Trustin's got his injuries, I was convicted and sentenced to death. The weight of that injustice was crushing. To be labeled a murderer for a tragic accident, to be stripped of your freedom and condemned to die for a crime that I didn't commit, is profoundly traumatizing. I began a descent into a darkness I never thought I would get out of. I never thought I would escape it. The cell on death row became my world, a cold and isolating space, you can only imagine, where hope seemed to wither and die. Death row is a dark place filled with the despair of men awaiting their executions. Many of them struggled with trauma, mental health issues, but there is no hope, no therapy, no support for death row inmates. It would be easy for someone to lose hope in such a place, easy to succumb to the darkness. But I was fortunate. I had my family. Throughout my ordeal, my family never gave up on me. They visited me regularly, accepted my many phone calls, and kept me connected to my children outside of those prison walls. The unwavering love and support that my family showed me was my lifeline, a beacon of hope in the darkest of times. They reminded me that I was not alone, that I was loved, that I was worthy of fighting for. My family's support was instrumental in helping me maintain hope and sanity during those long years on death row. They were my rock, they were my inspiration, they were my anchor. But meanwhile, the courts continued to turn a deaf ear to my pleas. It wasn't until years later that I finally had a team, the amazing Aaron, spearheaded it, that believed me and took the time to do what my trial lawyers should have done all those many years ago. Comb through the medical records, talk to the right experts to understand them. My team exposed the flaws in the state's so-called science and used real science from a biomechanical engineer to show that what I had said happened was possible. And they uncovered critical evidence that had been overlooked or even deliberately withheld at my trial. They finally found an explanation for the injuries that had led to the rape charges against me, which I had no explanation for because at that time I didn't know where they come from. And they saw what no one else had seen before the records. In those records that nurses at the emergency room had unsuccessfully tried 3 times to take Trustin's temperature with the rectal thermometer. This perfectly explained the 3 puncture wounds that the state's expert had said came from sexual assault. Through their hard work and dedication, my wrongful conviction was overturned. The state didn't even oppose that. Actually, they joined our motion for a new trial. But the journey wasn't over. Not yet. The prosecution was unwilling to admit their mistake. They insisted they would retry me for all the same charges, even though the coroner who had testified at my trial had changed her opinions when my team showed her the evidence they had uncovered. They did offer me a plea, but at a cost. I would have to admit guilt to a crime I didn't commit. Not only did that mean the state wouldn't fully acknowledge my innocence, it also meant that I wouldn't be able to get not 1 penny in compensation for all those years I spent wrongfully locked up on death row. And if I didn't take the plea, they fought to keep me in jail for at least another year, maybe 2, until they retried me again. And I was, at this point, back in the county jail under horrendous conditions. Faced with this agonizing decision, I thought of my family, my children, my grandchildren. I yearned to hold them close, to be part of their lives. And in the end, I chose freedom. I took the plea, walked out of the jail a free man, and embraced my loved ones after 17 and a half, almost 18 long years. I've never regretted that decision. But my time in the free world has been challenging. After being isolated for so long in those conditions on death row, I get overwhelmed in crowded places. I still suffer from severe anxiety, PTSD, and a plethora of other things if you want to think about it. I was eager to earn my keep after being a burden on my family for so long. But after just six weeks of working, my knee gave out on me, my left knee. I had a full knee replacement surgery last spring, but I still had to take it easy for more than a year after that. Unfortunately, the jobs that will hire someone like myself with a felony now, a record, they were too physically demanding for me. That caused financial stress, of course, but also left me frustrated and quite frankly depressed that I couldn't spend my time being productive out in society, which I wanted to do, which I am doing right now again. Fortunately, I was finally able to re-enter the workforce this summer and start climbing out of that hole, which I'm very happy about. My story is just not about me, though. It's a story that highlights the systemic flaws in our criminal legal system. It's a story that demands we take a hard look at the use of junk science, ineffective counsel. Every time I talk about my trial attorney, I get and the prevalence of prosecutorial misconduct. And all these problems are multiplied in the context of the death penalty, where mistakes that's not caught in time cannot be reversed. In some ways, actually being on death row, ironically, was a good thing for me because it meant a better chance of good attorneys and resources. But it can be a double-edged sword as well, because elected prosecutors aren't willing to admit they messed up politicized convictions like mine that make headlines. I met a lot of people on death row. Almost none of them came close to the worst of the worst that the death penalty is supposed to be limited to, our society says. My home county in Cincinnati, Hamilton, Ohio, is one of the 2% of counties nationwide that has accounted for more than half of the entire death row population in this country. Think about it. It can't be fair that the same crime committed in one city won't even be charged capitally, but will end up a death sentence in the next county or city over in the same state with the same population, same crime rate, and same resources. Not to mention that the best predictor of whether someone will get a death sentence is the race of the victim. Prosecutors and jurors simply value white lives more than others. Way more black and brown people get sentenced to death for killing white people than the reverse. That's sickening. And for wrongfully convicted people like me, the way the legal system is weaponized against us, with procedural hurdles and traps, will lead to executing innocent people. It already has in this country. One of the biggest problems standing in the way of accurate convictions is prosecutorial misconduct. How many cases will it take of prosecutors hiding exculpatory evidence before we say enough is enough? Right now, our prosecutors have absolute immunity, which I hate. It's disgusting. That means they can literally lie in court about a defendant's guilt, even if they have evidence disputing what they say right in their files, like they did in my case. and face zero consequences, professionally or personally. This has to change. It has to. And I love talking about it every chance I get to shine a light on that absolute immunity. I mean, I understand prosecutors have to do a job in our society, but to me, this is my personal opinion, it incentivizes bad actors. Not all prosecutors, but bad prosecutors. The absolute immunity covers them, and it incentivizes bad behavior. Until the prosecutors are held accountable for what they take away from innocent people, their families, and the victims, who they harm as well. They re-victimize victims, families, and all. Anyone is at risk for what happened to me. Anyone, including one of us in here, one of you guys in this room. I appreciate the opportunity to share my experiences and what they have taught me about our broken system of capital punishment in this country. Before I end, I know there are a lot of law students in this audience. One of the things I like to talk about, especially when speaking to law students who might go on to represent clients like me, is to try your best to meet your client where they are, intellectually, emotionally, if you can, because you're not going to get scholars as clients, just not. So some might be dealing with mental illness more than others, or just intellectually can't understand the law. So my recommendation is, like my attorneys did. My attorneys took the time to explain the process going forward, telling me what to expect and relaying the same information to my family, which is very important. And it did a lot for me and my family. It's very important. It did a lot to gain my trust and ease my concerns. Up until that point, my case had went through the state appeals. And when I crossed the threshold of federal courts, where the amazing Erin came on board, she was actually, she listened. I felt heard for the first time when Erin and the rest of the team, when I met them. And I gained some trust, finally, in somebody who believed what I was saying was the truth. Now, if your client is guarded or hard to reach, which I was at times, and I apologized profusely after that, a lot, still to this day. Try to pinpoint somebody in a client's family or a trusted friend who he or she listens to, and try to get through to that person and let that person be the liaison. That can help you get a better working relationship with your client. It did for us. Especially a client on death row who has been there most likely a long time, who is scarred, traumatized, and desperate for hope. Death row is very dark. Death row needs good attorneys, and the prosecutor's office need them too. We need attorneys who are compassionate, but most importantly, fair and willing to admit and fix mistakes, and not hide behind procedural hurdles, but search for the truth. Thank you, guys. I really appreciate it. Your attention and your invitation for me to speak today, Symposium, on such a I love that. What is it at? That's a great title. I love that title. I love that title. But thank you, guys. I really appreciate you guys for hearing my story. Thank you. Thank you. I appreciate it. Thank you so much. Hey, it was good, though. I'm available for any questions if you guys have any. I'm open book.
I'm gonna say we have some time for questions. If anyone I know Lamont loves to answer them.
Okay.
I have a quick one first.
Sure.
In your original case, was there a plea offer on the table ever?
I learned later that there secretly was for 15 to life. My attorney never brung it to me. Well, actually, he didn't bring it to me in the beginning. He brung it to me after I was convicted. Yeah. He told me about it. He didn't bring it to me. I found out and he admitted to me.
Can you explain a little bit what the experience was like to be sitting in a courtroom as other people talked about whether or not you should live or die, and you weren't supposed to say anything but just sit there and listen?
Thanks for that question. That's a great question. I like to talk about that. Going through that, I tell everybody, going through a public death penalty trial alone is traumatizing. You're posted in the media like this, this horrible person, and that it gives people an opportunity to judge you, prejudge you, to make you out as a monster, like the courts did and the media did to me. Secondly, I sat in a courtroom, literally the only person, like a sitting duck, the only person who didn't understand the language, the legal terminologies that was being weaponized against me, hurled back and forth in the arena of the courtroom. The prosecutor, my attorney, the judge, they all went to school and learned this language. I didn't know the language, and they weaponized it against me. I later learned it. I took paralegal courses and so I can get an understanding to try my best to help my defense attorneys defend me up against this giant of a system that I was up against. But it's humiliating, to say the least. It's just it was hard to do, especially when the prosecutor, like, I'm sitting here and he's right here. This monster right here, I can't show any emotion. I can't, react. It was hard. He acted like he'd known me for 20 years. But that was one of the hardest things that I had to do is sit through that and be accused of something I know I didn't do. And I like to talk about when I was convicted and sentenced to death for these charges here. I don't know if anybody know about the prison system. These are the worst charges, not only in society, these are the worst charges a man could have on him in prison. So I like to talk about the state of Ohio, not only put my life in jeopardy once by threatening to execute me, they put my life in jeopardy twice by making me wear this jacket of a child murderer, a child rapist, something that I was not. And it's very traumatizing. I'm just thankful that I survived it with my wits and my sanity, So thank you, man. I appreciate that question.
I think we have time for one more.
I guess first, I'm just so sorry you had to go through all that. It's obviously incredibly traumatic. We met last night and we were chatting earlier today, and I was just so impressed with your positive spirit and your joie de vivre, and and I guess I'm just wondering how, just from a very human perspective, you find that joy, and you seem like you're so full of love. How do you approach life with such a positive spirit after having gone through something so deeply unjust and traumatizing?
Thank you. I appreciate that. My family, my faith. I was blessed to be born into the family that I was born into. We are a very close, tight-knit family. When my father died in 2018, him and my mother had 58 years of marriage, and they taught me and my siblings to love each other. They showed us by example. And it's a choice. I get that question a lot. How am I not bitter and angry and walk around with my head down all day long? It's a choice. I choose not to. I choose to be optimistic. I choose to look at the world as the glass half full instead of the glass half empty. I'm 57 years old now. They've taken 18 years of me and my family's lives. I'm not giving them another second. When I came home, I told my family that portion of this journey that we're on, the traumatizing portion, let's close the page on. Let's turn the page on that. Let's move into the healing chapter and move forward. And I still got a lot more living to do. It's a lot of things I haven't done in life yet. I haven't never been to the ocean before. I have never seen the ocean before. This is my first time, my second time flying on an airplane to come out here. So I got a lot more living to do. I'm blessed. I have 13 grandchildren, and they are a joy. And I got a lot more living to do to sit and watch them, grow in this world. But it's a choice. It's a choice. Yeah, thank you, man. I appreciate that. Thank you, guys. Thank you.
Thank you. We're about to move to our next panel where you'll hear a little bit more about Lamont's story, but I do want to just give him a special thanks. It's not lost to me that Lamont comes here to share some of the darkest days of his life, to shed light on the legal system, and we just really appreciate him being here. Thank you.
Hi, everyone. I'm Izzy Carvalho. I'm the lead articles editor for Volume 60 of Law Review. I'm honored to introduce our next panel, Defending Death. Our panelists are Doug Ramser, Dale Bache, and Aaron Barnhart, who, as you will hear, represented Mr. Hunter. Please join me in welcoming our panelists.
I'm Dave Johnson. I have the pleasure of being a professor here, and prior to that I was in the public defender system for more decades than I want to admit to. This is really an honor to be moderating this panel. Some of my favorite folks. What I'm going to do is I'm going to kind of start and work my way down. I'll do a little bio on each of you before I ask you your first questions, if that'll work. We're going to start with Doug Ramser, who I'll talk about in a second. Doug's work for a lot of his career focused at the trial level. And then we're going to move down and talk with Aaron and Dale, who are fighting the battle currently at different levels. But it's all, as we heard earlier, you just got to keep fighting at every level. So Doug's got over 28 years of experience defending criminal cases, including 17 years exclusively defending capital murder cases in Virginia and Georgia. Prior to starting the Ram Law Firm, Doug served as the capital defender for Central Virginia and Southeastern Virginia. During his time leading the Office of the Capital Defender, none of its clients received a sentence of death. He was also lead counsel for the very last capital murder trial in Virginia history, and his client was acquitted of all charges. He's a nationally known, recognized expert in jury selection in capital murder cases and an adjunct right here at the law school. So I'm going to,
Graduate of this law school.
Yeah, me too. All right, so we're starting with Doug because, Doug, your work at the Capital Defender's Office was largely focused in trial representation. You spent 17 years, as we said, of your professional life exclusively doing capital work. So first, can you tell us how that happened? And secondly, how you were able to withstand 17 years and more? Why you do it, I guess is the question.
Sure. Well, thank you for that. And it's really lovely to be here. So many people are doing such amazing things, especially, again, at a place that I went to law school and be able to come back and do it. I will say, I didn't know that I was going to do this when I went to law school. I'm amazed at the students I see now who have this focus and this direction and want to be public defenders. Because I was young, I was straight from college to law school, and I just wanted to go be the smartest person in the room somewhere and win all the arguments, right? And I got fortunate that I started practicing with some lawyers doing criminal work and they were handling death penalty cases, and they needed someone to do their research and writing for them. And so by the time I had been, I think, 5 years in practice, I had already served as like second chair on 2 death penalty cases, which is scary, right, for that point. And I was always morally opposed to the death penalty, but I also felt like, gosh, there's got to be, I don't feel like I'm doing this very well and would like to learn more about it. And in 2002, we opened dedicated branches of the public defender system called the Office of the Capital Defender in Virginia. And so when they opened them, I applied and I became the deputy capital defender with, 6 years under my belt and was told, now you can start defending these. But what's amazing about that experience was that, it wasn't just me. I can't take all the credit for it. There were a lot of other lawyers doing great work, a lot of investigators and staff people who are all a part of this. And the public defender system put together these great offices that were set up to not be the window dressing that people expected them to be, but were supposed to be actually staffed with lawyers who were going to get trained to defend death penalty cases the way that they were supposed to. And then when we started learning more about how to work these cases and talking to the national community about that, we started to develop this skill set about like, hey, this is great. And what was amazing for me was, because I didn't go to law school to do this, it took me a few years, but I found the cause of my career in that. I was very, very lucky and fortunate to sort of find this path that way. And once you start doing it, it just means so much, right? You start to go, wow, this really matters. And what I was told about this isn't true. And the people I'm meeting, they're saying are the worst of the worst. They're not. These are good people. The entire time I spent trying to save my clients' lives, they saved my humanity, right? They taught me about people and the goodness and all around in those dark situations. And so it really was amazing. And so when you ask, why did I choose to do it? I don't know that I did, right? It almost felt like it got, at times, thrust on me, like something almost I didn't want to have happen. But I was fortunate to say, this is the path, that's the right way to go, and have people who could support me on that and do that throughout. And one of those people, by the way, is sitting here next to me, Dave Johnson, right, who was the head of the public defender system in its entirety and helped make sure when our capital offices got created and were put under fire that he protected them. At one point in time, we were doing such a good job and being so effective that the legislature decided they were going to cut half of our staff and resources from us, right? We'd have to lose lawyers and lose investigators that had helped us be so successful. And it was Dave who said, you know what, don't make us cut specific positions, just give us a monetary cut to our public defender budget. And they did, and he found the money in other places to preserve our work there, right? So it was a lot of people.
That's it? Tell me about your time in Georgia.
Oh, yeah. So I was fortunate, too. So I spent a little bit over 4 years as a capital defender here in Virginia. And then I went down to Georgia, where I got to be in the presence of people like Steve Bright and other great people. And what was amazing to me is I practiced for about 10 years in Virginia at that point in time. And when you only know one place, right, you kind of think that's how it is everywhere. And I went down to Georgia and joined what was a brand new capital defender system there, because the Southern Center for Human Rights that Steve had founded had been suing for the inadequacies in their death penalty system, and they'd recreated, and they now had this centralized, well-funded capital defender system. And I went down there to join it with a bunch of great folks who were brought there. And the first time I appeared in court in Georgia on an arraignment for a client, so just the first appearance, they handed me 2,000 pages of police reports and a list of witnesses, which were both things I'd never gotten in Virginia before. Okay? And I was like, oh my God, Georgia is fairer than Virginia. That's crazy, right? And but I learned so much by being in that group of people who said, we're going to support each other. We're going to fight the battles that we need to, and we'll fight the system as much as we need, and we'll have your back on it. And then when I came back to Virginia, David had taken over the system and was instilling that same thing here, and it made me a much, much better, stronger lawyer to bring that back in. And it was a really important period to come and bring some of that fight back.
And not to get personal, but I believe you also met your better half down there.
I did, my wife.
You want to tell them what she was doing?
So my wife is a Presbyterian minister, and she and I met because she was also involved in death penalty advocacy, and one of the things my wife has done is be a support for a number of men who were on Georgia's death row. And I told a story last night. I won't tell it again, but I'll tell a story. I told a story last night at the dinner we were at about how I was fortunate to have Steve Bright move for my admission in the United States Supreme Court when he was arguing the Foster v. Chapman case. And I had not told my wife that the case I was going to get sworn in that day for because I was worried I'd messed up my paperwork. But I came home afterwards and I was telling her about this amazing thing that I had seen in this great case. And she's like, well, what was the name of the case? I said, it was for a guy named Timothy Foster. And she said, I visited Timothy Foster. Why didn't you take me to come watch this argument? And but she's amazing. She, in fact, was with guys up until their last hours before execution, just to be with them and be a support for them. And so she's much better than I am. You should have her here instead of me.
Next time. Okay. Doug and I, full disclosure, we go back a long way, and I know he's going to remember, like I will, when we got to watch Governor Northam sign the bill abolishing the death penalty. I don't know if Jerry's still here. Jerry Zirkin was there with us. It was a surreal feeling. We were in the parking lot outside of Death Row, Greenville Correctional Center. A lot of people worked really hard for a lot of decades to get to that moment. A lot of people, not just the lawyers we're talking about. So I don't want to diminish their contributions in any way by asking this question. But that being said, I think a definite tipping point, as Doug alluded to, was the creation of 4 regional capital offices, which, by the way, the bill was drafted and pushed through by a very conservative Republican senator and former police officer who, so stranger things can happen, I guess, right? So these 4 regional offices were created in 2002. 19 years later, when the bill was signed, these offices had actually already eliminated the death penalty. That's kind of what made it happen. So that's my question. How'd you guys do it?
There was a lot of luck, for sure, in some ways, and there was a lot of people working hard for it. In 2002, when our offices got created, there had been a steady stream of folks on to death row in Virginia. And what we saw then was, in the next 20 years, the numbers just fell off a cliff. And when you gave resources for dedicated lawyers who were trained to defend death penalty cases, and that's all we had to do. We didn't have a bunch of other things going on. And, I didn't have 100 cases going on at any point in time. I had 2 or 3 maybe at a point in time that I could work on. You could do all the work. And so one of the sort of mantras for my office was that we were going to give poor people a rich person's defense, right? And we were going to put all the effort into it that other people weren't able to do sometimes. We had investigators on staff. We had mitigation specialists on staff. And we learned, how do we do those things? How do we look under all the rocks to find the stuff? How do we litigate all the issues? And one of the nice things is, it used to be before us, if you had a lawyer for a death penalty case, the judge picked that lawyer and paid that lawyer, right? And so if you're going to get that case, you had to be someone the judge liked. And if you wanted to get paid for all your work, the judge had to like the work that you did. But when it was a public defender system, the judges no longer had a choice of who the lawyers were. So my boss was not the judge in those cases. And I could afford to go after the injustices that I saw there and the mistakes that they were making. And they couldn't do anything about it right that way, but they had to take that. And so we were able to fight the battles that other people did. I didn't have to worry about that judge being mad at me and not appointing me some other case the next week, right? And so that helped a lot for us to feel comfortable that we could come in and do the job the way that we were supposed to do it. And so that's what we just kept doing. And what we found is, too, the prosecutors weren't prepared for the kind of fight that we were going to put up, right? They weren't used to all of this litigation and motions practice. And at first, they would make fun of us for filing as many motions as we did. These frivolous motions. At the beginning of any case, when I file my first 5 motions or so, I would make a copy for the judge, and it was just like 5 motions, but I would give him a binder that was about this thick, so he knew, and with a bunch of tabs to expect a lot more. Right, the tabs went to 100 so that he knew there were a lot more coming and to expect it that way. And what would happen sometimes is they would fight these fights and then they would not be successful, right? And we were able to get life maybe for our client in a verdict. And they realized, wait, I'm fighting these battles and I'm still losing, right? And so maybe now they should start talking to us about negotiating the cases. And I will tell you, the main reason we were successful in the Capital Defender's Office was not because we won cases at trial. Absolutely not. The reason why we shut off the flow of new death sentences was because we negotiated most of those cases out, right? And part of that was convincing prosecutors to offer plea agreements. And the other half, frankly, was convincing our clients to take them, right? Just like Lamont was saying, building relationships with clients can be very hard for lawyers sometimes, right? We want to do the law. That's what we're trained to do. We don't have a great bedside manner a lot of times. But when we were dedicated to this, we started being steeped in this idea, and we had mitigation specialists on staff who could help us show we had to build relationships with our clients. We had the time to go spend time. You can't expect a client to tell you their deepest, darkest trauma unless you've really built their trust. Because you got to remember, they're charged with the death penalty, and the government is saying, we want to execute you. And by the way, the same government says this is who your lawyer should be for that. And we're going to pay that lawyer while we try to execute you. And so that person's got every reason in the world to not trust me. Right? And so it took us a lot to build up trust where I could then say to a client, hey, you should know, I think this is really not going to go well for you. I think the hardest thing that can ever be done in the law is convince someone that they should agree to spend the rest of their life in prison. Right? And that's what we were doing for a lot of our clients, working through some of their trauma, working through some of their issues so they could accept responsibility sometimes. And there are times we might have a client who would say to us, I'm innocent, I didn't do it. And I want to be their lawyer, but I go, but it looks really bad. And innocent clients sometimes are more likely to get executed. And we're going to lose this trial, and we should look for ways to resolve trials, right? And so there were clients I pled, not necessarily for life all the time, but for lesser things too, that we felt that way about it. And so we were committed as an office to doing that, to giving that full defense to everyone. Another one of our mantras was we're trying to end the death penalty one case at a time, right? We wanted to work ourselves out of a job. And we came in each day, and they were hard days. Days when you're beaten down. A judge, it hadn't gone well. Sometimes your clients aren't as happy with you sometimes, but we supported each other, and that helped a ton, right? For us as we came in every time to give our best effort and our full effort throughout. And we saw the results of that, and that helped a lot throughout.
Speaking of working themselves out of a job, the reward at the end of the rainbow was after the governor signed the bill abolishing the death penalty. A few days later, the General Assembly ended the funding for the offices. So they literally did work their ways out of a job. Doug, you talked about the advantage of coming in, not being the local attorney that the judge appointed, not being local at all in a lot of cases, not worrying about aggravating people. I'm thinking back to when early on when I knew this was going to be an interesting ride. Do you want to mention the Robert A. Lee portrait?
So, Dave mentioned earlier a case. I did a case in a county, you can look it up easy enough, so I'll say Louisa County, which is about 45 minutes west of here. It's a rural conservative county here in Virginia. And my client was charged with capital murder, African-American man, charged in a robbery homicide. And the allegation was that he and a co-defendant had kicked in the door of the co-defendant's cousin's house in the middle of the night, who was a drug dealer, and had gone inside to rob the drug dealer. And a shootout occurred. My client was shot in it. The drug dealer cousin was killed. And then people left the house, and there was a chase later on, and it goes on past that. So, and this prosecutor decided he was going to seek death against my client. He wanted to prove that he was important enough to get a death case. And we came into this old rural courthouse in Louisa, Virginia, and it's one of these courthouses that's been there for a long time. It was built in 1908 is when it was put there. And in the courthouse is filled with portraits of historic people from the county, right? Judges or sheriffs, right? Former prosecutors. But the single largest portrait in the entire courtroom was a life-size portrait at the very back, facing the judge, a life-size portrait of Robert E. Lee in his Confederate uniform. And we looked into the research of this. Now, this was 2018, and it turns out this had been specifically commissioned in 1908 to be there, and they'd paid for it to be in for that place in the courtroom. It was built specifically for size for that. It had been, this was the part of the sort of the lost cause mythology in Virginia of rewriting the history of slavery and the Civil War. And so the community had said, we need to make sure in this courtroom we have this picture of Robert Lee. Now, Robert Lee had no connection to Louisa County. He'd never lived there. He never fought any battles there. As far as I know, he never stepped foot in the place. He's not a lawyer, right? There's no reason for that. And here he was in his Confederate uniform, facing down the whole thing. And it had been there for 110 years when we were there, and no one had previously ever objected to its presence in the courtroom. Right? Because everyone who came there wanted the benefit of the judge who was there, right? They wanted that judge to be happy with them, and that court to be happy with them. And we said, we're not cool with this. right? And we talked to our client about it because it matters for him too. We're gonna have a jury trial on this. And he said, absolutely, I do not want that here. And so we filed a motion objecting to having our trial in a courtroom that had this kind of image in it. And we came, and now our judge, who was really a pretty good judge, but he'd grown up in Virginia, and he'd been taught the lost cause mythology in school, that Robert E. Lee was a good person, right? That Robert E. Lee was a guy who went through West Point without any demerits. He was an honorable man, right? Didn't really fight for slavery. And we showed the history of this. We showed that, in fact, there were 3 people who voted to put this there. It was, at the time in 1908, the judge, the Commonwealth's attorney, and the clerk of court. And we showed the Commonwealth's attorney was a part of when they rewrote the Constitution in Virginia to entomb Jim Crow slavery. And his quote at the meetings for that was, "I'm just here to make sure that blacks don't get the same rights as white people do," right? And that was the people who put this up. And we had a hearing, and we filed a motion about how, this doesn't belong here. This isn't a museum. It's got no place, and it's intimidating. And our judge said, there's a state holiday in Virginia for Robert E. Lee right now. And if the state of Virginia thinks he's worthy of honoring with the state holiday that all state employees get off, then I think that there's no reason for me to take this portrait down, right? I think it's meant to just show honor, that he was an honorable person. And my response was, I don't think any African-American person has ever come in this courtroom and thought that was an emblem of honor to them that way. But he just couldn't see that. He had some blindness, I think, to that. And so then we continued fighting and litigating over lots of other issues in the case. We were, in fact, we knew our client was innocent. We knew, in fact, that the prosecution had their story all wrong, that there was, in fact, another person who had been present and involved in this shooting, which mattered because there's a triggerman rule in Virginia. You had to be a shooter, and only a certain number of guns. But they'd convinced the co-defendant to testify against us and insist there wasn't another person involved. They convinced the driver of the car to say there wasn't another person involved so they could put the finger on my client, who's now the only person facing death in the case. And we developed a lot of evidence through our work, including cell phone records and everything else that could prove there was another person that was present. And we went to the prosecutor in the case, and we said, hey, we have proof that there was another person present. That means our client was innocent, and the prosecutor refused to listen to our evidence. In fact, he got up and walked out of the room when we tried to show it to him because he did not want to be poisoned with our false information. That's what he said. And he marched out of the room on us. And so we continued to fight and battle. And then, interesting what happened, we had this amazing summer where George Floyd, unfortunately, was tragically killed. But a bunch of things were moving in society at that point in time. And it turns out our governor at the time may or may not have been in either a Ku Klux Klan outfit or blackface from his academic career. And they were looking for ways that they could have some more racial justice. And the legislature in Virginia repealed the Robert E. Lee state holiday. And they took it from him. And the day the governor signed that bill, I refiled my motion. And I said, if it was good enough for him to have a holiday, when they take it away from him, what does that mean for his respect and honor? And to his credit, the judge reversed his order. He ordered the portrait removed from the courtroom. We went to trial about a month later, and my client was acquitted on all charges. And we didn't know at the time that it was the last capital murder trial in Virginia history. And in fact, that verdict came down October 1st, 5 years ago. So 5 years and 2 days ago, our client was freed from that. Again, a lot of people, my office, the other attorneys, investigators, and staff worked really, really hard, and we're really proud of that. But it took a lot to get there. There's a lot of battles to get there. Thank you for asking about it.
I like that story. I'm going to move on down the row a little bit. So you've already gotten kind of an introduction to Aaron Barnhart. I don't know that I could say much more than just watching the interactions between Lamont and his attorney, but briefly, Aaron graduated from Ohio University and earned her JD at Notre Dame. She clerked for the Honorable Chief Judge Jeffrey Sutton on the U.S. Court of Appeals for the Sixth Circuit. She joined the Capital Habeas Unit of the Federal Public Defender's Office for the Southern District of Ohio in 2009. And Aaron represents death row inmates in federal habeas and civil rights litigation, as well as clemency and some and other related state court matters. Welcome.
Thank you.
Aaron, I think it's say we were all moved, to say the least, by Lamont's story, but I'd like to hear a little more about it from your unique perspective as the attorney.
Sure. Well, thank you. Thanks for having me and Lamont. To begin, I just wanted to show everyone that I have some flyers here about Lamont's case. There's like a little blurb on the back, and then we have 2 QR codes on them. One goes to a podcast. It's an episode of the Wrongful Conviction podcast where Lamont and I explain his story. And so it's just like 40 minutes long. So if you were moved by his story and wanted to share it with someone else, you can just easily, get the link to that and post it on your social media or share it with a friend. Take more flyers if you wanted to pass them around. And then the other is for his GoFundMe. As Lamont mentioned, he received 0 compensation from the state of Ohio and until recently was unable to work. And so he's still climbing out of that financial hole. And so, any amount of either financial contribution or just spreading the word about his case. He's available to do in-person or Zoom talks like this. He does kind of rely on honorariums and speaker fees to supplement the income he gets from his work. So I'll just leave these right here on the desk, and you can feel free to pick them up after the break. So Lamont's case was my first Shaken Baby case. I had heard the term, but really didn't know much about it. And, as Lamont mentioned, I think that we were the first people to, fully believe he said he was innocent. Okay, let's look into this. And so probably the best thing I did was I reached out to Kate Judson. She was at the University of Wisconsin-Madison then, but now she runs the Center for Integrity in Forensic Science, which is a wonderful organization. It has all kinds of resources for all kinds of junk science. She assists Robert Roberson, if you're familiar with his name. He's the gentleman on Texas's death row who came within 20 feet and 20 minutes of being executed last year. He very well could be the first person executed in this country this year for Shaken Baby junk science. She knows what she's talking about. I sent her the trial transcripts of the state expert, and she marked them all up and said, this is wrong, this is not science, there's no way she can say this, and we were off to the races. And she connected me with, the experts that we needed, who said, you need to get the records that his trial attorney didn't bother to get so that we can, make an assessment, because to properly do a Shaken Baby analysis, there's so many other things that can produce the injuries that Shaken Baby adherents like to say, have to have been from abuse. There can be, underlying genetic components. There could be birth injuries that sort of lay latent. There's just a zillion sort of things. And, it wasn't done properly in his case until we got all those materials. So, we just kind of did it the way you're supposed to do it, the right way. We got the right people, we got the right information. And as Lamont mentioned, I think we're the very first people who ever put eyes on those records, that said clear as day, blood noted on rectum after trying to take the rectal temperature 3 times. And, the coroner told us in her deposition, she had subpoenaed the records from the hospital, but they actually never sent them to her office. And you might be horrified that someone was sent to death row by that, but she told us actually she was sort of new in the coroner's office then, and her colleagues were sort of annoyed with her because she was even bothering to get these records because that wasn't sort of the practice in the office. And so, it's just the kind of thing I think there's just diffuse responsibility underlies a lot of this. Lamont and I have had conversations, and it's easy to say how his terrible attorney convinced him to waive jury, so he had a 3-judge panel. And one, you'd say how could those judges have convicted, him? And I said, well, they basically couldn't do anything else because they had unrebutted testimony in front of them because his trial attorney didn't hire his own experts, didn't put on, any of his own testimony. So all they've got is these, this, in particular, this child abuse pediatrician who's just saying all this unscientific stuff that basically there's no way short of a major car crash that you could get these kinds of injuries, other than abuse. And so they sort of had no choice to do it. And then, he and I have similar feelings about the integrity of the prosecutor in his case, that go beyond. But, even if you think a prosecutor's trying to do a good job, and they've got a very persuasive child abuse pediatrician saying to them, look, I'm telling you, I'm the scientist, I'm the doctor, and I can tell you this. Well, they're not a doctor themselves. So there are ones with integrity, I think, that go out of their way to try to get other opinions and talk to people. But you can kind of see how they'd be like, no, the doctors told me, like, this has to be abuse. And so there's all this, like, nobody bothers to actually get down to the ground truth. Except for in the advocacy, system, it's supposed to be the defense attorney, but if that falls apart, then it falls apart. So, we got Lamont's case. I am a capital habeas attorney, which means that the very first time I can get involved, when I did get involved in Lamont's case, is after all his state court direct appeal and post-conviction or state habeas or collateral review, whatever you want to call it, is concluded. I can file a petition for writ of habeas corpus in federal court. And a word that I don't think we've said yet today is EDPA, which is the acronym for the Anti-Terrorism and Effective Death Penalty Act, which Congress passed in 1996. And that governs a lot of what federal habeas lawyers do. In short, there's a ton of both procedural and substantive hurdles to relief by design. And makes it extremely difficult to get relief. So, we were fortunate in that I like to say, if you're going to lose, you want to lose big, like as bad as you can lose, because then you can sometimes turn that around. And so, when we deposed Lamont's trial counsel, he, not only admitted that he didn't do anything, but like doubled down and said, like, and in fact, I think it would have been worse to have an expert, and I don't need it. Fortunately, our judge said, like, well, in the case where like the only evidence is scientific, like you kind of do need to have an expert. And that gave us the discovery that we needed. That was our only hope. Like, if we didn't get discovery in federal court, like that, we were done. He got no process in state court, but that led us to discovery that we needed, and to get our own experts. That led us to, deposing the coroner, where she changed her opinion, and on we went. So we were very fortunate, and when I watched Mr. Robeson's proceedings in Texas, and virtually all shaken baby cases, like, share these similarities. There's always sexual abuse. It's so interesting how all these shaken baby cases have allegations of sexual abuse. In Mr. Robeson's case, the nurse performed like a sexual assault kit examination just on her own initiative, which, like, you're not supposed to do that. And it seems like completely bogus. And it's so powerful, though, right? Because as they use it against Lamont, even if you believe him that Trustin fell down the stairs, you can't explain these puncture wounds. So, it's such an easy way for the state to, dispose of whatever, the defendant's story of accident is. And so they're really terrifying because, the system is not set up for innocent cases, certainly not in the federal system. And so then it's the luck of the draw if your state court has passed laws to allow, you to reopen your case to bring forth innocence. Like in Ohio, we have a statute that allows you to pursue DNA testing, but that's it. Like, I have another client who I think is innocent. He was convicted, 35 years ago or something like that. And at the time, there were fingerprints at the crime scene that he was excluded from. Well, back then they just had their little regional database. Now the feds have APHIS, which is an international database. And so I would like to run those fingerprints through that database and see if maybe it hits on someone. But our statute only allows us to ask for DNA testing, not other types of forensic testing. And the judge actually said to the prosecutor, what's the big deal? Like, let's do this. And the prosecutor said, well, you just don't have jurisdiction to order that. And he said, but if you wanted to do that, could you call up the lab and have them do it? Oh, yeah. So it's, one of the things we talk about in Lamont's case is and I feel a huge structural problem is the fact that coroners and crime labs are housed within the executive, or within law enforcement. There's so many, structural and implicit bias and things like that. That happened in Lamont's case after the coroner who performed his autopsy changed her opinion. The prosecutors got on the phone and got all the other pathologists in the office for the first time in their history to issue a supplemental addition to the autopsy report, and they all said that they didn't think that she was right to change her opinion, and it was crazy, yes. But anyway, his case sort of as he said, brings to light all these aspects of junk science, prosecutorial misconduct, ineffective assistance, and it just shows you so many things that can go wrong. And, every day I am grateful that it worked out, that he is innocent, that his innocence was able to get him free. One of my personal models is never, ever, ever, ever give up. And it sort of relates to kind of luck favors the prepared, because, you litigate that motion, it seems like a loser because you don't know in 2 years they're gonna pass that law, right? Karina was talking about Richard Glossop doesn't know that getting a stay because of his lethal injection litigation is gonna allow time for other evidence to come forward. So much of this work is pursuing on all fronts so that if some break does happen, you are able to take advantage of it. But sometimes that break doesn't happen. And we talked about the arbitrariness, it's like being struck by lightning. I mean, I certainly see that in this work, is that sometimes people get relief and they deserve relief, but there are other people who are just as deserving of relief, if not more, who never get that lucky strike and get to have relief, so.
And just editorial license, what you might be picking up on, and you'll hear some more from Dale, is just for those aspiring attorneys, what a difference good lawyering makes. I mean, it's literally the difference between life and death. An example right there. I want to move on to Dale, but first, I know you do some clemency work too, and that's going to kind of tie in with Dale. So tell us a little bit about, I think you had one case in particular you might want to talk about.
Sure, yeah. I mean, clemency is the exact opposite of habeas. There's just no rules at all. And you can bring any kind of claim you want. It doesn't even have to be a legal claim. And in Ohio, there's aren't rules of evidence. People aren't under oath. It's kind of the Wild West. In some ways, it's incredibly uncomfortable because I think, I mentioned in an earlier comment, that's why I, heard one of the victim's widows, express that, she hadn't really been served or whatever. But clemency varies state to state, and so it's different everywhere. It's another example of this, you got to be prepared. Kind of like Glossop, one of my clients, we had a big win in Ohio on lethal injection. We had gotten an Eighth Amendment stay, and we also got it upheld on appeal. And fortunately, the Sixth Circuit took it en banc. The full court took it and reversed it by one vote, and it just happened to be the judge that a newly elected President Trump had who was the first judge he put on the Court of Appeals. So, the politics of this is clear. But anyway, in that delay, there's a long version of the story that I won't get into, but so my client had a clemency hearing before the parole board, had gotten an unfavorable recommendation. Now it's a year later after all this lethal injection litigation has happened. His date is coming up again. We're having another preliminary injunction hearing on lethal injection. And one of the other inmates who was in a wheelchair, had a colostomy bag, only had one lung, was going to need to have a medical pillow propped up even so he could breathe. In the middle of the hearing, the state disclosed that their own check found that they weren't going to be able to access his veins. And as we discussed in the last panel, we have to allege an alternative that's readily available. And we had been alleging a different method of lethal injection, which now could not work. So we had to amend his complaint right in the middle of the hearing. We alleged firing squad. Well, this kind of generated headlines. A juror on my client's case, who from 20 years before happened to see a headline about Ohio inmate, asked for firing squad. And in the article, it mentioned my client, the client whose trial he was on. And he was on it in his early 20s. He'd always sort of followed the case. He Googles it, happens to find our clemency materials that were posted on Ohioans to Stop Executions website, and immediately sees the things that, now we only had this client for clemency, by the way. So his lawyers had litigated the most common claim, which is ineffective assistance of counsel for presenting the mitigating evidence against a death sentence. And this client, it's classic, but it was very extreme childhood neglect and trauma, and was put into horrible foster care where there was abuse, and he kept running away and everything like that. Anyway, so we had pulled out these records and had highlighted things like the children seem underfed, I can't remember all the other stuff now. The minute he saw those things, he was like, what the heck? Like, this is what I wanted to see at trial. Like, they said they had a bad childhood, but there was no proof of it. And he writes an email that says, I don't know if this matters, but I was a juror in this trial. And if I had seen these documents at trial, I wouldn't have voted for the death penalty. Well, it very much matters in Ohio, because a single juror who doesn't want to impose death means death is off the table. It has to be a life sentence. So anyway, only because we had this delay, and then the thing about the veins, and the headline about the blah, 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 the juror comes forward, we meet with him, he ends up writing a letter to our governor, and the governor gives us a reprieve. We go back to the parole board. Here's an example of, if you're gonna lose big. No one on the parole board changes their vote, which is like absolutely insane. They're just like, we don't think it would have mattered. And he's like literally there telling you it would have mattered. And this is why they lose in court, because in court they're always like, well, we can't know if it would have like changed the jury's view, all this other stuff that you've put forward. And we're like, but this time we can know, because the juror right here is saying it would have mattered. Anyway, so we lost big, but I think that made the governor realize he didn't really have to defer to the parole board at all, because they were not like treating it, appropriately. And so we ended up granting him clemency because of the system failure. So that's my story of getting life without parole for a sentence for a client.
Good job. Let's move on to Dale. Dale Beige is the former head of the Capital Habeas Unit at the Federal Defender's Office in Arizona. He oversaw the final appeals of prisoners before their executions by Arizona, Oklahoma, Texas, Utah, and the federal government, as well as cases in Ohio and California as well. He's also guided the litigation that established the current Arizona execution protocol in the Oklahoma case, Glossop v. Gross, in the U.S. Supreme Court. He's achieved a handful of exonerations, but he's also witnessed the executions of 15 people. Dale's a prolific writer, and he also serves on the faculty at the Sandra Day O'Connor School of Law at Arizona State University. Thank you, Dale, for being here. You've been at this a while, and you do a lot of aggressive litigation. And we talked about this in a variety of areas. I know some of the important issues you're dealing with are lethal injection, access to information through FOIA and records requests, and clemency. So first question, let me ask, what approach do you take with this type of complex litigation, post-trial litigation?
Well, thank you for the invitation. I'm really honored to be here. We're defense attorneys, right? I don't look at myself as a defense lawyer. I'm a lawyer who wants to go on offense. And when I'm representing a client in a post-conviction case or in a habeas case or in a clemency case, I want to go on offense, because at that point in the proceeding, what am I there to defend? The client's already been convicted, sentenced to death. The conviction and sentence have been upheld on appeal. So my approach is to try to change the narrative, change the story. And one of the ways that I tried to do that initially was, you get a record, You have the discovery, you have the evidence that was submitted during the trial, but something's missing, right? So when I started out at the State Public Defender's Office in Ohio, there was a case called State Ex Rel NBC versus Cleveland. And the local NBC affiliate sued the Cleveland Police Department for records and won in the state Supreme Court. And I'm thinking, if the media could get these records, why can't I get the records? Because in Ohio at the time, there was no open file discovery. So we start sending letters to the police departments. We would get denials, and then we sued. And during the litigation, we got some documents. And then we appealed that decision to the state Supreme Court, and we got some more documents during the proceedings. And I took the documents that we got through the public records litigation and compared it to what the lawyers got during discovery, and we got a whole lot more. And in this one case in particular, the client's name is Tony Apanovich. He was convicted of rape, murder, and burglary, and it was a circumstantial case. But when we start getting the records from the city of Cleveland, we found out there were other suspects. We found out that there were witnesses that were not disclosed. We determined that the prosecutor made some material misstatements during the trial. So during the post-conviction and habeas proceedings, we were able to change the narrative that there was a Brady violation here. There was prosecutorial misconduct. There was ineffective assistance of counsel because the trial lawyers were not aggressive enough in trying to get these records. And what happened over time is that, again, time is on your side, and it's very hard for the clients when they say, you're just delaying my case because you're doing it for just to delay it. And Tony was lucky in that the Sixth Circuit, when we were up on appeal in habeas, sat on the case for 10 years before it set a briefing schedule. And finally, after 10 years and with the client threatening to do it himself, I wrote a two-sentence letter to the court asking it to set a briefing schedule. But what we were able to do in that 10 years' time is develop the record, and we won in the circuit on Brady. It got sent back to the district court for a hearing, and during that hearing, we got discovery, and what did we get? A DNA report that was prepared 8 years earlier that was never turned over to us. And the federal judge said, I don't want to hear anything about DNA. So we finish the habeas process. We go back to state court and file a fourth post-conviction petition, and ended up getting relief for the client. The judge ordered a new trial based on this DNA report, and the judge granted bond, and Tony was released from death row. But 2.5 years later, the state Supreme Court, which did not have to take the case, it had the discretion to let the case go for a new trial. took the case and said, based on the Ohio DNA statute, which Aaron mentioned, it's the defendant who has to request the DNA testing. And since Tony did not request the DNA testing,
because he didn't know it existed,
the court did not have jurisdiction to grant him relief. And the next day, Tony was returned to death row, where he remains today. We now have a second in time habeas petition pending in federal court based on the DNA evidence. 3 years ago, we filed a clemency application with the Ohio Parole Board, and the Parole Board said, no, we're not going to review the case because under our internal policy, there has to be an imminent execution date, and there cannot be any litigation pending. So we are stuck in this cul-de-sac that we cannot escape. You know, the point of telling that story is, one, Tony remains so hopeful. He's still full of hope, and Lamont and Tony knew each other, and he said to send you his regards. But the point is, you know, you have to keep working these cases. You can't give up, and you need to try and make your luck in the cases. One final point on the lethal injection litigation. In Arizona, we had a series of cases, and we had a decent district court judge who allowed us to make the record. He wasn't going to give us relief. But every time we appealed to the Ninth Circuit and argued the case, in the end, we were not successful. The circuit, I think, determined that if it granted a stay, the Supreme Court would vacate the stay. But what the circuit did was it got concessions from the state during oral argument, and during a series of oral arguments. And along the way, the execution protocol in Arizona became more transparent. And in the end, in 2014, when Joe Wood was executed, we had a fairly transparent protocol where we were able to see a lot of what was going on. And you may not know, but it took Joe Wood 1 hour and 57 minutes to die. And as a result of that, Arizona put a moratorium in place, and through litigation, we were able to settle our lawsuit against the state of Arizona. Arizona was using midazolam at the time, and part of the settlement is that they would never use a benzodiazepine for executions going forward. So, you know, the lethal injection litigation is important because you learn things along the way. I think you call attention to what the state is doing, and people are appalled. And you know, we tell our clients up front, this is not going to save you in the end. You know, this isn't about getting rid of the death penalty in your case, but it's about trying to make sure that if the state does execute you, that you're not going to suffer at the end.
Thank you. Dale and I talked about this, but Aaron might want to weigh in too. Doing habeas work, oftentimes the claim might be ineffective representation of counsel. You're going to be contacting trial counsel. What is it that you need or want from trial counsel, or what don't you need?
I do not want a lawyer to say to me, let me fall on the sword. I want the lawyer to tell me exactly what she or he did during their representation. I want to have an open and honest discussion with them, because if we get a hearing, I don't want to be blindsided. And, I think sometimes lawyers, they want to be helpful and they say, tell me what you need me to say. And I don't want to be the one telling the lawyer what he or she should say. I want the lawyer to have that dialogue and discussion with me, and hopefully through that, we will get what we need to support the claim.
But as Doug alluded to, in a lot of places, and Ohio is one of them, the trial judge appoints the counsel for indigent defendants, which almost everyone is. Certainly anyone who ends up on death row probably had indigent, or not everyone, but most of them. And it's an incredible conflict of interest, because you are relying on that judge for appointments for your livelihood, and you don't want to rock the boat too much, because then they're just going to say, like, this person was a pain in my butt. He put this binder with 100 tabs in it for all these motions. I don't want to deal with that. I'm not appointing him next time. And so here's the thing. No one expects you to win your capital trial, right? And the most politically disenfranchised people are inmates on death row. So when you do a terrible job as a trial counsel, there's no accountability for that. And so some of these people are drawn to the fact that there are higher caps for the amount that they can bill on capital cases, which makes sense because they require more work. There's this whole second phase. You have to have more experts and all that stuff. But so that's important. We have to have that, right? But it also is a way for unscrupulous people to just lie, to never visit their client in prison. So, I don't want people to fall on the sword, but I also want them to tell the truth. And sometimes they don't. They just lie about it. They don't do any work, or they think like, oh, I'm just going to plead this out, and the client doesn't want to plead it out. And so, some are extremely defensive and not willing to admit that they did anything wrong. Some even go out of their way to cooperate with the prosecutor and write an affidavit for them. Oh yes, I had a strategic reason why I didn't explore this alibi defense or something like that, which, just defeats your ineffective claim, which is completely unethical. You have a continuing duty of loyalty and confidentiality to your client. Now, if in an IAC, in an ineffectiveness claim, I might be partially waiving my duty, my client's right of confidentiality, because if I'm saying they messed up, they do, the prosecutor does say, well, let me see your files, let me see what you actually did or whatever. But we get there when we get there. So that can be a real problem, where you don't have the protection of someone other than that trial judge, who also is taking campaign contributions from those lawyers. It's the most messed up, conflict, inherently messed up system that you can imagine. And the Ohio Supreme Court had a task force a number of years ago about the death penalty, not whether we should get rid of it, but just ways to, reform it. And that was one of the suggestions, was to have the state PDs or some central committee do the appointments instead of the judge that is presiding over the trial. And of course, all the judges oppose that, because again, here's my lawyer that I appoint to cases, and then that lawyer is contributing to my campaign contribution. And remember, those judges also have an incentive to appear tough on crime when they're up for their re-election campaigns. We talked about a little bit some states where you don't have to have unanimous juries. There were some states that had a system called judicial override. So even if a jury unanimously would say, we think a life sentence is appropriate. Unlike in Ohio, where I said like one juror can prevent it, any vote at all, not for a death sentence, in some jurisdictions, a judge could override that and impose a death sentence on top, despite the jury's recommendation. And wouldn't you know it, that in election years, the number of times when judges are doing that override spikes, right? It's just like so obvious the way that like factors that are not supposed to influence this, like race and politics, do.
It's almost like they don't want us to win.
It almost is.
Yeah, it's weird.
I think we're about ready to start questions unless any of you all have I forgot to ask you anything. I would have been a good thing for me to ask you. Otherwise,
I'll just, it's almost like they want us not to win. I do like to say no matter what we do, it's wrong. Sometimes it's like, should we file this, a post-conviction motion or a motion for new trial? And like, no matter what we choose, like it's going to be wrong and held against us. And, something that I was reflecting on earlier, I think Professor Klein was, who was it? Professor Berger was saying that, the deference that is given is not necessarily appropriate, right, to these states that are coming up with lethal injection protocols. I mean, that's the name of the game in federal habeas under that EDPA law I mentioned, is it's extreme deference. Like, to get relief, you not only have to show that what the state court decided was wrong, it was unreasonably wrong. And the Supreme Court has said that literally means that no fair-minded jurist could have decided this way, which, like, by definition, a number of jurists in the state court have decided that way. So it's like almost an impossible standard to meet. And it's just like so, and I also think that is undeserved deference because of things I've just mentioned, because of the, the pressures to like be tough on crime and this messed up incentives and all that kind of thing. And it's just so interesting, like in lethal injection, the burden is on the plaintiffs to show this suffering, or the ratcheted up, risk of harm. But here's what would happen. In Ohio, they'd have an execution, they'd mess it up in some way. Well, then they'd change the protocol. So when we would go to challenge it then, we couldn't rely on them botching the last execution because that was a different protocol. Now we have a new protocol and you don't have evidence of what would happen with this new protocol that's different, right? So we're never gonna have evidence because obviously you can't do an experiment and show what's gonna happen. So then burden of proof on us, we lose, right? But somehow, in shaken baby cases, the state gets away with saying, well, obviously we could never do experiments of like shaking real children, so like you can't expect us to have the scientific proof. And it's like, but you have the burden of proof, so if you can't prove it, like you should have to have it. And I don't know why, in those cases, the state is somehow allowed to win, even though they admit that they can't do the very thing that, like, when we can't do it in lethal injection, it's held against us.
I will say one of the things I really agree with Dale about too is the litigation strategy, because I was a big fan of, I'm always really, really happy to litigate over anything that does not involve whether or not my client killed somebody, right? Any other topic I'm happy to spend a lot of time on. And what I found is when you start to do that, and then the other side, they get desperate to win, and then they will start to color outside the lines or cheat. Then the harder they try sometimes, the more mistakes they make. Right? And the more they try, and you're like, this is what the rule is supposed to be, and they're like, well, we're not going to follow that rule anymore. They make more mistakes, and then you get them on the ropes a little bit, and I think you end up sometimes popping things out you never expected sometimes. So even as ridiculous as it is, and they keep changing the rules, forcing them to do that repeatedly causes so much embarrassment that sometimes they stop, and you win. So you never know unless you try.
About questions? I think you got a few.
This is such an incredible quartet of people. I just am in awe of the trial and post-conviction experiences and accomplishments at that table. And Dave, thank you for hiring me in 2000. But I have a question for Dale with regard to Tony, and Godspeed to Tony. What you described is, just a panopticon. It's horrible. If he got a new trial with the DNA, and forgive me if you were specific in the facts, but would the state likely claim that the DNA is not dispositive on the facts? And then I want to thank Mr. Hunter. Thank you so much, absolutely, for being here and sharing with us. So, thank you.
I am guessing that the state would not take it to trial because when we were before the state Supreme Court, the state made an offer, plead guilty and we'll give you life without parole. And that was a non-starter. So I don't think the state has the evidence now to go to trial. It's been 41 years.
Aaron, I had kind of a two-part question for you. So, one of the things that I was wondering is, in Mr. Hunter's case, did you have any sense why, after all this evidence came out, the state wouldn't just relent and say, you know what, we got it wrong? I mean, was it pride? Was it not wanting to have egg on the face or something? And then the second part of the question is, you were mentioning sort of the incestuous relationship that can exist between like law enforcement, prosecutors, coroners, and how there was this unheard of effort to basically generate a supplemental autopsy report to defend, the recanted report of the original pathologist. Are you allowed to expose that? If it goes back to trial, are you allowed to take this monkey business and put it out there so people can see what's going on?
Oh yeah, and we would have. And that's the thing. The truth was on our side, right? And we should have been able to go to trial and show all this BS. But Lamont's life is hanging in the balance, right? And first of all, the worst thing actually would be he doesn't get back to death row. He just gets some kind of life sentence, a term of years, and then he doesn't have access to the right to counsel. Yeah.
And it's so unfair. I'm sorry, Aaron.
It's okay.
I just had to say that.
Yeah, why didn't they? I think this particular prosecutor has been involved he's involved in my other client who got a new trial 6 months before Lamont, where he, massive Brady violations. They withheld almost 4,000 pages of investigative material. He just said, he's like, well, I think Lamont's a monster. And I'm like, well, you don't know anything. You've never talked to him. And I just think that there's the hubris there. When he said back in chambers, we'll retry him, the judge was like, even on the rape? He was like, have you read this deposition? And he's like, yes. And he's like, well, okay. So I don't know if they care or not about the compensation aspect. It's not like it's coming out of their pockets. Like I said, my other client had gotten this new trial, and then a few weeks after that, a non-capital client had gotten a new trial from the bench for another Brady violation. Then we have Lamont. Hamilton County, Ohio is having some bad press recently. So, I think they wanted to minimize it. But I just think they did it because they could, and then as Lamont mentioned, he still might not have been retried today if we, because right away he was just like, well, I won't be able to go to trial at least for, another, I can't remember, something like that, right? And then they always and you don't have speedy trial rights when you get post-conviction relief. So we couldn't do anything to force it. And, right.
Getting out.
Right. So I just think they did it because they could. and they're jerks. And yeah, I mean, we do, we gave a talk at another law school where my whole topic was about this, undue influence of having the, crime labs in coroner's office. And I mean, this ridiculousness, the coroners would not speak to a member of the defense team without a prosecutor present. They would not even provide us this supplemental report, which is a public record. It had to go through the prosecutors. And the supplement, it was 4 sentences. And they got a continuance on Lamont's bond hearing for them to do this. And because of that, Lamont missed his daughter, Trinity's, high school graduation. She was 9 months old when he was arrested. And so he missed her whole friggin' life. And we were trying to get him out to be able to see her graduate. And he got a continuance the day before that bond hearing. He said, oh, well, we found out, that they didn't have these records. Well, you knew they didn't have these records since we filed our motion for new trial 9 months before. Yeah, that you've joined, exactly. So it was just nasty. And so they review these records, they provide no reasoning, no citations, absolutely nothing. And then when we're finally having a Zoom with them, with the prosecutors present, here's just one example. There's these things about retinal hemorrhages, bleeding in the back of your eyes. That's one of the signs, supposedly, of abuse. But they have to admit that a zillion and one things can cause retinal hemorrhaging. Number one, brain swelling, and being intubated, having coagulopathy, having CPR, all the things that happens to someone. And so the child abuse pediatrician says, oh, yes, I know, but the size and scope of the retinal hemorrhaging in Trustin, that's what was different. And so that's how I know it was abuse. And I said, do you have any literature supporting that? And she said, well, sure. And I said, could you have your attorney provide it to us? And of course they never did. And so one of the pathologists said something about that too. I said, well, could you talk to me about that? Because Dr. Makaroff never gave that to me, and my expert says that doesn't exist. So what are you talking about that supports this idea? And she said, well, first she started to say, I wouldn't want to give it to you because you'd basically rip it apart. But then she kind of stopped herself and finally said, well, I wouldn't want to do your work for you. You're supposed to be a scientist who's neutral, and you're so clearly on their team. So anyway, I'm sorry I'm getting worked up about all of this, but it's ridiculous.
Anybody have a question for somebody besides Aaron? So she can calm down for a minute. Yeah, we got a question here and back there. Whoever.
Thank you all so much for being here. As an aspiring public defender myself, this actually is a segue from the last question and the last comment that you made. Just speaking practically and then existentially, practically, how do you work within a system that seems so bent towards injustice? How do you work with prosecutors? How do you work with lower trial attorneys? How do you work with judges who seem bent against your clients in a system that's supposed to maintain professionality? And then existentially, how do you keep doing this work when it seems like it's just loss, after tragedy, after trauma, compounding? Of course, Mr. Hunter's stories are glimpses of light in this, but I'm sure they're few and far between. So yeah, practically, existentially, how do you do it?
I struggled, as a lawyer. I never thought I would do capital defense for as long as I did. I thought I'd do it for a few years and I'd go back out. And then when I did it, it started to mean so much to me, but it was hard because I would always feel like there's always something else you can do, right? There's always some more work, some more research, some more writing, some more investigation. And I would feel guilty if I was home on a Sunday night watching TV, that I should be doing something because my client might die if I don't do this. And that was hard, and it can burn you out very quickly. And what I eventually learned, and I think another colleague had sort of shared this with me and really resonated, which is I am not the injustice that my client experiences. And on the list of people who are responsible for whether or not my client lives or dies, my job is to make sure my name is at the bottom of the list, right? There are a lot of other people who are more responsible, the judge, the prosecutor, so many people in our system. And as long as I am working to keep my name at the bottom, that I'm the person who's always trying to be on their side and advocate for them, then that's kind of the best I can do. And it's what I have to do because the system is unjust and it doesn't want me to win. And I'm going to do my best to try to make it that better, but I can't. All I can do is try to influence it to be better. I say to folks, the worst thing about being a criminal defense lawyer is I don't get a vote. right? So lots of things happen to my clients, and I don't get any control over that, over whether they get acquitted or not, or what their sentence is, and that injustice that happens. So it's the worst thing. The best thing about being a criminal defense lawyer is I don't get a vote, okay? Because I'm also not responsible for that thing that happened to them, right? That injustice that happened to them. I can say I'm the person who stood up and said mercy for them is what they deserve. I'm the person who said they need justice, they need due process. And I was the one who did that the whole time, and I'm not responsible when they went and violated all of that person's rights because I tried to prevent it.
I agree with everything that was said, but I will add that I try not to demonize my opponent or the judge. When I was a younger lawyer, I did that, and it just zapped a lot of energy. I want my energy to focus in on the case, and I want to try and have cordial, professional relationships with my opponent. That goes a long way when you need a continuance or some other favor, but that has made me a bit more sane.
As I think you can tell, I'm pretty passionate about this. So, I find all this like craziness, this bonkers stuff, like really motivating. So I think you could, sure, like, is the lawlessness like pretty demoralizing sometimes? Absolutely. But also it's like, it makes me want to point it out, shine a light on it, like tell other people about it, And so I just think it needs people like putting their hardest into it because it's so messed up. You know what I mean? At a conference a long time ago, someone mentioned a phrase that critical care nurses have, which is that when the patient arrives, they're already dead because things are so bad that like you sort of can't make it worse. And that's kind of true. Like, think about how many bad things have happened, like how many losses a client has suffered by the time that they've come to me in federal habeas. Now, like, especially if they're not innocent, like, the innocence cases, like, those are the ones that keep you up at night. But that's there's a sort of freedom to just be like, let's try something new, let's do whatever, because like what's happened before doesn't work. So it can't get any worse than it already is, So I think there's that freedom. And as far as kind of like, existentially and like personally, I heard someone say this during the pandemic, and it's the hardest thing, but I think it's the most important. Instead of saying, have you worked enough to rest? You have a responsibility to bring your best self to work. So it's really, have you rested enough to work? Right? Like, you can tell when you're too tired, you're too hungry, you have a headache, you're just burned out, and you're not bringing your best self. And that's just as much as me keeping up on the case law and having like my law degree and all that and reading the record and stuff, me being the best, person that can digest things and advocate and like be at my top performance is part of my job. And so I try to remember that when I want to, be working on a Sunday night and ignoring my family and stuff like that, that like part of my job is also to have the balance in my life so that I can be the best lawyer I can be, which means being the best person I can be too.
I just wanted to add a little gloss to the answer about what you expect from defense attorneys when you do a habeas case. I had a capital habeas case in which defense counsel's first response was not to file an affidavit, but rather to deliver his entire file to the Attorney General, even before the habeas petition was filed. So the Attorney General ultimately claimed that they hadn't opened it and haven't looked at it, whatever, maybe. And the client insisted then on filing a ethics complaint, imagine that, against the defense attorney. They ordered a hearing at which I was called to testify, and they confronted me with a presentation I had made in which I had said that claims of ineffective assistance of counsel are inevitable in a capital habeas case, no mystery there, and that therefore since he knew that an IAC claim was coming, the suggestion was that it was okay for him to deliver the file. Now, of course, what the state statute, habeas statute in Virginia actually says is that you waive the attorney-client privilege to the extent necessary to respond to the allegations in the complaint of ineffective assistance of counsel. And of course, he didn't know what the claims were because the habeas petition hadn't been filed yet. The Virginia State Bar dismissed the ethics complaint. So they thought there was nothing wrong with his having turned his entire file over to the Attorney General.
So this is kind of a follow-up question. Dale, I heard what you said about needing to play nicely in the sandbox, but similar to what we just heard, what are some of the other ethics or bar complaints that you're hearing?
I mean, there's all kinds of bar complaints about prosecutorial misconduct and Brady violation. I mentioned my other client, Elwood Jones. If you like podcasts, the whole 4th season of the podcast Accused is about his case. He spent 27 years on Ohio's death row. He got a new trial 6 months before Lamont, but he's still on home confinement because his case is currently at the Ohio Supreme Court. It was argued in February. In that case, the elected county prosecutor, Joe Dieters, who is now Justice Dieters on our Supreme Court, was, after our evidentiary hearing, going on like talk radio shows, like talking trash about the case, about how this black liberal democratic judge was gonna like let him free, how he's a monster, he'd kill your grandma, like we don't need him on our streets, like. Well, that's what Seth, the prosecutor, at his bond hearing, he said he's 70 years old, he's got a lot of crime left in him. That's the lying prosecutor that he shared with Lamont, but this is the elected prosecutor. And then the day that we won the new trial, he held a press conference at the courthouse. Clearly unethical behavior, and nothing comes of it, at least in Ohio, so.
In Arizona, and I haven't had direct experience with this, but the state bar is pretty good at monitoring the prosecutors. They have disbarred a number of prosecutors for their actions in death penalty cases. There's a line, and when it's crossed, at least the bar in Arizona will act.
In Virginia, the dean of the prosecutor's capital murder bar was a guy named Paul Ebert, and he was an elected Commonwealth attorney in Prince William County, and he was very successful in getting the death penalty all the time. And in one case in particular, for a guy named Justin Wolf, in what was alleged to have been a murder for hire, they had a death sentence. And then there were innocence claims that came out. It turned out the person who claimed that Justin had hired him to do a drug killing recanted his story and came forward to give an affidavit saying he was recanting. And so Justin Wolf was given, and it turns out that in fact this person had given an inconsistent statement to the police when he was being arrested, because they told him, the police said, if you tell us that Justin did it, then you won't face the death penalty yourself. And so that's what he did, and that statement had not been turned over to the defense before the first trial. So Justin gets a new trial, and it come to find out, of course, that prosecutor Paul Ebert and his office had suppressed that statement. And then he's coming back for a new trial, and the prosecutors, Paul Ebert, then go and meet with this cooperator, again, who's now previously recanted, and said, oh, since you've recanted, we're going to seek the death penalty against you again now, if that's going to continue to be your story. And if you're going to testify for him that he didn't do it. And so, of course, this person then says, well, I'm not saying anything anymore then, right? And becomes unavailable to Justin at that. And then the prosecutors withdrew because they handpicked who would take over the prosecution for them in the next county over as the prosecutors that way. And so despite having clearly hidden evidence, going back and tampering to coerce to prevent that from happening and everything else, they were never prosecuted by the bar in a significant way. And in fact, there is currently still an award that is given for the best prosecutor in the state every year in the name of, Paul Ebert. They in fact have named, I think they named like the library at the courthouse or something for him now.
And he was elected for 56 years.
Yeah.
56.
Yeah. Mm-hmm. Yeah. Yeah, he was the deadliest person in Virginia history ever as a prosecutor, yeah.
Well, first off, thanks for being here with us today. Really appreciate it. I was wondering now that, federal prosecutors are going to be seeking the death penalty again under this new administration. What are the differences in death penalty litigation between the federal and state system? And do federal defendants who are at risk of the death penalty have advantages versus state defendants?
So I've had to switch, right? After we abolished the death penalty in Virginia in state court, I do a lot more federal stuff now. We still have the death penalty in federal court, and so I am still defending some death penalty cases in Virginia, just in federal court. It's a very different way of approaching things because we heard us talk before about how sometimes you could bankrupt a jurisdiction maybe with funding, or, if I could overwhelm a local prosecutor's office with my motions practice, right? I could outwork them. I can't do that as easily with the federal government. They have all the resources. And frankly, the prosecutors who are handling the case don't have any discretion. They get told by people above them what they're going to do, who have no skin in the game. And so what we've seen now is I currently have a case where one of the processes in federal court is, in order to get the death penalty, the Attorney General has to authorize it. And so I have a client who, Merrick Garland and the Biden administration said, we're not seeking death in the case. Now, once that decision has been made, there is no provision in the law for it to be unmade. And it has never happened before. But now, with the new administration, they are revisiting all of those decisions, and they are now reversing those what we call no-seek decisions to now try to seek the death penalty in cases where a decision had been made not to seek it that way. And that's being made at the Attorney General level, well above everyone else, and it's told then, several levels down to the prosecutors, now you have to prosecute for death, and you have no choice. You can't plea bargain the case, you can't work it out. It's a very different process, and then they have a ton of resources, the entire FBI, and they can really outwork folks in a much different way there.
The judge let them reverse the no-seek?
Oh yeah, it's happening all over the country. I mean, I'm still waiting for the decision where they're going to reverse mine.
They didn't let us.
But they have reversed some no-seek decisions, and then some have been struck. But there are some yet that haven't made it through the litigation yet. But it's coming. So we're going to be having all these fights over that.
The one thing that in federal death penalty, as Doug mentioned, the authorization, there is a formal process where the defense team makes a presentation to try and get it deauthorized. And so, a lot of times it's mitigation workup, and you basically say, like, we're going to go through this whole trial, and at the end, we think we can convince the jury not, to give him a death sentence. And so that's often how they become deauthorized. And there's no, it's certainly not true in every state. I'm not aware of a state that has that sort of like formal opportunity. You might be trying to do it like pretrial negotiations like that, but it's not as formalized as it is in the federal system.
I think we got time for maybe one more question, unless we've exhausted them. Oh, got a repeater.
Aaron, the statute that you mentioned that's limited to DNA evidence, have there been any moves to expand that to other tests?
I'm not aware of that. No. I will say that, like, ironically, in Hamilton County, actually in Elwood Jones's case, the prosecutor there did agree, and so we were able to get fingerprints in his case run through. So just another example of like the arbitrariness of like, geography. It so depends on, like the willingness of the people that you're working for. Again, like the state and the prosecutors have like all the power.
On that DNA legislation in Ohio, a legislator has introduced a bill every year to expand the statute, and she also said it should be applied retroactively, but of course the prosecutors are fighting her on that. And in fact, it was reintroduced, I think, on Wednesday.
I just want to say before we're done again how much I appreciate and how proud I am of the law review for putting this on. As someone who and seeing all the students here. 30 years ago, I was here in editor on law review, just like this, when we still do these symposiums. And I only say that to say it's really, I want the students here to know that you can make a difference with what you do, right? In the 30 years that I've been practicing law, we have now abolished the death penalty in Virginia, right? And we've had those numbers drop off because of students who turned into lawyers, who learned to advocate really well. And I'm just, clearly the standards of law review have gotten much higher now than they were when I was on them. But it makes me feel so great to know that there's this next generation of people who are still going to fight these battles. And thank you for listening to me.
I also, can I just say real quickly, you can make a difference even if you don't become a public defender or a criminal defense attorney. I work with the law student externs in my office, and, if you are a federal public defender like I am, unless I get permission, I did get permission in Lamont's case to go into state court to represent him, but otherwise, like in Elwood Jones's case, I have to recruit people to represent him. Otherwise, I'm relying on the state court judge to appoint his, lackeys to do it. So a lot of times I'm turning to my former law students who are at firms and asking if they can help us out in a pro bono capacity. So, just because you don't go into criminal defense as your main job, keep in touch with your classmates who do and offer to, help them in, maybe working. You'll do a ton of expert, work if you're at a big firm, right? And so you learn how to do those depositions and how to write expert reports, and, maybe you can help out with something like that, or maybe you can help, a federal attorney do something in state court. So, just because you don't do it as your primary work doesn't mean that you can't assist in some way in helping people in the criminal legal system.
Okay, well, I was here 43 years ago and was nowhere near the law review. But nonetheless, so that's not a prerequisite. I want to thank our panel so much. And a couple things. If you'd like a card, grab it during the break, and please stick around for afterwards. For a lot of us here, Stephen Bright's been a role model for a long time, and we're really looking forward to hearing from him. Thank you.
My name is C.T. Smith, and I am Volume 60's annual survey editor. And we are going to take a 15-minute break before our keynote speaker. Thank you.
Hi, everyone. It is my absolute honor to introduce our keynote speaker, Professor Stephen Bright. Professor Bright has devoted his career to representing people facing the death penalty, advocating for the right to counsel for poor defendants, and challenging inhumane prison conditions. For nearly 35 years, he led the Southern Center for Human Rights in Atlanta, serving first as director, then as president and senior counsel. He has taught at Yale Law School since 1993 and at Georgetown Law Center since 2017. Over the course of his career, he has argued and won cases before the U.S. Supreme Court, represented countless individuals facing the death penalty, and shaped generations of advocates. His work has been featured in books, films, and Bryan Stevenson's Just Mercy, where Stevenson wrote that he, quote, spent the first year of his legal career sleeping on Steve Bright's couch. Please join me in welcoming Professor Stephen Bright.
Thank you, Anna, and good afternoon, and thanks to all of you who stayed this long. I appreciate it. I want to thank Anna, Caleb, and all of those of you that are on the Law Review. What a great job you've done. What a great job the Law Review people have done. And I expect Professor Lane was maybe a bit of an inspiration, or maybe some help along the way. And what a tremendous... 10 years ago, I was invited here to this law school to speak at a symposium on the death penalty. At that time, Virginia was second only to Texas in terms of the number of executions in the modern history of the death penalty. Now I come back 10 years later and Virginia doesn't have the death penalty. And it seems to be doing just as well as ever. Now I want to tell you, it's not the only example. Michigan did away with the death penalty in 1846, and it's done quite well ever since that time. Without the death penalty. But I thought what I'd do just to wrap up today is just talk a little bit about where we've been with the death penalty, where we are, and where I think we're going in terms of the death penalty and this notion of advancing abolition in this time. It wasn't that long ago if I can get it to work, we were at the end of the first Trump administration and we had 13 federal executions. It was really quite remarkable. There hadn't been a federal execution in 17 years and only 3 in the previous 57 years. No president had presided over as many executions since Grover Cleveland in the 1800s. It was a remarkable time. 22 stays of executions were vacated to clear the decks for 13 executions, all 13. Granted by lower courts, granted by courts of appeals. Those of us who had some hope that the 6 members of the Supreme Court might make sure the rule of law applied and there were some guardrails, forget that. There were not even explanations for why the court did what it did. 2 people executed despite questions of whether they were mentally competent to be executed or not. One was flirtily psychotic at the time. Another executed despite questions of whether intellectually disabled or not. Other questions about the way in which the executions, you heard some about that earlier. All this done in the midst of the COVID pandemic. The executions were a super spreader. It didn't matter. Went right ahead with those executions despite all that. The Supreme Court even granted certiorari before judgment, a procedure that's an extraordinarily rare procedure only to be employed when there are issues of great public importance. A case that was set for argument before the Fourth Circuit. And the court grants certiorari before judgment, vacates the case, orders the execution, and we all know why. 5 days later, Joe Biden was going to take office. And so the Supreme Court did what it had to do to make sure that that 13th execution took place before Donald Trump left office. And then, just 2 months later, on March 24th, 2021, Virginia repeals the death penalty. When they called me and said Virginia might repeal the death penalty, I said, you call the wrong person, the wrong country, and the wrong guy. Here's Virginia, a slave state. Virginia, and that's important. We heard about that earlier, right? The death penalty was maintained in the South because you had slaves. And then Virginia was a 50-50 population, so you had to have the death penalty for all sorts of trivial offenses. The northern states, as I said, Michigan, Wisconsin, Rhode Island, they've all done away with the death penalty before the Civil War. Other states have restricted it only to homicide cases, but not the slave states, because it's absolutely indispensable to maintaining slavery. And I'll come back to that. But a few months later, Joe Biden declares or commutes, not a few months later, just a few months ago, President Biden commuted 37 death sentences, 37 of the 40 people on the federal death row. And then a month later, we're back to another Trump administration, another Trump Attorney General, Pam Bondi, and now we're hearing about the president and the Attorney General putting out statements saying we have to have the federal government carrying out, as you heard Doug talking about a moment ago, encouraging the states to carry out, encouraging the states to seek the death penalty against the people that President Biden had commuted, asking for the death penalty in Washington, D.C. Good luck with that. I don't know if they did the research, but, there was a referendum in Washington. Now, it's changed a little bit, but overwhelmingly, people voted against the death penalty for Washington, D.C. They've asked for the death penalty for crimes that aren't even punishable by death. And Trump has called this an essential tool for punishment and deterrence. How can it be an essential tool when half the states don't even have it? It's confined to a few places I'll talk about. But I want to talk about one other thing. Just a month and a half before the election, the execution chamber in Washington, the state of Washington, was closed. It had been opened in 1904. They had 78 executions. And you can see the value of that as a great public process, right? Over 100 years, you have 78 executions. But in Washington, in the state of Washington, 10 years before this, Governor Jay Inslee had declared a moratorium on the death penalty. In 2018, the Washington Supreme Court, applying the Washington Constitution and looking at the racial disparities, at the geographic disparities, at the arbitrariness, declared the death penalty unconstitutional under the Washington Constitution, under the state constitution, as some other states have done. And then in 2023, the legislature in Washington repealed the death penalty, and now the execution chamber there in Walla Walla has become, there it is, has become a museum. There's a former King County prosecutor, in fact, who prosecuted the last case, got the last death case, and watched the person be executed. He said, "We're keeping this because it was a failed criminal justice experiment. We're better than that. We moved past that." Washington is one of 23, one time, 38 states in this modern history of the death penalty, since the death penalty was brought back, as you heard about in the first panel this morning. At one time, 38 states had the death penalty, now just 27. And of those 27, 2 of them, Oregon and Wyoming, don't have a single person on death row. And many of the others have not sentenced anyone to death or carried out an execution in the last 10 years. And 2 others, California and Pennsylvania, both have moratorium. Governor Wolf in Pennsylvania for 8 years that he was governor, now Governor Shapiro has not only called or continued the moratorium in Pennsylvania, he's called for repeal of the death penalty statute in Pennsylvania. So again, how essential is this when we see that half the country is not using it? And so where are we? Where have we been and where are we going, as I said? In the 1980s and 90s, when I got into this work, and people were being sentenced to death right after the Supreme Court had upheld in 1976 the return of the death penalty. It had been declared unconstitutional in Furman versus Georgia, but it came roaring back. And now states were sentencing people to death. And we see that, I can't get my charts right. In the 1980s and 1990s, 290, 315 people being sentenced to death every year. We got to a high of 315 in 1996. Last year, 26 people. We went from 315 people to 26 last year, and less than that in the years right before that. And we've seen the same pattern with executions. Of course, it took a while because all those people had to be sentenced to death, and so executions started going up in the 1990s. We get up to a high of 98 in 1999, and then as you can see, we've seen a steady decline since 2000. And if you look at what's going on, it's the same states. We've had 5 states executed 24 people in 2023, and then 9 states, a few more, executed 25 last year. Look, it's the same states. Alabama, Texas, Oklahoma, Missouri, same states. And then a few that haven't executed anybody in a long time and then come back, like Indiana, which only has a few people on death row. Utah, which we've heard talking about Utah, they've carried out 8 executions. They've got 6 people on death row. You know, Utah carried out the very first execution after the Supreme Court said, you don't see much death penalty in Utah. And so, yes, there are going to be more this year. Florida, you know, in Virginia, when the courts finally upheld your death sentence, the attorneys general ran back to the judge and got a date, and they executed you just like that. And almost every time, 113 people. In Georgia, the same thing. Alabama, everywhere where I've been. That's not what happens in Florida. Florida, you go through the courts and you go back to death row, and then you hope the governor doesn't sign a death warrant. And there are a lot of people eligible, been all the way through state and federal court. They've got nowhere else to go. I had a friend of mine last year, I had a client, DeSantis signed a date, judges stayed it. This guy's been on death row a long time, but Hadn't been signed on this year. So yes, there are going to be more executions. Florida's executed 13 so far. I think there are 2 or 3 more in the pipeline. But still, I don't care how many executions we have. Let's say we have 40, that much. It's nothing like the 1980s and the 1990s. But at one time, Texas executed 40 or more a year all by itself, one state. And of course, the overwhelming majority of these have been in the South. 80%, 82% of the executions have been in the South. There's no death penalty in New England. There really isn't much death penalty anywhere else in the country when you really look at it. And of those in the South, of course, most are in Texas, 600. Texas is right about to break 600. Next time it carries out a few more executions. Virginia, even today, is one of only 5 states that have executed over 100 people since 1976. Texas by far the most. Oklahoma and Florida have both moved past Virginia now with executions. Missouri has now joined the club. They got 101, but Missouri only has 8 people left. They're like Virginia. You remember Doug was talking about here, Virginia only had 2 people left when they finally repealed. Missouri has 8 people left on its death row. Somebody told me 6, so I may be wrong, but 6 or 8, they don't have very many. Oklahoma, which is in second place here, Oklahoma only has 30 left. So a lot of people were sentenced to death a long time ago. Those people are being executed, but there's nobody else to execute once they're gone. Now, you may look at this chart and say, wait a minute, one of those is not a state, right? Harris County is not a state. How can it be that one county, Houston, has executed more people than any state except Texas itself? Well, the reason there is the reason in a lot of places. This is the main reason. Johnny Holmes, district attorney in Houston, almost 10 death sentences a year. If you were facing the death penalty in Harris County, Johnny Holmes went for the death penalty. There wasn't any plea bargaining, there wasn't anything, and got the death penalty. But that's only 1/3 of the equation. And I'd say this real quickly, even with all the executions it has, 135, there's still 33 people from Harris County on death row in Texas. It would be the 8th largest death row in the country, larger than a lot of states. But as I said, that's only 1/3 of the equation. Here's the other 2/3. This fella here, Jerome Godnich, is a really bad lawyer who represents a lot of people in criminal cases in Houston. And you can see just from this one example why that is. He gave $9,000 to Jim Wallace when Jim Wallace ran for judge. This is what people do in Houston. And then when Jim Wallace got elected judge, he appointed Jerome Godnich to almost 2,000 cases, including 5 death penalty cases. This is a lawyer who years ago missed the statute of limitation on 2 federal habeas corpus cases. His clients got no review in the federal courts at all because his lawyer couldn't file his papers on time. Now, in a lot of places like Virginia, people got bad lawyers because the lawyers weren't paid anything at all. But in Houston, remarkably to me, they pay people a lot of money to do a terrible job. And terrible they have been. I mean, 3 people sentenced to death in Houston were represented by lawyers who slept, defense lawyers who slept during the trial. Joe Frank-Cannon represented 2 of them. John Ben represented the other. A guy named George McFarland, a reporter from the Houston Chronicle, comes into court and says, in yesterday's death penalty trial, the defense lawyer kept falling asleep. And he would even snore. And every so often he would wake up. And every time he woke up, there was a different witness testifying against his client, George McFarland. And this reporter said to the lawyer, how can you sleep when you're representing a man in a capital murder case? John Ben said, it's boring. And then the lawyer asked the judge, Doug Schaefer, who's the presiding criminal judge in Harris County, how can you preside? That was my question. How can you preside over a case where the lawyer is sleeping? And Judge Schaefer said, well, the Constitution guarantees your right to a lawyer, but there's no guarantee that the lawyer has to be awake. Now, that's a strict constructionalist, if ever there was one. But one of Joe Cannon's clients, Carl Johnson's been executed, even though the lawyer slept. George McFarland's case has been upheld by both the Texas courts and the federal courts, and he's in the queue to be executed in the next year by the state of Texas. The one person who got relief was Calvin Burdine, and the only reason he gets relief, Cannon was the only lawyer. His trial only took 2 days, and Cannon slept through a lot of the trial. And when the case goes to the Court of Appeals en banc, because the panel upheld this, it goes en banc to the Fifth Circuit, and the Fifth Circuit judges are saying, well, how do we know he slept during any important part of the trial? That's, as a lawyer, I have to say, I thought that was an all-time low in my legal career, to see judges, life tenure federal judges, saying, how do you know he slept during an important part of the trial? The state of Texas said, well, you can uphold this death sentence even though Cannon slept, because you've upheld cases where the lawyers have been under the influence of alcohol, one where he was under the influence of drugs, one even where the lawyer had Alzheimer's. You know what the difference is? What the en banc court said, it was a bitterly divided court, but the majority court said, well, when you're asleep, you're unconscious. So you don't even know what's going on. When you're under the influence of alcohol or drugs, or even if you have Alzheimer's, I'm not sure if this is true, but they said, well, then you at least know what's going on. But if you're asleep, you're really absent. And since he was the only lawyer, Calvin Burdine gets a new trial. But the other two, there was some other lawyer where the judge had just appointed some second lawyer to sit there, second chair. This lawyer's not engaged in any way. Well, all I'm saying is it's not just aggressive prosecuting. It's judges willing to appoint these lawyers. It's lawyers like this that are getting appointed. And you had not only Harris County, we heard from Lamont Hunter just a little earlier about Cincinnati, Ohio, the same thing. Aggressive prosecutors, terrible judges, I'm sorry to say, but true, and incompetent, as you had at your trial, incompetent defendants. Same thing in Philadelphia. You had Ron Castile was the DA there, sought the death penalty a lot. You had Lynn Abraham, who was known as the deadliest DA during the time she was the district attorney there. You had since the Philadelphia Inquirer wrote an article about the lawyers appointed by the judges in Philadelphia. They said people in the system wouldn't want to be represented in traffic court by the lawyers appointed in death penalty cases in Philadelphia. So hundreds of people are sentenced to death. And that's why a lot of people in Ohio, out of Cincinnati, a lot of people in Philadelphia. But I'm going to tell you, let's start with the DAs. Johnny Holmes and people like that are dinosaurs. They're gone. They're not there anymore. Kim Ogg became the district attorney, served 8 years. She lost the last election, but she served 8 years as Harris County district attorney. When there was a question at the Supreme Court of the United States about whether a man named Bobby Moore was intellectually disabled and not eligible for the death penalty, and the Texas Court of Criminal Appeals said, that's right, he's not eligible. Kim Ogg said, oh, he is intellectually disabled. And the Supreme Court relied upon that. And then later, when a man named Dwayne Buck was sentenced to death in Houston after his lawyer called a psychologist who said Dwayne Buck was a future danger, was more likely to be a danger in the future because he was black. And Kimog said, no, we don't sentence people to death. This is after the Supreme Court reversed it, of course. But when the case comes back, no, we don't sentence people to death because they're black. And so that case was resolved with a plea bargain. In Philadelphia, of course, after Castile and after Len Abraham, Larry Krasner is elected district attorney. He's elected on a platform, we're not going to seek the death penalty. He's been in office 8 years now. He just won the primary. He's going to be in 4 more years. Never sought the death penalty. And I'm going to tell you, Philadelphia's getting along just fine without the death penalty. The homicide rate's declining. The crime rate's declining, just like everywhere else. But Philadelphia's getting along quite well without the death penalty. But the same thing is true with regard to the representation that people are provided. Dave Johnson contributed so much to building up the right to counsel in Virginia for public defender systems, for people to be represented at these 4 capital defender offices, and then making sure that they were funded when the legislature tried to take the funding away. And we went from a system where people were appointed local lawyers who had no idea what they were doing, didn't have the resources, didn't have the investigators, didn't have the mitigation specialists, didn't have the experts, to where we have people like Doug Ramasar, who are specializing, who have on staff mitigation specialists, who have investigators, who know what they're doing, who know how to select a jury in a capital case, for goodness sakes. And it's not just here in Virginia where we saw them shut down the death penalty here, did the same thing in Georgia. We don't have the death penalty in Georgia anymore because they're capital defenders. Same thing in South Carolina. And I can name other places where now, instead of having the judge appoint some hack who's going to come in and represent people and do a horrible job, now we have lawyers that this is what they do, and they're independent of the judges. In Georgia and Virginia, when this office was here, when you faced the death penalty, you went to the capital defender office. The judge didn't appoint his drinking buddy, his fishing buddy. I won't get into the other kind of buddies that might have been appointed, but as independent of the judges, they're not supposed to be managing the defense. That's something we got a long way to go in a lot of areas, but there's increasing recognition that the defense has to be independent. Let me say a couple of other things about where we are today. You heard earlier this afternoon about shaken baby syndrome. This is Robert Roberson. October 16th, Texas plans to execute him. He took his 2-year-old daughter to the hospital and she died. And the prosecutor said he shook the child and that's why she died. Same thing that Lamont Hunter was accused of. And he became a suspect because the people there at the hospital and the police people who came, they said he wasn't acting like a grieving father when they told him his daughter was dead. He was acting kind of odd and nonchalant, unemotional, detached, and uncaring. And the jury was told that. Said one reason, not only did they think the baby was shaken, and that's where he got the injuries, but that he was acting that way. Of course, nobody knew at the time of his trial that he was on the autism spectrum. Now we do. And now, of course, this shaken baby theory has been completely debunked. The Texas Court of Criminal Appeals in another case said, we're throwing it out, junk science, shaken baby, but not in this case. Well, Nikki actually died of severe pneumonia, which was exacerbated by improperly prescribed medications and so forth. The lead detective on the case now says this man's innocent. He said, I was wrong. I didn't know about the autism. I didn't know anything about shaken baby. I just took what they told me at the time. Well, if you're interested in it, Lester Holt, who was the anchor on NBC News, he's doing a podcast on Dateline starting Monday, a 4-part investigative series on this case called The Last Appeal. So I'm sure you can find it. I probably couldn't find it, but I'm sure you can find it. There are a lot of other examples. I'm going to come to my point in this in a minute. This is a fellow named Chris Barber. White guy, as you can see. He's on death row. He's been on death row 40 years now for murder of a black woman in Alabama. And years after the crime, this extraordinary work that the lawyers did in this case, as so often happens in this case, it turns out that the DNA shows that the semen recovered from the victim came from her 16-year-old next-door neighbor, African-American kid, who's now serving time for raping and killing another woman. And yet, even though Chief Judge Emily Marks, a Trump appointee, a Federalist Society member, United States District Judge for the Middle District of Alabama, has said that he is innocent, just like the attorneys general in Texas, the attorneys general in Alabama, doubling down on trying to bring about the execution of this man. And I just think back, I remember, talking about Ohio, I remember when Governor Taft, in one of the cases a long time ago, I think it was about 2013, he said, we don't know if this guy's innocent or not, but we're not so sure he's guilty that we're going to execute him. Of course, the best example is, of course, right here in Virginia, when Governor Wilder, faced with whether to allow a man named Earl Washington to be executed. He was an intellectually disabled man who had confessed to a crime he didn't do, couldn't even tell whether the victim was black or white. And again, it was, well, we don't quite know enough. We're not sure he's guilty, but we're not quite so sure we're going to let him be executed. And so Wilder said, I'm going to commute it for now. Of course, what happened later is there's more sophisticated DNA testing becomes available. Ultimately, he's completely exonerated, and actually they nail the guy who did it. It wasn't Earl Washington. And so, that's the risk you run when you execute people, when you've got the kind of doubts that there are in these cases and in other cases that are there. And I'm just going to say this. There's no death penalty in Illinois today because of innocence. There's no death penalty because the students at the journalism school kept showing that people sentenced to death were innocent. There was a guy named Anthony Porter who was right about to be executed, and they got a confession from the guy that actually did it. And George Ryan, who just been elected governor, he had supported the death penalty. He was a pharmacist from Kankakee, voted for the death penalty in the legislature. He got to be governor. He was going to let Porter get executed, and he said, wait a minute. We've killed 12 people, and we've had 13 exonerations. If you're flying on an airplane or an aircraft company that it crashes half the time, well, maybe not, really. And Governor Ryan did a remarkable study of the death penalty. The Chicago Tribune did a great series on the quality of the lawyers being appointed, on the science, on all kinds of prosecutorial and police misconduct that was going on, and ultimately Illinois repeals. First, Governor Ryan commuted every single sentence or pardoned, and then the legislature ultimately repeals the death penalty in Illinois. So if I were them, I'd think a little bit about what's going to happen. You've got Republican legislators in Texas that are arguing that Roberson is not guilty, but the Attorney General and the governor are absolutely determined to carry out this execution. We'll see what happens the next 2 weeks with regard to that. Of course, the real reason we shouldn't do it, and the real reason we shouldn't have the death penalty is because we can't. We're always going to have these questions in these cases. Over 200 people. You would think if ever there are cases where we try not to make a mistake, it'd be death penalty cases, and yet we have over 200 exonerations in death penalty cases. And we've had some people killed who, Todd Willingham in Texas, arson case, wasn't any arson in that case. Well, but it's not just guilt or innocence. Tuesday, Florida executed a fellow named Victor Tony Jones, intellectually disabled, should have never been eligible for the death penalty at all. And at his trial, the prosecutors argued that he had never been abused as a child, and in fact, one of the reasons he should get the death penalty is because he had squandered the opportunity to make the best out of himself with this home that the state of Florida had provided him when he was a child. But then last year, Florida's legislature recognized that that home, that reform school, the horrific abuse that had gone on there, the torture of children, sexual, physical, and other, and voted and even created a $20 million fund, and then sends Victor Troy Jones a letter. So sorry about your abuse. Of course, this is a different part of the Attorney General's office than the part that's trying to kill him. So sorry about your abuse. You're entitled to compensation. Even deposits money into his inmate account. Of course, once they put that together, the Attorney General's office quickly, scrambles to try to say, well, no, this doesn't really mean that just because we gave him some money, just because we wrote a letter saying we're sorry, it doesn't really mean he was abused. But childhood matters. Abuse matters. And we've learned over years of doing this work how much it matters, and how, when you have mitigation specialists and you have competent lawyers, how much it matters. And is the death penalty the way we respond to people who, through no fault of their own, have been subject to the most extraordinary and most heartbreaking abuse imaginable, and to those who, through no fault of their own, suffer from severe mental disorders? This is Andre Thomas. Texas wants to execute Andre Thomas this year. I've encountered a lot of mental illness in the work I've done, but I've never seen anybody quite as mentally ill as Andre Thomas. Usually the onset of schizophrenia is 18, 19, young adulthood. This young man was hearing voices when he was a child. Life of bizarre behavior. He married a woman who was white. They had a child together. They didn't last long. She leaves, has another child. The voice of God told him to kill his wife and the children. And he did, using different knives, stabbing each of them, then taking what he thought was their heart. One case was his lungs, but taking it off. And then stabbed himself to death, or tried to stab himself to death, but wasn't successful. So he's arrested. While he's in jail, he reads in his Bible that if your right eye offends you, you should pluck it out. And he gouges out his right eye. Many years later, while he's on death row, he gouges out his left eye and eats it. So he's completely blind. At his trial, the jurors are given questionnaires. And Andre Thomas is a black man. He's married to a white woman. And the juror questionnaire asked people if they had any feelings about interracial marriage. And 3 of the jurors who answered said yes. One juror said, I don't think God approves of it. My religion. The other 2 said, no, you should stay, you shouldn't be. The lawyers, the appointed lawyers, Sherman, Texas, they don't ask these jurors any questions. They don't ask them any questions. You're going to be in a case where the man is accused of killing his wife, who's white, and their interracial child. And these jurors are saying they don't approve of interracial marriage. And all 3 of these jurors serve on the jury that convicts him and condemns him to die. Maybe one of the reasons is because the prosecutor in closing argument says to the people on the jury, now, he married a white woman. You want to think about him getting out and maybe coming and seeing your daughter or your granddaughter? That was the closing argument in the case. This is what the race, what the death penalty is so much about, a matter of race, a matter of mental illness, incompetent representation, and other matters of concern we have coming down the pike. You know, the red state, some of the red state attorney generals, as somebody mentioned, I think earlier, trying to have the death penalty for non-homicide crimes. I mean, really, we only, even assuming we have 40 death sentences, we have 20,000 homicides, we sentence 40, we carry out 40 executions for that? Really? We're going to start giving the death penalty to people who don't commit homicides? Is that really where we want to go? Florida now, Governor DeSantis, oh, what an inventive man he is, can now be sentenced to death in Florida with a vote of 8-4. I don't think that's going to go too far. It didn't go anywhere yet. I remember in Georgia, we had a couple of times when we had jurors hang. In Georgia, if the jury wasn't unanimous, it's a life sentence. We had 2 or 3 cases where the jury hung 11-1. Guess what? Who the one was? The one African American on the jury who hung. And the governor and some of the legislators said, "Oh no, we've got to get rid of this. We've got to do like Louisiana or like some of the other states have done. We've got to go to non-unanimous juries." But I was surprised. A lot of people in the legislature, oh no, we're not going to go away with it. If the jury system is going to work, you got to have unanimity. The beauty of the jury is that everybody has the same amount of power. And nobody goes home until everybody goes home. But once you say 8-4, and of course Florida has done all this, they had majority vote before, and they had judge override and all these other kinds of things. Well, let me just say this in wrapping up here. I get a lot of inspiration, of course, by what's happened in Virginia, as I said earlier. A long time ago when I was teaching at the law school, one of my students was a reporter with a paper here called the Virginia Pilot, Norfolk, I think it is. And she gave me this picture, which is, they had taken pictures of people before they executed them in Virginia. And this was, I guess, they started doing it in 1908, and she gave me this in 1993. It's really striking, but if you can't quite see that, here's a little closer up. You look at it, it's like a Rorschach test of the death penalty in Virginia. Those people are all black. There are almost no white people in that picture. And it was really remarkable to me to see that. Virginia carried out the first execution, as somebody said earlier today, 1608. First execution in this country. From 1608 until today, Virginia's executed more people than any other state. Texas is going to catch up eventually, but they've still got a ways to go. And as I said, from 1982 until 2021, 113 executions, was second only to Texas. And then, and what a history. This is the Martinsville 7. These are people who were sentenced to death. They were all accused of rape or attempted rape, all tried close together, and all of them executed. In fact, every execution that Virginia carried out for a non-homicide crime, and in Virginia you could get the death penalty for rape, for attempted rape, for robbery, every single one was of a black person. Not a single white person on those. And then, whoa, we went all the way to the start again. Can you put me back where we were? In 1976 to 2000, underpaid lawyers getting appointed. And then in the 2000s, the capital defenders created, as you saw. They went from 2011 to 2021, not a single death sentence. 10 years in the state that's second only to Texas. 10 years. If you don't understand what the right to counsel, those students up here, if you don't understand what the right to counsel means, this is what the right to counsel means. That when you can deprive people of competent lawyers, you can sentence them to death, and you can't do quite as good as Texas, but Texas is a big state, and it really deprives people of lawyers. So and now you're providing people with lawyers, and we see that it makes a difference. And then Virginia repeals its death penalty law. So I think, we can look at Virginia, and we can look at its experience, and we can see all of the racism, the unfairness, the ugliness of the death penalty. And I don't know, it's not going to be in my lifetime, but it's going to be in your lifetime. That we're going to look at this and try to say, what kind of people are we? What are we doing? And consider with the better angels of our nature. And we will make permanent, absolute, and unequivocal the injunction, thou shalt not kill. Thank you.
We've got time for a couple of questions. So if anyone has questions, just go ahead and raise your hand. We'll bring the microphone around.
Steve, I know you've spent a lot of time arguing over racially discriminatory peremptory strikes and the use of them. Should we keep the peremptory strike system, or should we do some other way?
Oh my, what a controversial question, and a good one. One of the things I'm obsessed about is that all these years later, we still have all-white juries. And we still have all-white juries in communities with very substantial African-American populations. In the course I teach, I have a two-part thing called Part 1, History of the All-White Jury. Of course, right after the Civil War, you had Mississippi and other states, of course, didn't allow black people to be on the voter rolls. But even that wasn't good enough. It wasn't enough just to keep people off the voter rolls. You had a commission that decided who on the voter rolls could be in the jury, in the jury pool. And nobody made it. You know, the Norris versus Alabama, about 1935, Supreme Court looked at the juries in the Scottsboro case, no black people. They were saying that there were no qualified African-American people in that community who could sit on juries. And then the Supreme Court says, no, well, you can't just totally exclude everybody. So then there was token inclusion. Well, put 3 or 4 in. Not that they're ever going to be on the jury. And then Swain versus Alabama, just to cut to the chase, Talladega, Alabama trial in the early 1960s, Talladega's 25% African-American. Jury pool, 15%. So we see what's going on here. And then, of course, each side gets a certain amount. Those of you who haven't had this yet in school, each side gets a certain number of peremptory strikes. You strike theoretically for any reason. And in Talladega County, there had never been an African-American on a jury. And it's a 25% African-American community. And the Supreme Court, this case goes up right in the civil rights movement, right in the Warren Court, the so-called, criminal law revolution. And what does the Supreme Court do? It Robert Swain, this African-American 19-year-old, sentenced to death for the rape of a white woman, no murder case. This is a rape case. Back in those days, you could give the death penalty for that. And the Supreme Court opinion is a celebration of the peremptory strike. Isn't this great? That you can strike people for any reason. You can strike them for being Catholic or Negro or because they have blue eyes. That's right out of the Supreme Court opinion. Of course, nobody's getting struck because they have blue eyes. And Thurgood Marshall gets on the Supreme Court and starts firing off all these dissents and saying, you know, look what happened in this case in Mississippi, and look what happened in Illinois, and points out all these cases where all white juries are convicting people and mostly sentencing them to death. And so the Supreme Court, as you may have had in school, Batson versus Kentucky, says, well, now if the defense objects, and a lot of defense lawyers don't object because they don't want to alienate the judge, or they don't want to alienate the prosecutor, who maybe their fishing buddy, then the prosecutor gives reasons, and the judge decides whether they're race-neutral reasons or not. This is really, it's right up there with the thing about whether the lawyer missed any important part. We go through these fiascos where the prosecution strikes all the blacks and then gives all these ridiculous reasons, the trivial reasons. The person wouldn't maintain eye contact, they roll their eyes, or all these other kinds of things, and the judge upholds it. And you know, this is ruining the credibility. I argued a case, Snyder versus Louisiana, and I said in the brief, you know, the black people in Jefferson Parish, which is right over the river from New Orleans, I said, they know they're not a part of the criminal justice system. They're excluded every time. They're 15% of the population, never, ever on a jury. And so you know what? The white people know it too. It's a completely illegitimate system that we have here. But yet on it goes, and the Supreme Court has said that the reasons can be superstitious, they can be fanciful, whatever, and so we continue to have this. And then every now and then, you know, the truth comes out, or every now and then you have some prosecutor who didn't read the memo. You know, we had a case in Florida where the prosecutor said, well, I struck her because she's a young black woman and the defendant's a young black man. I said, well, that's sort of race, isn't it? But then he said, but I thought she was, quote, weak on the death penalty, when asked the death penalty question. That case was upheld by the Florida Supreme Court and by the 11th Circuit, a death penalty case. And that's how farcical this has become. And so what do? Arizona has done away with peremptory strikes. I didn't think anybody ever do that. Thurgood Marshall said, do away with peremptory strikes. I came to that conclusion too. I think the other answer to it, though, which I would point to Virginia for this, reduce the number of peremptory strikes. Because in Alabama, you bring in a bunch of people from the jury pool, and you qualify them who can't be there because they've got hardship or whatever, and then you divide by 2 and you strike until you've got a jury. And sometimes you have 20 some odd strikes. So there's a case in Selma, Alabama, in a majority black county in Alabama, tried by an all-white jury because the prosecutor was able, on strikes for cause and peremptory strikes, to get so many of the black people on the jury that he got an all-white jury. This is a majority black county. How can we possibly do that? So my solution, which not getting anywhere either, is to reduce the number to 3. I think that means the prosecution can get rid of the person they really think is not going to be fair. I think the defense can get rid of it by the same token. But I'm just, it's unfortunate. This is part of our democracy. And the juries have to reflect the community, and they don't. And this is a terrible tool. In those kind of cases, of course, I practiced in the Black Belt, where we have counties with 30, 40, 50, even, 55% black population. So a lot of people. But the more typical place is, 15 to 20%, like Jefferson Parish. In those places, you have 5 or 6 blacks in the jury pool, and the prosecution strikes them all. So.
Thank you so much. We've talked so much today about changing the cultural conversation around the death penalty, given how hostile the courts are currently. As the time you've spent doing death penalty research and scholarship over the decades, how would you say can we most effectively change that cultural conversation? What has been effective in the past in garnering empathy for people on death row?
Well, I think we've come a long way with regard to that. I think what's immensely challenging, I think you said, oh, you plan to be a public defender. Did you say that? Yeah. And, you know, what I have found immensely challenging, I've practiced law a little over 50 years now. And I think what's, you know, when we're dealing with crime, and we're dealing with really sometimes terrible crimes, and there are no getting around it, they're terrible crimes. And that has a tremendous influence. You never know what's going to be on the front page of the paper tomorrow, or wherever it is now in social media, whatever, that may, you know, the idea of the court system is we step back from the passions of the moment, and we try to be objective and fair and whatever. And sometimes we can do that, but a lot of times we can't. And but unfortunately, you know, one of the things I think is interesting about what Trump is trying to do with the crime debate now is he carries on about how terrible it is. You know, the statistics are all down. But if you've been carjacked, or if somebody in your family has been murdered, or some other terrible thing has happened, the statistics don't matter, you know. So you can play upon that. But I think the question is, you know, how do we really, as a society, respond to these things in a constructive and humane way? But that's really hard to do when you're caught up in the passions of the moment. And that's both true for what legislatures are doing. I mean, DeSantis, he's fanning the flames down there and all that, but it's also in the individual case. I mean, you know, the Utah doesn't get the death penalty very often, but, you know, that case, Charlie Kirk case is going to be an immensely high-profile case and all that, and so I don't know how it's going to come out, but it's going to be tough because of that.
Okay, I think this will be our last question for today. If anyone has one, if not, Professor Lane's got it. All right.
The pressure, oh my gosh. So this is a little bit of a twist on Emma's excellent question. And what I think about is, you know, as you just said, the Trump administration, you know, it's just like, you know, I mean, this is a perfect theme, advancing abolition in regressive times. So little did we know just how regressive we'd be when they picked this topic 6 months ago. But I'm wondering where you see the most, you know, where can we be most effective in these times as the national conversation is all about brutality, all about vengeance. You know, you're seeing this. And so I'm like, is the battle, you know, what's the best place? Is the battle in the courtroom, in the individual cases where it's like, okay, you might have this thing up here, but you've got this great advocacy and they're winning on the ground? Is it giving the death, is it like public information campaign and like giving the death penalty a black eye, you know, damaging the death penalty's brand? Do you see it as something else? I'm just kind of curious as like, you know, last comments of where do you see the best place for those who are really, really interested in this anti-death penalty advocacy in regressive times?
Well, I think it's in the things that I touched on. I mean, I think innocence is the Achilles heel here because, you know, increasingly this very swashbuckling view that these AGs have about we're going to kill these people whether they're innocent or not. That, you know, that's, I don't talk this way, but I know some people talk about the brand, you know, the brand of this, that, or the other, the brand of the death penalty. Not good for the death penalty to kill innocent people. You can't bring them back. And I think that, to me, it's extremely disturbing that whereas before we did have governors who would say, I think he's guilty, but I'm not so sure. I have a higher standard. But now, no. Certainly Abbott in Texas doesn't have it. You know, we don't have that. And so I think that's Of course, for a lot of advocates like myself, for lawyers, you sort of go where the cases take you. But what I think is interesting is that where the cases take us is, to some amazing things about the humanity of the people involved. I mean, I think it's very important that people hear from people who have been on death row and hear from people who are innocent, but also hear from people, who are guilty. I have clients of mine, Tony Amadeo, my client, who, was in for a long time, but then came out and did great work, and I think was real, James Woodson versus North Carolina, that very first case about the mandatory death penalty. The death penalty is going to get executed by North Carolina. He goes back, he serves, 17 years, something like that, goes out and becomes a minister. And is a minister for his whole life until he dies. Went back into the prison as a minister. Well, now wait, this is a guy we said was so beyond redemption, we were going to eliminate him from the human community. Well, now that's not the case, and Tony was the same way. I mean, I have many clients of mine who were once under death sentence who are in the free world today, not because they're innocent, but because we ultimately negotiated the case and we got parole, and here we are. And so I think that's important. That the thing that I think, I don't know if this is the answer to your question, I think what everybody ought to realize is just the criminal courts need to have more humility. It's better than fighting a duel to have a trial and decide whether somebody's guilty or not or what sentence they get. But it sure is not right every time. I mean, of course, we make lots of mistakes. I think, I tell my students, the courts are like an emergency room in a hospital. Everybody's bringing people in and everybody's running around doing things, not sure what they're doing or whatever. You got to do it, but it doesn't, you should have some humility to it. And the idea that you would put people away forever when you can't go back and fix it, that, to me, but obviously, there are a lot of people who don't feel that way. But you, again, look at what I said. The death penalty is really, it's Texas, Alabama, Florida, these southern states, and it's 2%. I think you reminded me it was 2%. Responsible. 2% of the counties in the country are responsible for, half the people that are under death sentence or have been executed. So I hope that helps. I don't know.
Thank you very much,
Right.
Professor
Sure.
Bryant.
This was supposed to be a quick wrap up. Now we have tech problems. Thank you so much, Professor Bright, and thank you, Professor Lane, for the perfect question to wrap us up today. I think that really gets to a lot of the themes we touched on. Before everyone heads out, I just want to take a few moments to wrap us up. I know it's been a long day, so I'll be quick. It takes an absolute village to pull off an event of this scale, so I really quickly want to thank all the people who made the symposium possible. First, thank you so much to our guests and our speakers who came from far and wide to share their knowledge with us. Like Caleb mentioned, each of our speakers is way too humble to tell you just how remarkable they are, so I'll do it. Each of them is doing such important work, so I appreciate them taking the time here today. Thank you especially to Lamont for sharing your story. You are such a light, and I really hope you see the beach very soon. I would also like to thank Richmond Law staff and administration for all the work they put into this event. First, Carl Ham, who makes sure all things tech-related go well, not just today, but every single day. Thank you, Carl. I would also like to thank Mary Ruth Walters and Will Thompsons in the Dean Suite. Mary Ruth especially puts so much work into these events. She is ever patient and ever kind, and none of this would be possible without her. I'm also incredibly grateful to the members of the Volume 60 of Law Review, many of whom are here with me now. All our staff members dedicate a remarkable amount of time and work into our journal, and I hope that today helped you contextualize some of that work and to see how Law Review plays into the broader legal community. Thank you to the Law Review Executive Board, Caleb, Casey, Izzy, Grace, Cece, Jeff, Olivia, and Julia. Being on Law Review is like being a part of the best group project in the world, which if you know me, I don't love group projects. But every single one of you works so hard and is so good at what you do. I love working with you all, and I cannot wait to cheer you guys on during your big Law Review weeks. Thank you to Professor Lane and Professor Collins for their steady guidance throughout the planning process, despite being the two busiest people I know. Thank you to my family and friends in attendance today, especially my parents, Charlie, Emma, Matt, Lane, Libby, and Ashlyn. Finally, thank you to all of you who attended today. I know it's been a long day, but I really appreciate you spending it with us. I invited you at the beginning to imagine what justice, rooted in mercy, hope, and community might look like. I hope if anything from today resonated with you, that you'll take it with you when you leave. Thank you so much.
You all go. I also just want to give Anna a huge shout out. She did so much of this planning and has put on an incredible symposium today. And Anna is also far too humble to ever say that about herself, so I will say it for you.